capacity?
I'm employed by NCEMC, the North Carolina Electric Cooperatives, and I am Senior Vice President of Energy Delivery.
Did you cause to be filed on May 28th, 2024 direct testimony consisting of 17 pages?
I did.
Did your testimony include any confidential information?
I did not.
Do you have any changes or corrections to your testimony at this time?
I do not.
If I asked you the same questions today from the stand, would your answers be the same?
They would.
And did you also cause to be filed a summary of your testimony in docket number E-100 sub 190A?
I did.
Presiding Commissioner, I request that the pre-filed testimony and summary of NCEMC witness Lee Ragsdale be copied into the records if given orally from the stand.
Seeing no objection, your motion is allowed, and the direct testimony and summary of the testimony of Mr. Ragsdale will be entered into the record as if given orally from the stand.
Thank you. It's my understanding that there's no time reserved by parties for cross-examination of Mr. Ragsdale on his direct testimony. However, Mr. Ragsdale was identified on the cover letter accompanying the July 29th, 2024 partial stipulation between NCEMC and CPIRP that was entered into the record yesterday. And as one of the, Mr. Ragsdale was identified as one of the witnesses that the stipulating parties would make available for cross-examination on the stipulation. As such, Mr. Ragsdale is available for cross-examination on the stipulation this morning, as well as commission questions.
Okay, thank you, Mr. Dodge. Is there any cross-examination from Duke or the public staff or any other party in regard to the stipulation?
No, there's not. Not on behalf of Duke Energy.
Mr. Creech, do you have any cross-examination?
I do not.
Okay, seeing that there is no cross-examination of Mr. Ragsdale, I will turn to the commissioners for commission questions. Chair Mitchell.
Good morning, Mr. Ragsdale.
Good morning.
A few questions for you. First, want to start with your testimony. Your testimony expresses concern regarding the pace at which Duke has to or is going to have to allocate resources to meet its obligations going forward. Is that correct?
That is correct.
Okay. And you expressed the direct concern that Duke's resources are being allocated away from transmission issues that are of concern to NCEMC. Is that right?
That is correct.
Okay. And I think your testimony I'm going off memory, but your testimony specifically mentions 7 delivery points that you're working on, that NCEMC is working on at this point with Duke or with the Duke operating companies.
That is correct.
Okay.
Subject. Yeah.
Okay. And is it your testimony? I just want to make sure I understand what you're saying here. Is service adequacy being implicated, or has it been compromised in recent years because of Duke's allocation of resources away from whatever NCEMC's requests have been?
So I'll say that we work with Duke on a regular basis for servicing the needs of our members. And there are a number of delivery points that are being pursued currently, and Duke is working with NCEMC on those delivery points and delivering them through time. NCEMC has raised the concern that we want to make sure that the pace remains manageable. You've heard other witnesses talk about the rate at which Duke can interconnect solar and other resources to the system over time, the volume of those interconnections, and the outages required to manage those interconnections. If we push the pace on those individual interconnections, that could impact the future ability to serve load and manage delivery points within the system. And so NCEMC continues to reiterate the importance of pace and making sure that we maintain not only the carbon plan, but also the other aspects of the transmission system that need to be maintained.
Okay. So it sounds like to me from your testimony today, and you correct me if I've gotten it wrong, that service adequacy hasn't been compromised yet. There's just a concern that as we look forward and to the future, when Duke is working to interconnect resources, that there could be a delay in Duke's attention to NCEMC requests.
Specifically with in regards to delivery points, we are seeing that Duke is working with us to deliver those, and the adequacy is not being compromised. There are other aspects of operations and maintenance costs. We've seen a decline in O&M costs, and we've seen impacts to projects that Duke has considered for our members that could potentially impact reliability. One example that I would give is we've made requests on multiple occasions for replacement of old oil circuit breakers that Duke owns at our member delivery points. Those we wish to replace with NCEMC-owned breakers, as is customary for new delivery points. The reason we want to replace those is because they're not connected to SCADA, they're not remotely operated. So in the event that there's an operation, it's a significant delay in dispatching staff to reconnect those delivery points. That's an example of one of the O&M aspects that we think needs to be continued to considered going forward. We've seen and we've heard anecdotally that our requests have not been at the top of the priority list. I appreciate that. We've done everything we can to help facilitate, and we only can see that it's resource constraints that are limiting Duke from being able to do that.
Okay. You mentioned O&M just a moment ago, and I've forgotten exactly what you said, but you said, did you say O&M expenses or O&M expenditure? When you mentioned O&M, what were you specifically talking about?
Specifically O&M expenses. We noticed in the filings that Duke has published that their transmission O&M expenses for DEP, for instance, were down nearly 30% in 2023. And we're feeling or observing that impact as well. I think I'd call back to the public staff's reference to O&M on generation and the potential impact of reliability it could have. We also feel like reduced O&M expenditures could have impacts on reliability in the future.
Okay, but that again, that's a concern about a potential and not necessarily something that you all have experienced to date.
Correct.
Okay, understood. Thank you. All right. Your testimony touches on the work of the CTPC, and I just want to make sure there's some discussion sort of, and I'm going to be very general in my paraphrase of your testimony, but about the transparency of the work that the CTPC is doing. You participate in the work of the CTPC, don't you?
I do not directly participate in the work of the CTPC, but my team does participate in CTPC.
Okay, so are those NCEMC employees that report to you?
That is correct.
Okay. And so can you tell me how many meetings of the CTPC have occurred since Duke has implemented its new procedures that were not that long ago approved by the FERC?
I don't have that specific number in front of me.
Chair Mitchell, if that's something you'd like us to provide, we can certainly provide a summary of the meetings that have taken place since.
Well, maybe on questions on commission's questions, you could clear that up. Okay. So when you talk about transparency, can you be specific? What do you mean? What do you want to see? What does your team want to see and hear that it's not seeing and hearing?
So with transparency, it's important to understand not only the cost and the cost benefit analysis that is associated with transmission expansion, but also how those benefits can be allocated or can be assigned. We feel that it's important to make sure that at cost allocation is commensurate with the benefits that can be accrued by the parties that are at play. So our ask, and from a transparency perspective, is to understand more than just the single black box number that's the cost benefit analysis. Duke's witness, Mr. Roberts, went to great lengths to talk about the cost benefit analysis associated with the Red Zone 2 projects and their benefits. But that's a single number. In the transmission planning doctrine, there are a number of categories that benefits can fall into. Those include reliability, but they also include production cost and energy savings. They include loss reduction. They include asset deferral. Those benefits need to be allocated across those categories so that we can discuss cost allocation. NCEMC is not wanting to. NCEMC fully intends to bear the costs that are appropriate for and commensurate with the benefits that we imbue by participating in the network. But to the extent that there's requirements for building the red zone projects to interconnect generation, those benefits are predominantly, I would imagine, I don't have the numbers in front of me because we don't have the transparency to see it. Those benefits do fall into the production cost category, which are energy and not transmission savings. So we want to be able to see and talk about the benefits across those categories. That's our request.
Okay. All right. Thank you for clearing that up for me. And I don't hear NCEMC saying it doesn't want to pay, it doesn't want to be responsible for the cost of transmission service from which it and its members benefit. Is that correct?
That is correct.
Okay. All right. And NCEMC, as well as electricities and the Duke operating companies, have a long history of working through transmission planning and coordinating transmission development together, don't they?
We do.
And do you anticipate that's going to change, that history of working together?
I do not.
Okay. And
the CTPC has continued to evolve over time for the local transmission planning, and we have enjoyed being a part of that process and look forward to continuing to work in that local planning process.
okay. All right. Well, I appreciate your testimony. That's all I have.
Thank you. Commissioner Duffley?
I do. So apologies if I tread ground. I was a few minutes late today.
Good morning.
On page 7, lines 9 through 16, can you explain this testimony a bit further?
Yes, give me a second. So this section of my testimony speaks to the process that the CTPC undertakes. We talked 2 years ago with the RZEP 1.0 projects about the process of the NCTPC at the time evaluating projects. We want to make sure that the process for the RZEP 2 projects also goes through the CTPC. It's important that when we establish a process that we follow that process. And so we want to make sure that it is not, we don't depart from that. You heard earlier this week that both Duke and the public staff indicated that if the commission makes a comment or acknowledges the need for the RZEP 2.0 projects, that has significant weight for the CTPC. We want to make sure that the process plays out as it is. Excuse me.
Okay, thank you. And then if you could turn to page 8. Did you hear my exchange with witness Roberts regarding GETS?
I recall, yes.
Okay. And what's your view on Duke's implementation of GETS at the present time and what he stated the future of GETS will be?
I thought that witness Roberts' perspectives on GETS was appropriate. I do know that Duke is considering GETS and they are looking into that. And I think it's appropriate to think about how they can have marginal benefits to the transmission system. But if I recall correctly, he also said that it's not the end-all solution. My words, not his, but I think that that's appropriate. We support Duke and how they are continuing to examine GETS and other opportunities to enhance the network grid.
Thank you. And then if you could turn to page 11. Lines 17 through 22. Can you just further explain your request of the commission?
So our request is for the commission to encourage Duke to have more transparency on the cost benefit information associated with projects so that we can have a cost allocation discussion up front when we have these projects come into the system. When projects are built, they're put into the FERC accounting and then they flow through a transmission rate to network customers such as NCEMC. It is not it is normal for there to be an opportunity to have a cost allocation discussion, again, because costs should be allocated commensurate with the benefits that are received. And so we want to make sure that we have that conversation in the front and not in the end.
Okay, and did you hear Mr. Roberts testify, and I think it's in the rebuttal testimony as well, regarding FERC Order ER-24-134? And what I thought I heard Mr. Roberts state is that FERC has decided the cost allocation methodology or the cost allocation for these multi-driver type strategic transmission plans. Do you agree with that?
My understanding is that Duke has a default, an ex-ante form of cost allocation, which is load ratio share across the network customers. FERC declined to rule on our questions of cost allocation when we brought that up, said it was not the appropriate time. And so we would continue to bring that in front of the CTPC, we'll bring it in front of this body, and we'll bring it back up in front of FERC as well. But Duke does have a default approach to cost allocation, which is load ratio share.
Okay, thank you. And then on rebuttal, I just want to give you an opportunity to respond. The companies responded to your concerns that the companies focus on interconnecting generation, that that focus may be creating risks to reliability. And specifically, the company presented a chart indicating a significant increase in the numbers and spend for reliability projects. What's your response to that?
I think with greater transparency on the costs and the benefits of projects, we can see, we can have our own view of the contributions to reliability of projects as well. Any project that's done on the system will have an impact on reliability, positive or negative. But the main drivers for those projects are not often, don't necessarily have to be reliability. The RZEP2 projects, for instance, they have a reliability benefit, but they are driven by policy for interconnecting solar and other generation. And so that is not necessarily the main driver. Reliability is not the main driver for those project investments. We acknowledge that Duke is continuing to make upgrades to the system. They are improving reliability and doing their job, but we want to again reiterate its pace, and we want to make sure that we don't have an obsession as an industry in the state to just installing new generation, but instead think about how we serve our member consumers at the end of the line.
Okay, thank you. Those are all my questions.
Commissioner McKissick.
Just one question, and that's based upon your last statement that you made. Could you articulate what the position is at this point of NCEMC when in terms of priorities that Red Zone 2 projects should receive relative to other projects that might have been assessed and are integral to reliability?
So our members have consistently told us at NCEMC that reliability, affordability, and sustainability are important, and in that order. We want to focus on reliability. We want to focus on affordability. And we place those as high priorities. We also place a priority on sustainability. So we have to balance all three of those. We don't want to forgo one for the others. It's important for us to make sure that we maintain reliability on the system and balance that with affordability and balance that with sustainability.
And it's my understanding from reviewing your testimony that essentially, the request has been made for the commission to acknowledge these Red Zone 2 projects, that you prefer that they go through the normal North Carolina Transmission Planning Collaborative, and that they make an initial determination assessment before we take any action. Is that correct?
That is correct. They are currently being considered by the CTPC, and I encourage you to consider allowing that to play out.
Thank you. I don't have any further questions.
Okay, thank you, Mr. Ragsdale. We'll now move to questions on commission questions. Mr. Drack?
Yeah, just a few. Good morning, Mr. Ragsdale. How are you?
Good morning. Thank you.
So want to address two issues that you discussed in your testimony just now. And you talked about transparency. Do you recall that testimony? And I think you're specifically referring to transparency related to the benefits of the Red Zone 2.0 projects, correct?
That is correct.
Okay. And are you aware that Duke has provided the entirety of its cost benefit analysis with respect to the Red Zone 2.0 project in this proceeding?
I'm aware of the cost benefit analysis, but not the allocation of those benefits between categories, not the categorization and the.
So you're not aware, just to confirm, the entirety of the analysis showing how the manner in which the benefits were determined, the categories of benefits were provided in discovery in this proceeding. Were you aware of that?
I'm not aware of that.
Okay. So you would not disagree that Duke has withheld, you're not asserting that Duke has withheld any information about the benefits and the analysis supporting those benefits, correct?
I have not been made aware of the benefit categorization and through the CTPC process that we've been involved in.
Okay, so the fact that Duke provided, no one's made you aware of the fact that Duke has submitted all of that information through discovery?
I'm not aware of that.
Okay. I want to turn to a second subject, and you said, to generally paraphrase, you said that Duke has a default cost allocation methodology with respect to transmission investments, correct?
That is correct.
Okay. And do you understand that when you say Duke has a default cost allocation methodology, would you agree that that cost allocation methodology is subject to the jurisdiction of FERC?
That is correct.
Okay, and would you agree that FERC has consistently found that the existing cost allocation methodology to be just and reasonable?
My understanding.
And would you agree that's the job of FERC to determine whether or not cost allocation that goes to FERC jurisdictional transmission customers, it's the job of FERC to determine whether those are just and reasonable?
It's my understanding.
Okay. We have no further questions.
Mr. Dodge, do you have any? Mr. Creech?
Couple quick questions, if I may, Mr. Ragsdale. Good
Absolutely.
morning.
Good morning.
Excuse me. You talked initially with Commissioner Chair Mitchell about your very broad overview of your testimony, and then you had questions from Commissioner Duffley relating to RZEP. In your response, part of your response, I believe it was in response to Commissioner Duffley's question, was when a process is established, you follow the process. How does that go into your discussion of transparency? I mean, specifically, if you have a process and the projects that are located in North Carolina and South Carolina, these RZEP projects, should they not go through the CTPC before they come to the North Carolina Commission for acknowledgement?
That was our testimony, yes.
Okay. And then second question is in response to Commissioner Chair Mitchell, you talked about, there was a question about the long history of working together with the company. Do you recall that?
I do.
And has part of that history working with the company been in the context of the CTPC and until recently working through these types of projects, these RZEP projects?
Yes, it is. Thank you.
Mr. Dodge?
Yes, thank you, Presiding Commissioner. Mr. Ragsdale, do you recall Chair Mitchell asking information about the number of meetings that have been held by the CTPC since? All right. And subject to check, would you agree that the OSC and the Planning Working Group both meet monthly? So since the time Duke made its filing in November, there have been 9 meetings of those two groups of the CTPC?
Subject to check, yes.
And subject to check, would you also agree that the Transmission Advisory Group has met twice in 2024 since that time? Now, again, the filing was made in November. However, would you agree that the actual effective date of the changes to attachment N1 were not until April 2024?
Correct.
Okay, thank you. No further follow-up.
Okay, I think that looks like that's the end of questions on commission questions. So Mr. Dodge, I don't believe that you have any exhibits. You have no exhibits to admit. So is there anything in addition before we excuse the witness?
No, Presiding Commissioner. Thank you.
Mr. Ragsdale, thank you for your testimony. You may step down and be excused.
Thank you.
So before we turn to Duke's rebuttal witnesses, are there any matters that we need to address? Seeing none, Duke may call its first rebuttal witness.
Thank you very much. At this time, Duke Energy calls Kendall C. Bowman and Glenn Snyder to the stand.
And Mr. Director, you have placards for the witnesses?
And for the benefit of the commission and all parties, as a reminder, at this time, Ms. Bowman and Mr. Snyder will be presenting both Ms. Bowman's rebuttal testimony as well as the joint supporting settlement testimony of Ms. Bowman and Mr. Snyder.
Okay, thank you.
Good morning.
Yeah, and good morning, Ms. Bowman and Mr. Snyder. I'll just remind you that you were sworn in earlier and remain sworn in. Okay, Mr. Jack, you may proceed.
Thank you. Ms. Bowman, did you cause to be pre-filed in this docket a rebuttal testimony consisting of 22 pages?
I did.
And do you have any changes or corrections to your rebuttal testimony at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Does your rebuttal testimony include any confidential information?
No.
And did you also prepare and cause to be pre-filed in the docket a summary of your rebuttal testimony?
I did.
And staying with you, Ms. Bowman, did you cause to be pre-filed in this docket settlement and testimony filed jointly with Mr. Snyder consisting of 9 pages?
Yes.
And do you have any changes or corrections to that joint settlement testimony at this time?
No.
If I would ask you the same questions today that appear in your pre-filed joint settlement testimony, would your answers be the same?
Yes.
Does your joint settlement testimony include any confidential information?
No, it does not.
Did you also prepare and cause to be pre-filed in this docket a summary of your joint settlement testimony?
Yes.
Presiding Commissioner Kemmerite, I would ask that Ms. Bowman's rebuttal testimony and rebuttal testimony summary be entered in the record as if given orally from the stand. And I would also ask that the joint settlement testimony of Ms. Bowman and Mr. Snyder, as well as their summary, be entered in the record as if given orally from the stand.
Okay. Seeing no objection, your motion is allowed, and Ms. Bowman's rebuttal testimony and the summary of her testimony shall be entered into the record as if given orally from the stand, along with the joint settlement testimony of Ms. Bowman and Mr. Snyder and the summary of their testimony.
Thank you very much. The witnesses are available for cross-examination and commissioner questions.
And the order of witnesses, I believe, is Attorney General's office first.
Yes, thank you. Good morning. Terrell Moore with the Attorney General's office.
Good morning.
Morning.
I just want to discuss briefly the near-term actions outlined in the amended stipulation. And I believe they start on page 6 if you want to review those. These procurement numbers were informed by but are not the output of a capacity expansion model, correct?
That's a fair characterization.
And so these numbers have not gone through the reliability verification step in CERVM, correct?
I wouldn't say that directly. I mean, all of our modeling runs did go through that, and these resources do not subtract from the resources that are already in the model. And so we're not saying this is just a subset of the near-term actions. The reliability verification step is done at 2033 and 2038. And the resources that are in those reliability verification steps are consistent with this level of resources. So I would say, well, not exactly megawatt for megawatt. There is nothing in here that subtracts from the resources that we're able to provide a reliable system through that 2033, 2038 verification step.
These near-term actions, is it fair to say there's less onshore wind than in the public staff's preferred portfolio? Is that right?
In the near term, but there's also, it's much or more than what's in many of the companies. And the reliability verification was run on the companies as well, and it was deemed to be reliable.
And there's less CCs than in the company's portfolios, isn't that right?
There are less, when you say less CCs, there's less that we are requesting relief for the commission to select in this docket here, but the remaining CCs are still in the modeling results. And in fact, in the stipulation, we say we will come back to this commission for those further CCs in our upcoming comprehensive IRP, which is about a year from now, we'll be filing that. So it is less being requested of the commission, but not less in the plan.
Has a bill impact analysis been done of this mix of resources?
Again, the bill impact is similar to what I just said about the reliability, which is it's at a couple snapshots in time. It is not on a subset of resources, which the NTAP can be considered as subset of resources in the total plan. And so the bill impacts are for all resources in the plan and not just the ones that are in the near term. These are consistent in the stipulation, the settlement with public staff and other parties. These resources are consistent with the level of resources that were in the bill impact analysis that we provided in SPA fall base, our preferred portfolio.
No further questions.
And before we move to Avangrid, Mr. Durack, I want to make sure that the record is correct. I believe that you stated that Ms. Bowman's rebuttal testimony was 22 pages. That was my understanding of what you said. I have checked the rebuttal testimony. I believe it's 20 pages. So if you can check the pages, and if I am correct that it's 20 pages rather than 22 pages, you could make a revised motion so that the record is clear.
Thank you for that clarification.
Okay, so we will move to Avangrid.
And actually, Avangrid, having heard just was testified, is going to waive its 5 minutes.
Okay, and Ms. Kress with SIGFER.
Thank you. Good morning, Ms. Bowman. You testify on page 1 of your rebuttal testimony at lines 16 through 22. That the company's CPIRP and the modifications made in its supplemental planning analysis, quote, represent reasonable steps that maintain or improve reliability while balancing affordability and ensuring the ability to meet continued load growth of the Carolinas. Is that correct?
That is correct.
Is it your testimony that a monthly bill increase of approximately $1.5 million a month for a typical 50 megawatt industrial customer is affordable?
I'm not sure where you're getting those figures from, but as we're balancing multiple different perspectives in this proceeding, there's not one size fits all approach. We hear perspectives from a range of customers wanting to go faster, wanting to be focused on price. We believe overall that the portfolio and the near-term actions we're putting in front of this commission are reasonable and balancing the affordability, reliability, and the path towards getting to clean energy. So we believe that this plan that we're putting in front of the commission is reasonable and affordable for all customers.
So if you could turn with me, please, to SIG for potential cross exhibit number 85, which should be in one of the binders in front of you. And Presiding Commissioner Kimwright, this is already in the record because it was an exhibit to pre-filed direct testimony sponsored by SIGFR. And so I've just included it in the binder for the witness's benefit.
And Ms. Kress, for the purposes of the transcript, could you identify the exhibit as it was introduced?
Absolutely. It was SIGFR Witness Collins Exhibit BCC2. And again, this was potential cross exhibit number 85.
Thank you.
Ms. Bowman, are you familiar with the testimony sponsored by SIGFR Witness Brian Collins in this case?
Generally.
And this exhibit is already entered into the record, but would you agree with me that it is pre-marked and identified as Exhibit BCC2, showing DEP and DEC's monthly bill impacts for a typical 50 megawatt industrial customer?
Yes, it's for a LGS time of use customer.
On top, and then on the bottom is actually for Duke Energy Carolina's OPTV.
Yes, time of use.
And do you see the column on the left that says January 2024 cost for DEP is approximately $2.49 million a month?
Yes.
And then all the way to the right, the 2038 bill increase versus 2024 is just short of $1.5 million a month.
Yes, I do not know. I mean, I can't verify these numbers, but yes.
And then turning to the DEC OPTV rates, same thing, 2.186 million for January 2024 costs. Is that what it appears to show here?
Yes.
And then 2038 bill increase over 2024 numbers is just short of $1.5 million a month.
Are you looking at for 2038? Yes.
Thank you. No further questions.
Thank you, Ms. Kress. Mr. Smith with EDF.
Good morning. Ben Smith from Environmental Defense Fund. I just have a few questions. Excuse me. I want to go to paragraph 11 of the amended settlement. And just reading the record, the stipulating parties agree that the company's 2023-2024 CPIRP modeling, including the supplemental planning analysis and CAA section 111 sensitivity analysis, is reasonable for planning purposes and presents a reasonable plan for maintaining reliability in a least cost manner and achieving the state's CO2 emissions reductions targets in a manner consistent with the requirements of NCGS section 62-110.9 and prudent utility planning. Did I read that right?
Yes.
Do you recall, and you both were around during the sub 179 initial carbon plan proceeding, isn't that right?
Yes.
Yes.
And do you recall that during the sub 179 proceeding, the companies filed an appendix with their application that was a carbon accounting appendix?
Yes.
In this proceeding, there was no carbon accounting appendix that was filed with the application, isn't that right?
Yeah, the baseline was really the main point of that because it was our first carbon plan. And so establishing that 2005 baseline back in 179, the math behind that was agreed upon and confirmed in that proceeding. And so there's the 2005 baseline, now is not changing. And so there was no need to refile that baseline. And I would say that's the difference.
Thank you. And do you think it would be appropriate for the companies to consider filing updated emission reductions numbers in future carbon plans so that we could validate the progress made on emissions reductions?
Are you saying file what actual emission reductions are over time?
I suppose what I'm saying is filing whatever mathematical modeling or otherwise studies that are done as you all continue to decarbonize your asset portfolio so that the commission can see the progress.
Yeah, I think, what we attempt to do is show all of the trajectories. We have a lot of testimony. It's certainly in our plan what those carbon trajectories are under the different pathways. So I'm agreeing with you that yes, we need to show for each portfolio that we present to this commission what the attendant carbon emissions are for that portfolio. So I agree with you.
Thank you. No further questions.
So I think that's the end of Walmart. My apologies. I had heard that you had added some cross time.
No, I think it should be my apology because I think I was a little late in realizing I should probably ask those questions of this panel. So I apologize and appreciate you. Hopefully you see that I've reduced 5 minutes for the next panel to address this. I want to discuss sort of two items at the same time. Page 5 of the settlement testimony, you discuss some of the agreements in the stipulation with respect to CCs and CTs and the agreement to sort of pause seeking a CPCN for certain combined cycles until after the next CPIRP. Do you see that?
Before we go further, do you have your placard for the court reporter? Okay, thank you.
It's on page 5 lines. It's approximately 1 to 11.
Are you referring to our testimony or the
You're
actual?
correct, your
stipulation?
testimony,
Okay.
your joint testimony.
I see that.
And so hypothetically, after the CPIRP that's going to get filed in 2025 and the receipt of a commission order, it would be the company's intent to then come forward and potentially seek CPCNs for CCs 4 and CCs 5.
Yes, I think the agreement with public staff is to ensure that the conditions at that time, with the new IRP filing a year from now, subject to the fact that if it is to still support, given load growth and other changing market conditions over the next year, it's still needed as shown at that point in time, that we would wait until then until filing a CPCN for CCs 4 and CCs 5.
Okay, so then I'd like to draw your attention to paragraph 12 of the amended stipulation. And I note there that there's a sentence that says the stipulating parties further agree that an updated resource adequacy study will be conducted prior to 2027 to reflect updates to the company's generation portfolios, load forecasts, and expansion plans. Did I read that correctly?
You did.
And so can you tell me what prior to 2027 means?
That means it takes time to produce these analysis. It's a lengthy process. It's a big undertaking. And so prior to us filing our 2027 IRP, we will, well in advance of that, engage in a new resource adequacy study. Again, we've heard a lot of testimony over the last week on changing market conditions, neighbor systems, coal retirements, et cetera, that are going to potentially impact that analysis. So we will endeavor to update that analysis prior to the 2027 IRP and file it at that point in time.
So does that mean that the commission you do not anticipate that the commission will have the benefit of an updated study for purposes of next year's CPIRP filing?
It won't have a formal new resource adequacy study. Again, a large undertaking, and we do it every few years. But we will continue to do, when we do the validation step, within the IRP modeling. It is what I would call an abbreviated resource adequacy. It's a check of each portfolio to say at various points in time, do these portfolios, even given the 22% that goes into the beginning input, when you develop a portfolio, is it still adequate with that resource mix? And that final check that we introduced in the last IRP, we continued in this IRP, we will continue that into the next IRP. So you will get a reliability verification step that looks at the robustness of each portfolio that we file in this upcoming IRP.
And will that robustness be as compared to whatever reserve margin the commission adopts in this proceeding?
No, actually, when you do a verification step, that's the whole point. It's moving away from reserve margin, but it's staying to the 1 in 10 year event. And it's saying with this resource mix, with this new mix of batteries and wind and solar and gas plants, does that portfolio maintain a 1 in 10 reliability standard that's an industry standard? And so we will look at each portfolio that we're presenting to this commission, and we will do the reliability verification to ensure that we are still meeting that 1 in 10.
And so you believe that as a potential outcome of the 2025 CPIRP, the commission would have sufficient information in front of it to determine whether the reserve margin is appropriate as an outcome of that proceeding?
I believe the commission will have enough information in front of it to know whether or not each portfolio is reliable and adequate and meets the reliability standards set forth in House Bill 951.
I don't know that I feel like that's precisely an answer to my question. I guess what I'm trying to figure out is if the commission were to come in and your portfolio were to show something that reflects that it's suddenly well above the 1 in 10 LOLE standard, would that be a sufficient basis for the commission to adjust the reserve margin in the 2025 proceeding? Okay. So whatever reserve margin is set in this proceeding will carry through to the 2025 CPIRP, and the earliest it could be adjusted is 2027. Is that fair?
Again, yes, that will be the initial input that will go into next year's IRP, will be the 22%.
Thank you. Those are all the questions that I have.
Okay, thank you. I have a couple of questions. I think my first question will be directed to you, Ms. Bowman, and it relates to the stipulation, amended stipulation in regarding to the interim target.
Okay.
And specifically paragraph 14 and the sentence at the last sentence of the paragraph that states, the stipulating parties agree that it is no longer reasonable or executable to require future resource plan updates to consider pathways to achieve the interim target by 2030. And so my question is, and I'll give a little bit of background, we're still a number of years away from 2030. We've received quite a bit of testimony yesterday from some of the interveners about their opinion that load growth is uncertain about the extent of it. It could be greater or it could be less. And then we also have Commission Rule R860A that states that each CPIRP filed prior to 2030 shall include at least one resource portfolio that achieves a 70% reduction in carbon dioxide emissions by 2030. So can you explain why it's necessary to include that statement in the stipulation?
I believe the parties have come to consensus that we believe it's unachievable to get to the 2030 date because circumstances have changed. It's not practicable, it's not executable. And so what we're asking the commission in this proceeding to do is not pick a particular portfolio, but to pick the near-term actions, those actions that we need to implement now to continue on our path for the clean energy transition. It's not just load growth that we're planning for. It is the retirement of the coal generation to help us meet those carbon reduction goals. And so we need decisive action now. And as we're thinking about the next iteration of the carbon plan, if we're seeing it's unexecutable and not reliable today, then we believe that there's not a need to go forward and conduct another one. And I'll look to Mr. Snyder to see if he has anything to add.
Yes, thanks. Yes, presiding Commissioner Kemmerate, I would just also point out that even our original filing, before the supplemental filing, we found it impractical and unexecutable to meet a 2030 target at this point in time, even when we had a lower load forecast. The supplemental just emphasized that point even further and made the unattainability just that much greater. So it's not at this point, even if load comes back a little bit, which is not what we're seeing at the moment, but it is, I will agree, it's forecasts can change. We don't see it at both the passage of time as well as the amount of load that we're seeing just here in the near term makes it untenable. And so it really becomes, is it a beneficial exercise? There's, a whole lot of analysis being done. And is it the best use of limited portfolios and sensitivities and before this commission that this commission would find useful to continue to put forth portfolios that are unexecutable?
Okay, thank you. And then I have a question about paragraph 21 in the stipulation and amended stipulation. And this potentially could be a question that would be better asked to witness Roberts. But this is about the future procurement from existing qualifying facilities. And this is going to be my word rather than what I've read, but it seems that this is low-hanging fruit to try to keep solar facilities that are already operating on the system so that new replacement generation is not needed. Do you know whether these legacy PPAs, have any of them expired? Are they rolling off yet? Or have you already seen that happening? Or is that going to be happening within the next year or two?
It's largely a forward-looking, if you think about how solar came onto the system in the Carolinas, it was under PIRPA, largely 15-year, but we do have some 10-year PPA contracts. Most of those, didn't start until the late teens, 2017, 18, 19. So we do have some, a tranche expiring at the end of the 2020s. And in the stipulation, we agree that we should look for a way to competitively procure those with sort of a 5-year look forward. Mm-hmm. And we think that anybody expiring, let's say in the next 5 years, let's figure out how to get them on. And then in a future procurement, the new ones that could be expiring. So it's largely a forward-looking issue, presiding commissioner.
Okay, thank you. So none of the PPAs have expired and the solar facilities have stopped operation at this point. Is that right?
None to my knowledge. Subject to check, there may be, a half a megawatt one there that either, may have I don't think they expired, but, it may not have continued operating. I'm just not sure on that. I do know I have looked at when do the majority of these expire, and it is a forward-looking expiry.
Okay, thank you. And my last question is your testimony, and I think this is Ms. Bowman's testimony. Your testimony discusses new programs or tariffs that might evolve out of the MOU with Amazon, Google, Microsoft, and Nucor.
Yes.
When does Duke anticipate that any new programs or tariffs would be filed with the commission?
We are hoping to file some by the end of this year. They are currently under development, so that is our goal.
Okay, thank you. That's all the questions I have. Let me check with the other commissioners. Chair Mitchell.
Good morning. Mr. Snyder, I have a few for you related to the modeling, but I'm going to hold those until you're back up. But for purposes of, well, Ms. Bowman, let me start with this one. When you were up on your direct, you discussed with certain counsel the issue of affordability. Do you remember that?
Yes.
Do you remember that testimony in exchange?
I do.
Okay. And in response to a question from one of the attorneys, you made the point that DEC's and DEP's rates have consistently been at or below the national average. Do you remember that testimony?
Yes.
And over the course of the past couple of days that we've been in this hearing, we've heard a lot of testimony from all different types of customers and interested parties who are interested in the electric system regarding the affordability of service going forward. Have you heard that testimony too?
Yes, I did.
Okay. So looking ahead as the company manages bringing off more, almost nine gigawatts of coal in the coming decade, as well as meeting your service obligations to the load that materializes, both the residential growth that you all are experiencing, as well as the industrial customer, non-residential growth that is going to materialize. What are you all going to do to ensure that your rates remain at or below that national average, or as close to that national average as they can remain?
So, several things that we're focusing on. One, we're trying to take advantage of federal tax incentives from the Inflation Reduction Act. We're also applying for IIJA, the Investment Jobs Act, trying to get dollars there. We're also thinking creatively. I think we just referenced the MOU in partnering with those large high-use load customers that want to locate to our area, partnering with them to help with financing arrangements to try to help some of those offset those costs. I think we heard some testimony to that effect yesterday. So we're trying to partner with them. So if they're asking for a gigawatt of power, ensuring that the rest of our residential customer or commercial or industrial customer base is not adversely impacted by that. And we also continue to focus on our costs, our O&M, continuing to be efficient as a company and continuing to focus on the world around us, paying attention. I think one of the things, when we're comparing national average is what are our neighbors doing as well. And it is our focus and goal to try to maintain competitive rates so that North Carolina stays, a great place to do business, a great place for people to want to live and work.
Okay. The companies are not unfamiliar with managing cost and expense. Is that a fair statement?
Yes.
And that's something that these companies have to do today. It's something that these companies have always had to do as they've made investments and managed economic conditions and revenue pressures and needs to invest, et cetera. Is that correct?
That's correct. We always have to have flexibility. I mean, you have to pay attention. Labor markets, inflations rise and fall, and you've got to pay attention.
And so there was a period of time in the 70s and the 80s when predecessors to DEC and DEP were engaged in a build cycle. Is that a fair statement?
Yes.
Building this fleet of nuclear units that you all now own and operate. Is that correct?
That's correct.
And during that period of time, is it a fair statement that the companies had to work to manage costs to customers, costs that well, let me say it this way, the rates that their customers were asked to pay to cover the costs the companies were incurring?
Yes, there were challenging times.
They understood, but the company managed through that challenging time. The companies at that time managed through that challenging time. Is that correct?
Yes, they did. And I believe those hard decisions that the companies made back in that era have served us very well and are one of the reasons that we have maintained and been below the national average. That strong nuclear fleet that we have and that we're seeking to relicense to continue to operate, I think will continue to benefit the customers here in the Carolinas.
Okay. And I guess, my question for you really is, this isn't investing in new generating facilities, large new generating facilities, managing those impacts to your customers. This isn't a new challenge for the companies. This is something that the companies have been through before. Is that correct?
That is correct. And even today, we manage big projects. If you think about a nuclear refueling outage, that is a massive undertaking, a massive operational execution project. And so I think we are well positioned to be able to manage the execution going forward.
And also during that time and in the past and not so distant past as well, the companies had to manage unforeseen or unexpected challenges. Is that a fair statement, such as storms or fuel price volatility or other other things that have come up that have required the company to spend on behalf of its customers. Is that right?
Absolutely.
Okay. And is it, the company has managed its financial health so that it can access funds and at reasonable rates through those periods of time? Is that correct?
That is correct.
Okay, so can you talk some just generally about the challenges that lie ahead for the company and as you all look to taking this coal off and managing the expectations of this commission and your customers that rates remain affordable for all of your customers, as well as, you know, being able to serve the load that's going to materialize? How do you navigate these circumstances and ensure that you all remain healthy and that all of your other obligations that I've just mentioned are met?
So I think you're hitting on one of the challenges that the company is currently focused on. If you look at this execution plan going forward, it is a tremendous amount of capital. The utility industry is definitely capital intensive, but this is something that we haven't seen in decades, as we just mentioned, the early 80s. We're going to need to continue to have a constructive regulatory environment to ensure the financial health of the company. We need to be able to access capital. We need to be able to go out in the markets and borrow, and we need to have a financially healthy utility in order to get good interest rates to pass those savings on to our customers. So we're going to need to pay attention to the regulatory structure. We're going to all need to work together, I think, to come up with some constructive ways to handle this. I think we're also going to think through joint ownership potential. I know we're working with the co-ops on joint ownership for the CC at Person County, so we can think through those types of arrangements to help with the cost, the capital for the company as well. There are other financial arrangements out there that we will be looking at, but we will be staying on top of this. I'm not going to say it's going to be easy, but I think we can, you know, work together and manage through.
Okay. And we've heard from you all pretty consistently throughout this proceeding about this sort of the need to check and adjust and the ability to check and adjust. Talk some about how that is going to be, how that sort of factors into the company's thinking at this point and long-term thinking as well. And you know, how you see that as benefiting customers. Does my question make sense?
I think it does.
Okay.
And, you know, I think that's one of the great things about 951, the legislation. It wasn't just pick this path, stick to it no matter what. It is, you know, as we've been talking about planning, it's an evolving, it's kind of a living document. Factors change, assumptions change. And so the ability to come in and check and adjust is really going to be beneficial. As we've heard about, economic load forecasts can change. They can change overnight. And so we have the benefit of coming in every 2 years and checking and adjusting, looking at our plan and being able to tweak it one way or the other so that we can meet all of these metrics of affordability, reliability, and getting to our carbon reduction goals. So I think it's going to be beneficial for us to be able to come in and update all of the numbers and the assumptions every 2 years to ensure that we are on the right path for North Carolina.
Okay. Thank you for that testimony. Mr. Snyder, one thing I want to discuss with you, when Mr. Metz was on the stand, I'm not sure if you were in the room, but he discussed the natural progression of the coal facilities. And I know you're the modeling guy, you're not the operations guy, but just talk some about sort of where we are with the coal facilities. There's emphasis on 951 and the carbon reduction obligations the company has under 951, but sort of irrespective of those obligations under 951, what's the situation? Just help me understand the status of the coal-fired fleet.
Yeah, no, that's a very good question, and I'm sure we'll have some more discussion later in the day or throughout next week as well on, you know, as we go through the Clean Air Act, Section 111 rules, for example, right? We have a coal fleet that has, as you said, nearly, you know, over 8,000 megawatts that we need to retire over the next decade. Those plants, I think one of the commissioners in some questioning reference, they are 50, 60 years old. By the mid 30s are going to be 70 plus years old, right? And it's in the face of a devolving industry, right? You have coal mines, our fuels panel will probably tell you a little bit about, challenges in the coal commodity and transportation. You have, sort of an aging and declining workforce. Not a lot of people coming out of college wanting to be a boiler engineer these days. So, this industry, we need to thoughtfully plan. We can't let this sneak up on us. So we need to have a plan to exit this in an orderly fashion. We believe that we're well positioned, given the diversity of our coal fleet. We'll talk more about it in the modeling panel. I think you gave me a little forewarning. We're going to talk about 111 in more detail in the next panel. But we have some of our fleet that's co-fired, and we have some that's not. We have some supercritical units and some subcritical units. And so our plan is to exit those units in an orderly manner, leaving some flexibility because we're going to maintain reliability. If I have to push one out or pull one in 6 months, we will do that. But we're going to plan to exit that in an orderly fashion that's consistent with EPA 111 rules. It's also consistent with our, just outside of EPA 111, these aging facilities and the reliance on coal that we now have that we need to reduce over time. And so these are staggered. We stagger these over the next decade, getting out of these units, and we make sure that we have reliable replacement generation in place prior to the closing of any coal unit so that we don't hamper reliability for the grid.
All right. Thank you, Mr. Snyder. All right. I have nothing further. Thank you all.
Just one follow-up question, Mr. Snyder. You talked about orderly retirement of coal, and you stated this, but I'd like for either you or Ms. Bowman to talk a little bit more directly about it, because there had been some testimony about concern about reliability related to the executability of certain generation resources. And can you just talk at a high level about Duke's plan about the idea of replace before retire to ensure reliability of the system? There's been some real concern addressed by some of the interveners.
Yes, if you look at any of our portfolios, and I just had a conversation with Ms. Grumman about the 22% reserve margin, right? We are going to, when you retire a coal unit, on the system as a whole, say 350 megawatts is 1% reserve margin. So if I retire 1,000 megawatts of coal, I'm essentially losing 3% of my reserves. And we are going to make sure that those are replaced and in service prior to retiring that coal, such that that's on a long range planning perspective, such that our orderly exit of coal has new resources that have the reliability characteristics needed to keep our system at that reserve level or better. And 951, puts forth maintain or improve system reliability from the passage of the act. And so that is all of our plans are designed in that manner, such that when the model is solving for coal retirements, it's simultaneously maintaining reliability. And then when you move to execution, you will adjust. If I can get a combined cycle on 3 months early, maybe I can move that coal retirement up 3 months. If I ran into some weather delays or other delays that were unforeseen, maybe I have to wait 3 months to retire that coal unit. But we will, both in planning space and in execution space, ensure that we have a reliable system for the Carolinas that we serve.
Thank you. Commissioner Duffley.
Just to follow up on that last answer. So what I'm hearing you saying is that the reserve margin, it's going to be a little lumpy, but you'll have the minimum of 22%. And
we're, subject to, we are growing into that 22% by 2031. And, we are endeavoring to do so But yes, we are going to ensure that this coal is being replaced in a manner that we don't drop below the reserve targets that we're shooting for.
Okay, that's the end of commission questions. So questions on commission questions. And are you able to bring your placard up for the court reporter? Thank you.
Good morning, Justin Smolovsky on behalf of the North Carolina Sustainable Energy Association. Mr. Snyder, you recall Commissioner Kemroy asking about paragraph 21, which relates to the treatment of existing QFs in the amended settlement agreement.
I do remember.
And those projects, for purposes of the 45-55 ownership split in HB 951, as they're all existing projects, are they going to be considered new facilities or existing facilities under this arrangement?
I don't know that that's fully been determined. I mean, if you think about these are legacy PERPA QFs that were not selected, and they're non-dispatchable. We don't have the environmental attributes for these. We don't have economic curtailment rights on these. These are must-take legacy PERPA contracts. If we move to a competitive process that shifts these from PERPA, just normal QFs, to a facility that looks more like a 951 selected, so conveying environmental attributes, giving us economic curtailment rights, things of that nature, and they are selected as part of this procurement process, I think there is a possibility that that would be considered in that balancing of the 55-45. I don't know that, again, I'm not a lawyer, and I'm not saying that's the definitive, but that's my perspective on it, is we are moving these from one category. And again, not all all of these may not choose to participate in any future procurement. They are still QFs, and they have the right to QF rates, and they may decide that I'll just take my 5 or 10 year, depending on the size of that facility. When their existing QF contract expires, they may become a QF, and those certainly would not be part of the 45-55 if they maintained their QF status as a normal PERPA. But if they went through a competitive procurement and became more of a selected resource, I think it's fair to assume that potentially they would be part of that.
Okay. Thank you for that clarification. And one other question, Mr. Snyder. These QFs at the end of their contracts are being modeled and assumed that they'll be replaced in kind.
Yes.
Does this potential process delay the need to revisit and consider whether that's still a reasonable planning assumption?
No, I don't think we need to reconsider whether that's a reasonable planning assumption. I think it's still a reasonable plan. It's the manner in which they're going to be replaced. Is it through competitive procurement? Is it through renewal? And will we potentially see some either retire or sell off system? I guess that's a remote possibility, but we're replacing kind is a reasonable planning assumption.
So one follow-up then. So the assumption, though, is that 1-for-1 at the end of their contract, that same megawattage of solar that was on the system will still be in the system in terms of the modeling.
Yes.
Okay, thank you. No further questions.
Mr. Creech.
One quick question, if I may. Good morning.
Good morning, Mr. Creech.
Schneider. This, in response to the question from Chair Mitchell on affordability, the response discussed federal tax incentives, IIJA, the MOU with large customers with rates coming out later this year, proposed rates, relicensing of nuclear facilities, and of course the settlement speaks to EIR, the EIR program. You also had discussion on coal retirement. One question I have is, what role does the company envision for securitization in helping with affordability?
So Great question. We are definitely pursuing the securitization requirements for retiring of the coal facility set forth in 951. And that is a tool that potentially we could look at for future ways to help customers save money.
And before we move on to more commission questions, we are going to go ahead and take a 10-minute break. So we'll be back on the record at 10:03, please. Let's go back on the record and we will pick up where we left off with questions on commission questions. Mr. Tratham.
Thank you. Good morning, Marcus Tratham for CUCA. Ms. Bowman, if I could, I want to follow up on some the discussion of affordability that you had with Chair Mitchell. And recall that you and I had an exchange about this previously on direct, asked you some questions about affordability. And I think that we had agreed that affordability was an important aspect of the carbon plan and that Duke had not offered a specific definition of the term. Is that fair?
That's fair.
And would you agree that rate impacts that would impact affordability include not only this plan, but other costs which impact rates?
Could you repeat the question?
Yes. So in other words, ultimately what goes into the rates that Duke charges, it's not only the carbon plan, but there are other costs which are being incurred which impact rates, correct?
Yes, the carbon plan talks about the costs for the resource plan, but there are other costs that go into the overall rate that customers pay.
And I believe that rates since the initial carbon plan in 2022 for DEC customers have increased about 35%. Does that sound about right?
So when you're saying rates, what precisely are you referring to? Because rates are made up of multiple things. You have your base rate and then you have fuel rates, and the fuel rates change every year. And then we also have our riders, and those components change every year.
Is certainly very, very fair. I'm speaking in reference to average residential rates.
I don't know precisely off the top of my head. Witness Bateman might be a better witness to ask those precise questions too.
If you could just turn to potential cross-examination Exhibit 6, that's in the binder to your right. Yes. Presiding Commissioner, I don't intend to mark this as an exhibit. Happy to if you'd like, but just would offer this for her to look at. CUCA potential cross-examination Exhibit 6. And you see here.
Presiding Commissioner, if I may.
Mr. Drack.
I believe some guidance has been given that new exhibits or even introducing exhibits on questions on commissioner questions should be limited in scope. Certainly there was a discussion about reliability, but we've heard no explanation for why a general question on reliability leads to the need to introduce a specific exhibit that could have been used in the initial cross-examinations.
Mr. Tratham, can you respond? Because I did give direction yesterday that we were going to be very strictly limiting exhibits on commission questions. And I recognize that you are not asking that this exhibit be admitted, but nonetheless, we're still talking about an exhibit on questions on commission questions.
Yes, as I said, I'm not intending to admit it. I was simply intending to refresh your recollection.
Okay, let's move quickly. If you can refresh your recollection, and then let's move quickly because I very much do not want to be talking about exhibits on commission questions.
Thank you. Ms. Bowman, do you see in the column I've just recaptured the rates from Ms. Bateman's testimony, and I'm simply done the math. The numbers will speak for themselves, but does that look about right?
Yes, it does. And Ms. Bateman can speak to this, but I believe these include fuel increases. And this year, fuel rates are likely to go down. They're still pending in front of this commission, but hopefully by next year, a percentage should drop drastically for residential customers from fuel going down. So those rates, as I mentioned before, fluctuate year to year.
Okay, thank you. Just a couple more here, still focusing on affordability. And would you acknowledge that many manufacturing customers operate in a global environment? They don't have the ability to pass on rate increases to their customers?
I will admit that they operate in the global, but in terms of whether they pass on rate increases to their customers, I do not know.
And were you here for my discussion with Ms. Bateman previously?
I was not here.
Okay. I asked her some questions about whether Duke had performed any analysis of the rates impacts on industrial customers. I understood her to acknowledge that Duke had not done that. Is that your understanding as well?
I think you need to ask Ms. Bateman. I do believe we did some industrial analysis and a data request.
Okay, that examination will speak for itself. That's all I have. Thank you.
Any additional questions on commission questions? Mr. Durack?
Yes, just a few. And just to confirm, there are no other parties with questions on commissioner questions? Okay. Just three quick topics. Mr. Snyder, begin with the questions you were asked with respect to the QF provisions in the stipulation, and then you were asked questions by counsel for NCSCA. Do you recall those questions?
I do.
And Mr. Snyder, while you may have stayed at a Holiday Inn last night, you are not an attorney, correct?
No, I'm not.
Okay.
I'm jealous though.
And I assume you would consult with your attorneys as we evaluate how that particular provision will be implemented and assess how it should be treated under applicable law.
Yeah, absolutely.
And the stipulating parties were not attempting to resolve that issue or address it at all in the stipulation, correct?
No, they are not.
And the companies believe they'll come to a reasonable outcome that's consistent with law on that issue, correct?
Yes.
Okay. Now, the two of you were asked some questions by Chair Mitchell about the history of the commission and the history of the company, and specifically some questions about the historic, hard, complex, but important decisions made by this commission through prior execution periods that had long-term multi-generational benefits for customers. Do you remember those questions?
Yes.
Can you draw some parallels for this commission around how the hard, complex, but important decisions in this proceeding are similar to the ones that were made in that historic period by this commission and by the companies?
Sure. I will start, we referenced the early 80s, late 70s when both companies were building new nuclear facilities, and it was a challenging time. It was a huge capital undertaking, rate increases for customers. And this commission, worked with utilities in a constructive regulatory environment and have kept this state below the national average from those hard decisions. And I think we're entering a period now. We're seeing lots of new generation that we're going to have to put on the system. And it is complex. This proceeding is complex. I would dare say it's a little bit more complex than it was in the 70s and 80s. Lots of different types of generating resources, lots of grid edge. It's a very complex docket. But I believe we have confidence in this commission and all of our stakeholders and working together to come out with resolutions that will continue the path for North Carolina customers on this clean energy transition that abide within the guardrails of preserving and improving reliability, but also that question that we love to talk about, affordability. So Glenn, I don't know if there's any other parallels you want to draw.
Yeah, I was just reflecting on that a little over the break, that question. And, if you think about, we've been through clean smokestacks, right? And I sort of started in this role way back at the beginning of clean smokestacks, right? And so we're not at the beginning of an orderly exit out of coal. I've made the point many times before this commission that it was only 2005 when we were 50% coal, 50% nuclear. And look how far we have come since clean smokestacks, where, less than 2 decades ago, 1 in every 2 electrons were produced by coal and the other was nuclear. And so the diversification that we've achieved, we've retired dozens of coal units, replaced it with a diverse resource mix, and we're just accelerating something that we've been undergoing for the last decade and a half. So to Ms. Bowman's point, I think, the pace, scope, and scale of that is going to be really important as we balance those factors. There was a lot of discussion over this last week. I was listening in either in this room or on the feed of that pace, scope, and scale, and how that trade-off with cost occurs. And so as we've looked at these various portfolios, we see that as well. And so that will be the check and adjust lever that we'll have just a year from now. Dare I say, we'll be filing this again. Don't know if I have any hair left at that point. I'm losing it quickly. But it is, we certainly are in the midst of a big energy transition, but we've worked well with this commission over the last decade and a half as we've been going down this path.
Thank you, Mr. Snyder. And just one last question here. So you talked about pace of execution, and there was earlier questions from the commission touching on bill impacts, touching on reliability. Again, can you state just generally how does pace of execution in this case impact how does it impact bills, and how does it impact reliability, and where does the company feel like its recommended pace of execution as reflected in the stipulation falls within the continuum of recommendations made by other parties in this case?
I think, as I said earlier, this commission hears a broad range of perspectives from interveners in this proceeding, but also from customers that have submitted in this docket. We hear the same broad range. We hear some that say you need to move faster, faster, faster. We hear some that say you need to move really slow. You don't need to really do anything different. We believe we're trying to balance all of those, and there's not a precise mathematical formula to get that right balance. But what we believe we've done in the stipulation and settlement with the parties is we believe we're on the most reasonable path. We believe these near-term actions that we have in front of you right now is the most reasonable path that strikes that right balance between the competing priorities of everybody, that really ensures that affordable and reliable path and pace of getting to our clean energy goals.
Thank you. No further questions.
Mr. Drack, I believe that there's no exhibits to enter, but have you had an opportunity to determine if an amended motion needs to be made?
I have, and I appreciate the attention to detail of the commission and the staff. You were 100% correct. It's 20 pages of pre-filed testimony, so thank you for confirming that. So we would move that Ms. Bowman's rebuttal testimony consisting of 20 pages be entered in the record.
Okay, thank you, and your motion is allowed.
Thank
you. Ms. Bowman, I believe that you are done testifying. Is that correct?
That is correct.
Okay, so you may step down and be excused. Mr. Snyder, you're not done, so you may step down. And Mr. Drack, or Duke may call their next panel of witnesses.
Thank you. The company calls the IRP and near-term actions panel back to the stand, which consists of Mr. Snyder and Mr. Thomas Beatty. Commissioner Kimmerer, they continue to be under oath, so I can proceed with introducing their testimony at this time, if that's appropriate.
Yep, you may proceed.
Mrs. Feinberg.
Very good. Good morning, gentlemen.
Morning.
All right. Mr. Snyder, did the panel cause to be pre-filed in this docket on July 1, 2024 rebuttal testimony consisting of 159 pages and 3 rebuttal exhibits, which is amended and replaced by commission order issued on July 22nd, 2024?
Yes.
And do you have any changes or corrections to your rebuttal testimony at this time?
I do not.
And if I were to ask you the same questions today that appear in your rebuttal testimony, would your answers be the same?
Yes, they would.
And your rebuttal testimony, as well as your Exhibit 1, contains confidential information.
Correct.
And did you also prepare and cause to be pre-filed a summary of the panel's testimony?
Yes.
Presiding Commissioner Kimmerer, at this time, I'd ask the panel's confidential rebuttal testimony and rebuttal testimony summary be entered into the record as if given orally from the stand.
Seeing no objection, the panel's rebuttal testimony that contains confidential provisions along with a summary of the testimony will be entered into the record as if given orally from the stand.
Thank you. I'd also ask that the panel's 3 exhibits be pre-marked for identification to be entered into the record at the appropriate time, and that confidential exhibit 1 be maintained under seal as filed.
Seeing no objection, the 3 exhibits, including the confidential exhibit, will be marked as identified.
Thank you. Before opening up the panel to questions from cross-examination in the commission, I do have one procedural matter to request leave from the commission. During the direct examination of the panel by counsel for SACE et al., counsel introduced confidential IRP and near-term actions panel direct supplemental exhibit 9, which presented a comparison of Duke's modeled battery storage costs and compared that to the projected battery costs in the supplemental planning analysis with the NREL ATB report for 2024. As the commission may recall, during that direct examination of Commissioner Snyder, there's a number of questions asked about that confidential exhibit, which he accepted subject to check. Subsequent to that examination, we worked with counsel for SACE to obtain the work papers and check the accuracy of the exhibit and the way it was presented in the examination, both of Mr. Snyder, and then in a subsequent panel, there were some questions asked to Ms. Meeks. We worked with SACE to ensure that the commission has the most accurate information. And so through checking that exhibit, we identified that the way it was portrayed wasn't complete and fully accurate in the representations. And so it was, I think, respectfully, it was lawyers doing math. And so that was always a dangerous place to be. But we've worked constructively with SACE to get to a proposed exhibit, which is not replacing the original exhibit, but subject to leave from the commission. We would allow Mr. Snyder to have a brief opportunity to explain the updated exhibit and how it more accurately characterizes a comparison of what was intended to be represented by the initial confidential Exhibit 9. We identified for the parties and commission staff that this was part of the plan introduction to the panel's rebuttal presentation. And so consistent with ordering paragraph 4 of the commission's July 18th order, we do believe there's good cause for this late filed supplemental exhibit, which Mr. Neal would propose to introduce at this time to be introduced into the record. And then the companies would ask for a brief opportunity to direct examine Mr. Snyder to answer a few brief questions about what the data actually shows.
Okay, thank you. Mr. Neal, do you wish to be heard?
No, that mostly summarizes the issue. I think what will hopefully become clear is, what the NREL ATB comparison was to which particular cost assumptions do use and encompass versus what we have now, which will be overnight capital costs to overnight capital costs. So I think the attempt is to get to an apples to apples comparison.
Okay. Seeing no objection, do you have copies of the exhibit or?
Since it was SACE's original exhibit, we work with SACE and they have agreed that they would propose to sponsor the now updated exhibit that would go into the record. So Mr. Neal has copies and
okay,
at the appropriate time would present that to the commission.
Okay, Mr. Neal, for efficiency, why don't you just go ahead and pass it out to the commissioners? So I will allow your motion. Good cause has been shown. And we and the parties are providing copies of the exhibit to the commission and the court reporter.
Thank you. Thank you. So with leave of the commission, just a few brief questions for Mr. Snyder about the exhibit.
Yes, you may proceed.
And just to be clear, this is a confidential exhibit that should be maintained under seal, but we anticipate that we can speak generally and directionally to the confidential information and not have to go in a confidential session.
Okay, and if there's any questions from commissioners, we will make sure that we do not reference any confidential provisions.
And we'd be glad to go in a confidential session if need be, but hopefully that won't be needed.
I hope so too.
Thank you. All right. Good morning, Mr. Snyder.
Good morning, Mr. Brushwood.
So, or I'm sorry, would it be appropriate this time for Mr. Neal to, has the exhibit been appropriately identified and we have the sufficient foundation at this point?
Okay, Mr. Neal, can you proceed?
Please. Thank you, Presiding Commissioner Kemmerite. At this time, we would ask that SACE et al. Confidential potential cross-exam exhibit 74 be marked for identification as SACE et al. Cross IRP NTAP rebuttal confidential exhibit 1.
Okay. Seeing no objection, it will be so marked.
Thank you. So, Mr. Snyder, I want to start with just generally, you recall the questions from Mr. Neal to you in your direct case about what was previously confidential Exhibit 9 that presented a comparison of the company's supplemental planning analysis, battery cost assumptions, and then compared that to the 2024 NREL ATB updated report that had been issued?
I do remember those.
Okay, thank you. And subsequent to that exchange with Mr. Neal, I think you said that you were accepting the comparison subject to check. Do you recall that?
I do.
And so subsequent to that, you and your team went and actually checked and did the analysis of the accuracy of that comparison and identified some concerns with the way it was presented. Is that generally fair?
That's fair.
Okay. And can you explain this new updated exhibit and what it shows and explain it to the commission, please?
Yeah, certainly. I think it was just a difference in how dollars are represented. I think Commissioner Hughes has pointed out a couple of times in this proceeding, you can look at the dollars in nominal or you can look at them in real terms. And real meaning you subtract out the impacts of inflation. And it's often easy to cross the two. And I think that's just what happened in the original exhibit was we were comparing companies' inflated costs to NREL real costs. And so what this exhibit does is it puts real to real or, overnight to overnight. And so once that's done, then you have for that specific variable made that correction. I'm not speaking to Miss Meeks saying that there could be some other things in how costs are derived due to battery configuration or technical. I'm not the technical expert on that, but just from a model to model or number to number comparison, that's what we saw.
Okay. And directionally, is it fair to say that the company's fall 2023 supplemental planning analysis battery storage assumptions are materially closer to what the 2024 NREL ATB report assumptions represent when compared on this more apples to apples basis?
Yeah, in the original, it showed us being significantly outside of the NREL range. NREL gives a range. They have, what they call conservative price decline. They have battery cost declining over time, and they have conservative, mid-case, and aggressive price decline assumptions. And we were outside the range in the original filing. What the exhibit, without getting into the numbers, shows is it brings us under their conservative and between that and their mid-case. And you've got the numbers to see the percentages and everything in front of you. So, you can see where that does. So it does move us within the NREL range of cost to their 24. Again, not speaking for Witness Meeks on other differences that NREL may have.
Thank you. So based on your further review of this issue, is it accurate that the company believes your initial battery storage cost assumptions presented in the supplemental planning analysis remain reasonable for planning purposes?
Yeah, I continue to maintain that.
Thank you. That's all I have. The panel is now available for cross-examination and questions from the commission.
Mr. Smith, I think you're up for Abendbrand.
Thank you. Ben Smith for Avangard Renewables. I would like you to turn to page 20 of your rebuttal testimony, please.
We're there.
Thank you. And beginning at line 10, I'm going to read this excerpt because it's going to lead to the questions I have. And you can confirm that I'm reading it accurately. The public staff also finds the modeling nuclear resource availability and proposed action for meeting these timelines reasonable, so long as the development of the SMR industry stays on pace and the cost estimates used in the Encompass modeling for the 2023 CPIRP for SMRs remains within a reasonable range, with the company's updated costs in the SPA generally aligning with the public information provided in Dominion Energy North Carolina's recent 2023 Integrated Resource Plan. Did I read that right?
You did.
Thank you. So what I want to talk about is sort of planning for a resource that's not yet commercially available in the terms of modeling. And I guess I'll start with, when you're validating your modeling scenarios, is it fair to say that you compare your outputs with historical data like real-time costs? For instance, you would compare a CT output versus what the real world cost for a CT would be.
Yeah, I think you compare it to that, but also to publicly available, sometimes not, sometimes private engineering firms that give you cost estimates, often with specific projects. There are specific project details that can drive costs up or down relative to a more general generic representation of the cost for planning. Things like, are you in a union or non-union labor environment? Are there specific site characterizations that were challenging for a CT? Was it located in a spot easy to site or difficult? So things like that. So you have to take the real world information. You certainly want to look at that. But often your generic costs are based on studies that come from engineering firms that are responsible for building these things.
And when you want to incorporate a new generation asset, one that's not yet commercially available, what's the process for reviewing the cost assumptions that will be in your model there?
We look for sources of industry data that are being used for these individual technologies. Generally, Thomas, you can correct me or maybe add to what we used for.
For new nuclear specifically, we use an Idaho National Labs report, which Mr. Capps can tell you more detail about, but that was what recognized industry report.
Sure. And I want to keep it on modeling, and maybe Mr. Capps can testify to modeling, but my understanding is you all are the modeling panel on rebuttal. Isn't that right?
That's right.
So when you're going to be modeling, step back. Were you here for the public staff panel testimony of Mr. Metz and Mr. Thomas?
I was here for part of it and I watched part of it.
Okay. Do you recall them discussing the price inputs that came out of the Idaho National Laboratory report?
I don't recall the details of that conversation.
Okay. As paraphrasing, subject to check, they said that there was one price assumption that was built into the SMR modeling in Duke's model. Is that accurate?
So for the SMRs, we had one price cost. Yes, that's what you're asking.
So are you all familiar with the concept of scenario analysis?
Yes.
So wouldn't it be prudent to, when you have a asset that's not yet commercially available, to model a range of price inputs in case the model, in case the asset costs more or less than what a national lab report, for instance, might project?
Couple quick points. Yes, I think it is reasonable. We did run high capital sensitivities across technologies and high and low capital sensitivities And we also used a conservative, I mean, the first of a kind, pretty aggressive, when I say aggressive, pretty high cost for nuclear, recognizing it was a new technology. And then we did stress that with sensitivity analysis.
But did you use multiple prices in the ultimate model that provided the recommended portfolio?
We viewed that in the high, and Thomas, I'll invite you to add any detail, Mr. Beatty. But we did run a high capital sensitivity that stressed up. You got to remember, these capital prices can move for all technologies, whether it's nuclear, offshore wind, solar, gas. So we did run a high capital across all technologies to see if you take your higher price ones and yet again stress those relative percentage wise, that's going to be a bigger nominal increase than lower cost technology. So we did a 25%, I believe, stress on high capital, and it did still select new nuclear in that scenario.
Thank you. And I guess I'm more getting at the idea of a scenario analysis where you include both high and maybe lower pricing for a new asset like SMRs. Wouldn't it be prudent to model a range of cost outcomes in a scenario analysis on this?
I think I just testified that we ran 25% high, 25% low, and a mid case. So I view that as a range.
Okay, so I might be confused. I thought I heard that you all used one price from the Idaho National Lab.
We use one price in terms of, and again,
So we ran one price as our base forecast, and we ran that for most cases, but we did run two sensitivities, a high capital cost and a low capital cost case for all technologies.
And so there was a run that was a high capital cost case specific to nuclear?
It was across all technologies.
No further questions.
Ms. Kress, I think you're up for SIGFR.
Thank you. Good morning, gentlemen. You testify in your rebuttal testimony on page 123, if you'd like to turn there. Lines 5 through 8, you testify that, quote, while a merged utility would allow for efficiencies and cost savings in collectively satisfying the reserve margin as one utility, prior to a merger, the companies are not permitted to jointly plan for capacity needs. Did I read that correctly?
You did.
Have the companies quantified, as we sit here today, the potential efficiencies and cost savings that could flow to the system and by extension to ratepayers if the companies could jointly plan for capacity needs and jointly satisfy their reserve margin?
We have begun to look at those, but we have not formally filed those here in this case.
Have you shared those in discovery in this case?
I am not aware.
Okay. Do you know who would be aware? Would that be a Ms. Bateman question, perhaps?
Perhaps.
Okay. You also testify on page 110 of your rebuttal testimony that deferring a decision on offshore wind allows for more time to receive information from leaseholders through an RFE. Is that right?
Can you direct me to a line number? I'm sorry.
Sure. Lines 9 through 14.
I see that, yes.
And it also allows for more time to gain alignment on significant investments between North Carolina and South Carolina, correct?
Correct.
You would agree that House Bill 951 delegates significant discretion to this body in the implementation of the carbon plan. Is that fair?
Yes.
Including the discretion to delay interim compliance beyond 2032 for reliability or affordability reasons, or in the case of offshore wind or nuclear being selected as a new resource, correct?
Objection. This is calling for a legal conclusion. Mr. Snyder has previously stated he is not an attorney.
Ms. Kress, would you like to respond?
Mr. Snyder and his panel testify extensively about House Bill 951 and the company's interpretation and application of House Bill 951 in its modeling and in its selected carbon plan and near-term action plan. And as the witness who is providing that vision on behalf of the company through some 202 total pages of rebuttal testimony and exhibits, I do think this question is appropriately directed to this panel.
I'm going to overrule the objection. Mr. Snyder, recognizing that you are not an attorney and you're not providing a legal conclusion, answer the question to the best of your ability.
Yeah, I think to the best of my ability, we all understand House Bill 951. The one correction I would make to Ms. Kress is I think the commission, it says nuclear and wind. It doesn't specifically say offshore wind.
And so just to clarify your answer there for the record, you agree that House Bill 951 provides this body the discretion to delay interim compliance beyond 2032 for a number of reasons.
I would concur with that.
Okay. And it also includes the general discretion including perhaps to require more frequent updates from the companies on the status of the IRP and carbon plan implementation. Is that fair?
I don't know that section of the rule. If you can point me to it, I could.
So the question is whether or not House Bill 951 delegates general discretion to the commission in the setting and implementation of the carbon plan.
Yes, I think we just spoke about some of the flexibility afforded this commission.
And so do you agree that the commission has the discretion to require more frequent updates as it pertains to affordability and reliability?
Presiding Commissioner, I think maybe objection to the lack of clarity, though, when council is saying more frequent updates. Can you?
Okay, Ms. Kress, can you restate the question and provide some more specificity?
Mr. Snyder, do you agree that House Bill 951 requires updates to this commission every 2 years?
I do.
Do you, and you previously testified that this House Bill 951 delegates significant general discretion to this body in implementing the carbon plan, correct?
We spoke about some very specific language that we called out that I agreed on. So I would say on those specifics, I agree. With respect to the frequency of filing IRP or IRP updates, I am not familiar with any section of 951 where that's other than the shall file every 2-year section of the rule that envisions or contemplates filing it on a more often basis. I think R860A also envisions every 2 years. I would never tell this commission what they have discretion or not discretion to do, but I'm not familiar with that filing more often as part being envisioned in 951.
You testify on rebuttal that Duke's near-term action plan supports what you contend to be the most reasonable, least costs, and least risk resource plan. Is that correct?
Yeah, we've had a lot of testimony in the last 2 weeks about these balancing factors, and I believe that our near-term action plan works very hard to strike that balance of all of those.
Would you agree that the present value of revenue requirement is an important metric for determining whether one portfolio is least cost as compared to one or more other portfolios?
It is a used metric, yes.
And it's used by the companies in this proceeding, is that
Yes.
correct? Is it fair to say that capital spending is an important input into calculating those respective PVRRs for different portfolios?
It is an important input.
Okay, thank you for that. And now at this time, I do have some questions about your rebuttal exhibit 1, which the companies have designated as confidential in its entirety. And so unfortunately, because of the company's confidential designation, it does require a confidential session.
Okay, so we are going to go into Did you wish to be heard, Mr. Brushworth?
Yes, Presiding Commissioner. So the Exhibit 1 is a replication for the commission's convenience and for ease of parties to see tables, exhibits, figures that were presented in the testimony. So there is one figure that is confidential that was in the testimony that's replicated in Exhibit 1. So no objection to going into confidential session if that's necessary, but to the extent we can just ask directional questions about, I don't know. I guess I'm just clarifying the record of it's not comprehensively confidential. There's only one figure that is confidential, and I defer to Ms. Crest if we need to venture into confidential sessions so she can ask questions about it.
So Ms. Crest, are you going to be asking questions about the confidential aspect or numbers in the exhibit?
I am.
Okay, so with that, we will go into confidential session, and the hearing room will need to be cleared of everyone who has not signed, and help me here. Mr. Brushwood, tell me what the confidentiality is. Is it the confidentiality agreement with Duke Energy?
Yes, Presiding Commissioner Kimmerer, this is Duke's confidential information. So it would be the non-disclosure agreement that Duke Energy has entered into with most parties in the room, and I'm looking to confirm. And
so every person in the hearing room who has not signed the NDA needs to leave the hearing room. Okay, Ms. Crest, you may continue.
That was the end of my questions. Thank you.
Mr. Smith with EDF, I believe you're next.
Thank you. Just 1 second. I apologize. I pulled the Okay, Ben Smith, on behalf of Environmental Defense Fund, I'd like you to open up to page 147 of your rebuttal testimony.
I'm there.
Okay. I'm at the top of this page. There are 4 options for converting gas units under, as the companies see it, to meet the carbon neutrality requirements by 2050. Isn't that right?
Yes. I wouldn't say converting. There's 4 pathways we see towards compliance with the net zero by 2050 requirement in 951.
Thank you. So my questions are pretty simple. If a pathway is hydrogen, when can we expect the full cost implications of that hydrogen build out to be included in Duke's modeling?
We included hydrogen in our modeling to date. I know parties have taken different opinions as to how much and whether there's enough costs of hydrogen in the modeling, but I would say we have already included hydrogen in the modeling, and there's just a difference of opinion as to where those future costs may be.
Okay. Okay. And if it's the same question for carbon capture and sequestration, have you all included that already in your modeling, or do you intend to do so in the future?
Certainly might do so in the future, depending on how that technology comes to fruition in the industry. I think the point of this general part of my testimony says that the nation as a whole, on prior pages right near this section, has 45% of the nation's energy comes from natural gas. So North Carolina is not alone in seeking to decarbonize. And so we are going to be a player within the industry and try to be a leader within the industry in one of these pathways. But, you know, the fact of the matter is if the nation is going to decarbonize from its most prolific source of energy by an order of magnitude, there's nothing close to natural gas that provides electricity in the U.S. today. We collectively are going to have to go down right now, unless some new technology comes out in the next 25 years, one of these pathways, which is hydrogen. We can use carbon capture. We can get down the resources down to where they're running at a level that is not as intense as they're running today, and potentially have offset markets. And then to the extent they're needed slightly beyond that, there may be a reliability need to run those beyond that. So that's just the 4 pathways that I point out generally that the nation is considering at the moment. And we have included hydrogen costs in our modeling today as one of those pathways. Could that pivot in the future to sequestration or offsets? That's certainly a possibility.
Thank you. And last question, would the companies consider, are the companies considering for these 4 different pathways, given that they're relative to decarbonization, providing the impacts and the carbon reduction requirements as they move forward, modeling out these different pathways?
I believe we've done that at an early stage right now with a blending of hydrogen and then converting over a longer time horizon. But yes, we will update those as these technologies mature and come to fruition, and the impacts that they might have on the pace of decarbonization of our gas fleets. We will include those in future IRPs as appropriate.
And last question, and specific to option 3, utilizing the carbon offset markets to offset up to 5% of the baseline carbon emissions. I don't have any qualms with that statement, but is there a way that the companies intend to sort of validate this 5% offset to show that they're not going above it going forward?
Yeah, I would think, and again, it's early in the game. Offset markets are starting to emerge around the country, but I certainly believe having a verifiable offsets and demonstrating that you're within that, your offsets are consistent with your emissions so that you do have a verifiable offset would be a part of that future market. So yes, I see that.
Thank you. No further questions.
Mr. Neal, do you have cross-examination?
Yes, I do.
Okay.
Just waiting for the green light. Good morning. Mr. Snyder, how you doing?
Good morning, Mr. Neal.
I think most of my questions are for you, but obviously feel free to jump in if need be. As a general matter, you would agree that your modeling team receives inputs for capital cost assumptions for various technologies from other teams in Duke, including Duke staff involved in procurement.
Yes, we definitely receive inputs from others.
And returning to batteries, the original comparison that we discussed and that was previously entered into the record as SACE et al. Cross IRP NTAP direct and supplemental confidential exhibit 9 that you discussed with Mr. Breitschwerk at the outset, you would agree that that compared Duke's inflated direct costs with the capital expenditure costs from the 2024 NREL ATB for 4-hour batteries, correct?
Again, with the clarity that it was an NREL real cost,
That's
so
right.
that did not include inflation, to a number that did include inflation. So yes, originally
You were also comparing inflated direct cost to a overnight cost.
Well,
As Ms. Meeks stated, that is not an apples to apples comparison.
and that's part of what I wanted to clear up. And I could turn your attention to it if need be, but the SACE et al. Cross IRP NTAP direct supplemental confidential exhibit 9 that's already been entered in the record. I'm happy to do you have a copy of that? The original one.
I do not have the original one. Is it in one?
It would be
Which potential exhibit was that?
it's not in there, but you will need that in a minute. That was I can tell you in just a second. It was potential cross exhibit 8 so it'll be in our second notebook.
And again, Mr. Neal, this contains confidential
It does, but
information.
I'm not going to elicit confidential testimony.
Okay, thank you.
I now have that.
And just in the upper left-hand corner, do you see where the reference, in the, where it has the NREL ATB, that it says, it doesn't say OCC or overnight capital costs, it says capital expense costs?
Where it says CapEx, all values are given in 22 US dollars.
Yes.
Yes, I see that.
So, and again, this is part of why I wanted to clear up is that I misspoke. And in my cross-examination of you, that the original comparison was not to the overnight capital costs in NREL, but to all their capital expense. Just wanted to make sure that was clear for the record.
Yes.
All right. So if now I could have you turn to SACE et al. Potential redirect exam exhibit 28, which is in the other notebook. And we would ask Presiding Commissioner Kemmerite, that this be marked SACE et al. Cross IRP NTAP Rebuttal Exhibit 2.
So potential redirect exhibit 28, SACE's potential redirect exhibit 28 will be so marked as exhibit 2.
And Mr. Snyder, do you see where that's the definitions from the NREL ATB?
I do see it.
And I'm sorry, the binder is, if you need.
That's all right. I can look at it sideways.
Well, just to direct your attention to, you see that there's an explanation of what elements are included in NREL ATB's capital expenditures on that first page, starting on that first page.
Yes, I can see that.
And you see, if you go into down into the next page, that includes the kinds of costs required to achieve commercial operation of any given technology.
Yeah, I see their categories.
And then if you turn on page 2 of that exhibit, you see that overnight capital costs is just one component that's fed into the NREL capital expenditure cost projections. There's a definition.
I see it.
Okay. And the reason I'm bringing this up again is just to make sure we're all clear. This is one reason why the SACE et al. Confidential Potential Cross Exhibit 74 that we introduced into the record has different prices, has different NREL prices as well, because we are now looking at overnight capital costs and not the more expansive capital expense costs. Do you see how that, do you see what I'm trying to get at?
Yeah, I think so.
Okay, this was just, and did you tune into questioning of Duke Witness Meeks on the renewables and energy storage panel?
Yeah, I believe I was here for that.
And at one point, do you recall that I asked something to the effect of, in our original comparison, we were looking at overnight capital costs from the GUS and overnight capital costs from NREL?
Yes, I remember.
And you would agree that I misspoke and that I should have said we were comparing the inflated direct capital costs that Duke used in Encompass with the capital expense costs from the NREL ATB.
Yes.
All right. Thank you for helping me clear up the record. So staying on Exhibit 2, the NREL definitions. I'll have a question about that in a second, so don't let that go away. The new exhibit that we've entered in, or that will be entered in the record, the SACE et al. Confidential Potential Cross-Exam Exhibit 74, which has now been marked Exhibit 1 for this panel, now compares the overnight capital costs used in Duke supplemental planning analysis with the overnight capital costs projected by NREL ATB, correct?
Correct.
All right. So turning your attention to page 6 of those NREL ATB definitions.
And I'm sorry, which one have we turned to again?
Redirect Exhibit 20, Redirect Exhibit 24 that had the NREL ATB definitions. It was in the, you just had, it was the last exhibit in this notebook right in front of you.
Oh, got it.
So if
28.
you go to page 6.
Mr. Neal, I believe that it was potential redirect exhibit 78. Can you confirm?
28.
I'm sorry, 28.
28.
Excuse me. Yes.
Sorry. Yes, which has now been marked as SACE et al. Cross IRP NTAP Rebuttal Exhibit 2.
Okay. So for clarification, it is potential redirect exhibit 28 that has been pre-marked as SACE et al. Cross IRP and near-term actions panel rebuttal exhibit 2.
Yes, thank you. Do you see on page 6 where it has definitions of the terms conservative, moderate, and advanced scenario?
I'm sorry, what page is that?
It's page 6 of that exhibit.
Yes.
So could you, it's a very short definition. Can you read the conservative scenario definition that NREL uses?
Historical investments come to market with continued industrial learning. Technology looks similar to today with few changes from technology innovation. Public and private research and development R&D investment decreases.
And does Duke anticipate public and private research and development investment into battery technology to decrease in the coming years?
No, I think, the U.S. is trying to increase, as I'm generally observing the market. I'm not Ms. Meeks and the expert in that one, to try and have a domestic supply chain that does not rely so heavily on our current China supply chain for batteries. So I think part of the difficulty with batteries is you have different costs at different points in the world, and everybody is trying to advance that. But today, some of the lower costs are coming from supply chains that may prove to be difficult in the future. So there's a lot of puts and takes, as I said in my direct testimony, on battery costs. But yes, the U.S., as I understand it, is continuing to try and develop its domestic supply chain, but the NREL costs may not be based on a U.S. supply chain. So their starting point may be higher than what we're using today.
Does Duke anticipate there will be few changes in battery technology innovation in the coming years?
No, I think that's a good reason to have a measured pace of adoption. Is hopefully costs will come down dramatically in the future, and degradation rates will get better. So part of it is, no, we hope for enhancements in the battery technology.
And just to speed things along, can you just read the advanced scenario definition on that same page?
Innovations far from market ready today are successful and become widespread in the market. New technology architectures could look different from those observed today. Public and private R&D investments increase.
So if NREL, pardon me, if NREL ATB's advanced overnight capital cost projections end up being more like what we see in the market over the next decade, you would agree that's a good news story for Duke's ratepayers, because capital costs will be significantly below what Duke assumed in this proceeding.
Yeah, I hope the cost of all technologies come down.
And you would agree that Duke's assumed capital costs for 4-hour batteries show up in the PVRR calculations that Duke used to compare the costs of various portfolios?
They do.
So switching gears to your rebuttal testimony, when, and just, I think this will be very brief, and we can take as a given, you've said to this commission in response to a number of questions that it's your opinion or Duke's opinion that the P1 fall supplemental is not executable. So I understand that's Duke's position, correct?
Yes.
But you would agree that even as a modeling exercise, Duke did not look at how P1 fall supplemental might comply with the 111 rules in comparison with the P3, correct?
No, I think when you say 111 rules, can you be more specific? I think they all comply. Oh, you're saying, I'm sorry, I was thinking 951. How the modeling, did we do a modeling of 111 under a P1? No.
And in the modeling sensitivities to explore compliance with the EPA's 111 rule, you would agree that Duke explored an aggressive SMR scenario, which assumed that the first SMR could come online in 2034 and increase the total number of SMRs available for selection.
I think increase it by 2 units over through 2050.
And Duke also considered an aggressive SMR no offshore wind scenario as part of its 111 scenarios, correct?
Correct.
And now Duke did not provide an aggressive offshore wind scenario as part of its 111 modeling. Is that correct?
No, it did not.
And Duke did not provide a delayed SMR scenario as part of its 111 sensitivity.
No, what we did was we looked at the trade-off. I think public staff in their testimony as well acknowledged, and I think the term is used that offshore wind through all the initial modeling and the supplemental before you even get to clean air 111 modeling. So we did 3 waves of modeling in this proceeding. I think Mr. Metz used the term ductile, which I had to look up. Mr. Thomas used the term fickle. I would use the term marginal. So offshore wind has always been the marginal resource that when you hit resource limits and still want to comply with a given interim date, offshore wind, if available in the time frame, so not available by 2030, but yes, available by 2035, gets selected. If what the public staff observed, we also observed that if you give it more time, that offshore wind either gets delayed or eliminated from the planning horizon. So if that interim compliance date moves out, whether that's for 111 or for other reasons that this commission has the latitude that we just spoke of earlier today, that would be the marginal resource in a check and adjust that would move out in time or potentially decrease in volume. And that's what, when we hear the term ductile or fickle or marginal, public staff was referring to. And so in the 111, we were illustrating with a couple of our sensitivities how those might play out in those scenarios, how that resource would come to fruition.
The flip side of that, Mr. Snyder, you would agree, is that if for whatever reason advanced nuclear SMRs were delayed as a technology, and you were still looking at EPA 111 compliance or HB 951 compliance, there might be a need to bring that offshore wind online sooner to make up for the loss of the SMRs, correct?
Yeah, I think, we pretty much have in a very aggressive case for offshore wind as it is. And when you speak of, Mr. Neal, our accelerated nuclear, it was really, 1 unit by 1 year and a total of 2 units through 2050 increase. So it was not a market increase because that also is a long lead time resource that we just can't bring on, by 2030, like a P1 would need it to come on, or nor could we bring offshore wind on that fast. So this was just to show just how a slight move can impact that marginal unit. And so that was the intent of the analysis. After seeing public staff's testimony, it confirmed what they were seeing is that, it plays a role, but that role can vary depending on other factors in the plan.
And Mr. Snyder, when it comes to nuclear projects that have been built in the United States over the last few decades, are you aware of a nuclear power plant that was built to completion ahead of schedule?
I am not.
No further questions.
So Ms. Grunman, I believe you're next. So we'll need to make a space for her at the council table. Oh, I'm sorry. There is a chair already there for her. Okay.
Maybe councils that are done can take their notebooks. I don't know where to put them or I do it, but we're running out of space. Sorry, I just I'll be brief.
Good morning, still gentlemen. Carrie Grunman on behalf of Walmart. I am looking at table 2 on page 40 of your rebuttal testimony. And that is the table that reflects the company's proposal to phase in the 22% reserve margin beginning in 2027, going up 1% until 2031.
I'm there.
And you're contrasting that with what was public staff's original proposal to sort of implement the 5% in 1 year as of 2031, correct?
Correct.
And even today, and I didn't ask you about it because I think it came up in response to a question that Commissioner Duffley asked you on commissioner questions when you were up on the settlement. And because the commission has asked that exhibits not be entered in response to commission questions, I wanted to raise it with you here. Both in the rebuttal testimony and then as a result of the stipulation, the company is still planning to phase in that 22% reserve margin, correct?
Yes.
Can I ask you to turn to what has been pre-marked as Walmart Potential Cross-Examination Exhibit 12? And Your Honor, I would ask to mark it and I would request your guidance on precisely how to do so.
So we will mark Walmart's Potential Cross Exhibit 12 as Walmart Cross IRP and Near-Term Actions Panel Rebuttal Exhibit 1.
Thank you, Your Honor. Just looking at this response, Mr. Schneider, you are the respondent for this particular response, is that correct?
I am.
And I'm looking down towards the latter third of that response, beginning with the sentence, for the period 2024 through 2031, DEC reserve margins range from approximately 19 to 23%, and DEP reserve margins range from approximately 19% to 27%. Do you see that?
I do.
When you are providing those ranges in your responses, is that something that's sort of growing every year, or is it up and down throughout that 2024 to 2031 period?
It can be lumpy.
Okay. And did you reflect that lumpiness in a table anywhere in your testimony, either in direct or rebuttal?
It would be in the LCR tables that are in the technical appendix in the SPA. That would where you see the year-over-year reserve margins.
Thank you. Those are all the questions that I have.
So that's the end of cross-examination questions. Redirect.
Very briefly, thank you. Mr. Snyder, two questions. First, Councilor Sigver had some questions during confidential session on your figure, your confidential exhibit 1, figure 5. Do you recall those questions?
I do.
And there was some discussion about whether the cost identified included an assumed transmission cost.
I remember those.
Okay, but you didn't recall at the time whether that was included in the capital cost assumed for the technologies.
Yeah, I would need to double check to see.
Would you accept subject to check that your team has double checked and that they would confirm that note 1 is correct and the forecasted technology specific capital cost presented in figure 5 did not include transmission cost?
Yeah, I think that we would need to amend that note. That was my understanding all along, so that does not surprise me. I think what it did include is interconnection, but not network upgrade.
All right.
So cost interconnect, but not network upgrade.
Thank you. Councilor Sigfer also had some questions about the company's plan and what you viewed in your rebuttal testimony addressed as the most reasonable, least cost, and least risk resource plan. You recall that?
Yes.
And she was highlighted that in terms of the relative cost of resources and how that was informing the pace of execution.
Yeah.
And I think in Exhibit 1, this is not a confidential part of the exhibit, but figure 7, I believe you had some testimony about how the company viewed the P3 pathway and the fall-based portfolio as the most reasonable and least cost and least risk trajectory of execution of the resource plan. Is that a fair characterization of what you're trying to present there?
Yes.
Would you just take a minute and talk that figure through the commission and what you perceive that it represents, and also then address how that pathway 3 and the fall-based portfolio relates to the stipulated resources that are included in the stipulation with the public staff and other parties?
Yes, certainly. I think it's a really important exhibit, actually, there's a lot of discussion last 2 weeks about, going faster, going slower, load materializing, load not materializing. If we don't have resources, the load won't come to the state. If we build them, maybe they don't come and then we strand them. And so there's all this discussion for 2 weeks. And I think this graphic tries to just simply illustrate that we recognize, I think Witness Thomas said, no model is perfect, and he'd be remiss not to get on the record that our models are wrong. I don't know if I'd go that far, but I would say there's certainly inherent uncertainty in both the load forecast and the pace of resource additions, whether in execution space, they can be moved up or run into barriers that could cause them to slide. So all this graphic tries to represent in my rebuttal testimony is, where does this commission and the company and the parties, where are they better off if we land? And if you look at that graphic, it simply shows that the pace of resource additions is on the horizontal axis and the vertical axis is load growth. And it says I tried to simplify it to 4 basic outcomes. Either load comes really fast and then we don't keep up with resource additions. That's the upper left quadrant. That's the worst place you want to be. That's reliability risks. That is day in, day out. I'm struggling to keep the lights on. I don't want to be there. I don't, as a planner, intend to have us land there. If load comes in low because we weren't able to bring in the resources, that's the lower quadrant, lower left. That just means we had to start putting the brakes on economic development and telling people to look elsewhere because we don't have internally the approvals or the action plan to execute fast enough to enable those businesses to locate here. So I call that the missed opportunity quadrant, right? And what we're talking about trying to strike the right pace is I'd rather be on the right side of the quadrant. I'd rather, if I'm going to miss it all, and if you take the center as P3 base and the stipulated resource, I'd rather try and get as close to at or above plan as I can. If I get ahead of plan, and it's obvious that we are going to have resources available, then we may have to be able to attract the type of businesses and industry here because we're prepared to bring them here. So that's the high load sensitivity that we ran in our supplemental analysis, where we not only get those that have made serious commitments, but that queue that's behind them that potentially is looking but haven't committed to North Carolina, we attract them and we have the resources to meet them. That's a growing economy in the upper right. If I get ahead of plan and my load forecast takes a little longer to come in, then I have a lot of mitigation opportunities there. I can then market to new economic development customers. I can sell to my neighbors who might be behind plan, and those in the real time, and those would go to customers in terms of fuel savings. And I would have extra reliability, not be deficient on reliability. So I think it's really important to have a mental model of where do you want to be as you go through this energy transition. Do you always want to be behind plan and chasing load, or do you want to try and get out in front of the plan and be prepared for that load and be prepared for even more load? And there is no perfect answer, as was said many times in this, but the risks and the mitigants to those risks are very, very different. And as a planner and as someone who's been doing this a long time, as I said, I think this graphic says we're far better off to be on the right side, and preferably the upper right, than we are being on the left.
Thank you. And this was specifically at the rebuttal phase prior to the stipulation, but would you briefly touch on how you feel the stipulation continues to reflect this approach and being ahead of plan, as you mentioned?
Yes, I do. And I think there were some questions of, the amount of resources that are in the near-term action plan are consistent with our P3 base, but on the aggressive side. So we've got the higher end of solar and batteries with some check and adjust if we have a VAM or if we don't see the attrition. We had discussion on the CCs and CTs. We still have CC4 and 5 in our modeling and in our assumed needs. We're just not asking this commission at this point in time to select those, and that we need to confirm that those will be needed in our next IRP. And so all of the resources that are needed to maintain reliability and support growth while being able to simultaneously retire over 8 gigawatts of coal in the next decade are supported by the stipulation.
Thank you. No further redirect.
Okay, so that comes to our second morning break. So we're going to take a 10-minute break, come back on the record at 11:37, and we have a slight modification for our lunch schedule. We will be breaking for lunch at 1 o'clock rather than 12:30. We'll go off the record. Okay, let's go back on the record and we will move now to questions from the commission, beginning with Chair Mitchell.
All right, guys, just a few. Mr. Snyder, did you happen to hear testimony given by AGO witness Burgess from the stand in response to questions I asked him?
I was listening, yes.
Okay, so his testimony, and this is my paraphrase of his testimony, sort of challenges the company's assessment of 2030 and 2032 compliance and makes some specific criticisms regarding the robustness of the company's analysis of those early compliance dates. Do you recall the exchange that he and I had?
I do recall that exchange.
Okay. My takeaway from that exchange when he was on the stand is that he criticizes the company's approach to allowing certain resources and not allowing others. I think he referred to it as the suite of resources that the company analyzed or allowed to be analyzed for purposes of meeting those early compliance targets.
I remember that, yes.
And can you respond to Mr. Burgess's criticisms of the company's work?
Oh, certainly. Yeah, Mr. Burgess started mentioning things like, multiple different configurations of solar and storage, or, different types of really what are essentially the same block of resources that in execution you may pivot towards, but in the modeling space, you can't model. The model, just stepping back a second, is trying to solve for the optimal mix. And so when you do the optimization model, it's looking at all permutations and combinations of available resources. And as you start increasing the number of resources the model is looking at, it becomes unsolvable. I mean, some of our model runs today take over a day to run, right? We have a very big system. We're one of the biggest systems that gets modeled as a single, as two systems with the JDA and all of that. And so when you take batteries, for example, you don't need every possible permutation and combination, and it certainly wouldn't change the outcome of the resource plan, because it basically says, I know I need some amount of storage. The exact, is it configuration of that storage with solar is not as important as how much storage do I need versus how much solar. As a matter of fact, I'm not really aware. I asked someone on my team to look. I'm not aware of other utilities that even model solar paired with storage at all. It's here's storage, here's solar, and then we'll figure out in execution how much we end up pairing or not. But we want the model to solve for solar. We want the model to solve for storage. And when you start getting into more and more and more granular configurations, it's really you're not adding to the answer. The model often doesn't have the fidelity at that phase. It's a screening model, and that's why you screen down to these resources, and then in the production cost you do more detailed analysis. So the fact that you could somehow add more granularity and throw more variations of what was already being modeled and get to a different result, I've never seen that be the case where we have had. We've actually are looking for ways to make the model more efficient so that it can run, so that we can do more meaningful sensitivity. So I completely disagree with Mr. Burgess that you can just, unless you've run these models for a living day in, day out, and tried it on our system, and public staff has done that, and they've run into some of the same issues, I believe, which is there are limitations to just how much you can throw at a model. And then you ask, does it add to the answer that this commission needs to come to? So yeah, I completely disagreed with his testimony in that case.
Okay. I want to get you to answer the one specific question that I spoke to him about and that he testifies to. And I'm going to work to pull up his testimony. So just give me 1 second here. I'm getting there. Hang on one second. All right. In his testimony, I'm going to read it to you. I know you probably don't have, do you have it in front of you? Oh,
I do.
okay. Look at page, I have page 13. At the top, starting in line 1, he says, Duke explains that battery and CT availabilities were not increased. Again, this is in the context of examining compliance in 2030. And he says Duke's approach of increasing the availability of some resources and not others is inconsistent and inappropriate, and almost certainly skews the model results when comparing pathways 1 to pathways 2 and 3. So can you just speak specifically to that criticism?
Yes, and again, it comes down to we increased in pathway 1 all resources to what we didn't assume was like we could do nuclear starting in 2027. I mean, but other than that, we increased every resource, basically saying we know it's going to take a basket of resources similar to the 2035, but I'm going to need them all by 2030. Because if it took all of those resources to get me to be compliant in 35, but I had 5 more years, the easiest way to say how much do I need to increase my resource availability is to say, I don't have those 5 years. So now I've got to go back and I've got to accelerate all of those and say they all need to be online by 2030. And so what are those resource availabilities that we would need to allow? And so we dramatically increased in, Mr. Beatty, if you want to call out what we.
So in P1, the SPA, it was over three times the amount of batteries were available to be selected versus P3 fall base. So I would disagree with this statement where he said we did not increase battery availability.
Okay, you've answered my question. Thank you. All right, you took questions just a moment ago from Council for SIGFER about modeling the merged utilities. And we know, or at least my understanding is that in this proceeding, the utilities were modeled as separate BAs, but there was some sharing allowed. Sharing of operating reserves was allowed. But each utility still has to meet its own load obligations. Is that correct?
Yeah, each utility still had to meet its own peak demand resource obligations and have its own independent planning reserves. That was a condition of the original merger back in 2012.
Okay. And the modeling work that you all did for purposes of this proceeding does reflect the reality of the JDA, correct? It does reflect that there is some energy that can move across BAs when it's economic to do so?
It does.
And when conditions allow? Okay.
It does.
And so when it comes time to model a merged scenario where you've got DEC and DEP merged, assuming that the companies, well, first, let me just ask this question before I get there. We've talked a lot about merged utilities, correct? And in this proceeding, and I think general consensus is that a merged utility means DEC and DEP merge into a single BA and a single operating company. Is my understanding consistent with yours?
That is.
Okay. To achieve that merger, isn't it the case that DEC and DEP have to go before the Federal Energy Regulatory Commission and get approval?
With my, I'm not a lawyer, but that is my understanding.
And I recognize you're not a lawyer.
And I'm still jealous.
Mr. Snyder, but it's not the merger isn't a fait accompli, is it?
No.
Okay, so I just want to make sure I'm clear, because we talk about merger as if it were gonna, I know it's within the company's plans and the company is moving that way, but there is still a regulatory hurdle the company has to clear to get there.
Yes.
And I'm not undermining the work the company is doing to get there, but I just want to recognize that reality. Okay. So when it comes time to model the merged utilities, what do you anticipate the models will show? And I'm asking you to speculate here, but since you've been running these models for so long, I'm hoping that you have some informed opinions.
Yeah, and I think, there's been a fair amount of testimony on the fact that, there is efficiency and there's others have testified to this, in having a single 22% versus individual 22% reserve margins, right? So that if DEC happens to be long and have excess capacity, on a forward long-range planning perspective, DEP would then, you'd be one, so you'd be able to take advantage if they were short. And the two could share long-term planning reserves, such that as you build bigger units that may make it, and we use the term, I use technical term lumpy, that has you a little long in one utility and maybe deficit in the other. Right now, we'll show a build in this other utility to maintain them individually. And so it will help you defer and more efficiently time assets coming on the system so that you can smooth out some of that potential. Now, I think the bigger one that hasn't been discussed at all that will show future benefits is you'll also be able to optimally site resources, right? And so to the extent solar is got a better interconnection, better irradiance in one part of the state, you'll be able to site it more optimally. To the extent wind has better, if gas plants are better in one area or nuclear is better, you're going to have a bigger geographic footprint over which to site all of these resources. And that will help lower the cost of these resources by finding the most optimal site for each resource type as a merged utility.
Okay. When Mr. Thomas was on the stand, I asked him the same question, or I think I asked him, somebody asked him, and he indicated sort of his answer, at least in my view, was consistent with yours, that we'll see some savings as we think about the reserves that are going to be required. And what I took away from his comments or his testimony was that we're not going to see an entire CC deferred or a large generating unit. It'll be savings along the magnitude of hundreds of megawatts. Do you remember his testimony, and do you agree with his testimony?
I generally agree. I mean, you're still needing 22% collectively as a whole. It's not like you magically go to 10% because you're merged. So yes, you'll be able to move in that. In my estimation, it would be potentially move that in that order of magnitude back and forth more efficiently in a merged utility.
Okay. Now, so what I hear you saying is there will be some savings that the company will be able to realize, assuming its merger plans are approved as it envisions at this point in time. But those savings may come from, as you say, things like optimal siting of a facility or sort of refinement and timing and perhaps shaving off of actual megawatts of capacity, but it's not going to be big, large generating plants.
I think they will move in time as opposed to just shaving off, large chunks by and large. And again, I went through a pretty long, I apologize on that. It can help us get ahead of plan, right? There's a lot of headwinds we're facing right now, as we've all discussed. This is a very aggressive transition, and we have an aggressive but achievable execution plan. We need to find ways to get some tailwind behind that. And I would say the merger, it would be a good tailwind that would help us in execution, because we certainly are going to have, as we've all acknowledged, our share of headwinds. And so the way I look at it is, the merger will help us efficiently bring this energy transition into being.
Okay. Their testimony in this case from some of the parties and suggests that a pause until the merger is accomplished would be prudent, is called for in the interest of ensuring that we don't overspend or overbuild at the risk of ratepayers. Can you comment specifically on that concern?
Yeah, it's really taken, your magnitude question is really key here, which is the magnitude of the transition we're facing, we just went in confidential session and looked at the capital being deployed across numerous fronts. We can't wait and see, or we are in an execution mode now, and a pause in execution is really going to be detrimental, not just towards the carbon goals in 951, but in terms of an orderly exit out of coal and a movement towards that growth into that 22% reserve margin. You've seen in the near-term action plans the immense number of steps that are being taken across multiple technology types. It would, if anything, we are looking for ways to, how do we accelerate, not pause? I mean, this would be a very bad point in this critical transition to pause over, we want to effectuate the merger while executing on the transition plan. They aren't sequential, they're concurrent.
Okay. One more question on the modeling that you've sort of on the initial modeling. Did you all assume well, let me ask it this way. For the resource adequacy study, now I recognize you didn't perform that resource adequacy study, but certainly you're familiar with it. Is that the case?
Yeah.
Okay. And I know Mr. Wintermantle is going to be up here later, and so you can punt things to him if you need to. But I just want to know, did you all assume for the modeling done there the retirement of Allen 1 and 5?
I believe that was yes,
Okay.
because it happens before the base year of the study.
Okay, just wanted to make sure I was clear on that. All right, I want to ask you now about the 111 Clean Air Act 111 sensitivity analysis that y'all performed. And I really want to focus on 111, the provision of the regs that would apply to your coal-fired facilities.
Okay.
Can you, sort of at risk of having a long conversation about this, can you just walk me through what you all found with respect to the existing coal fleet and implications for the retirement schedule that you had initially proposed in this proceeding?
Yes, I can. And, maybe if not to read every word on it, but if you'll go to our Exhibit 1 in our testimony, this is not the
Exhibit 1 to your rebuttal testimony?
Yes, and it's not the confidential portion, so no concerns there. Page 15 of that.
Presiding Commissioner, clarification, Exhibit 2.
Yeah.
Oh, I'm sorry. No, this is in the figures, Brett. I'm sorry. This is Exhibit 1. It's blown up a little bigger. Sorry. It's the same information that we present elsewhere, but I think this one is blown up bigger so you can see it in Exhibit 1.
Okay, so you want us to go to 15?
Yeah.
Okay.
15 and 19, where it has existing coal. It should be a table that says Clean Air Act, Section 111, Final Rule Summary.
Okay, I'm there.
And you've got existing coal, which is the 111D portion of the rule, and new gas, which is the 111B portion of the rule. And so the rule, and again, a very lengthy rule, but if I were to summarize it, it states you must get out of coal, all other things equal, by the end of 2031. If you want to operate after 2031, you have to reduce your carbon emissions through the use of co-firing. And that is their BESR that they call out, but they actually call out an exact carbon reduction target, but it equates to about a 40% co-firing of natural gas. For units that have the 40% co-firing, they are allowed under the rule to run until the end of 2038. So they would then need to retire in the beginning by 2039. They would need to be retired, even if it's a co-fired unit. And then there is this other note at the bottom, in that bottom part of the table in white there, where it says you do have the option, if you fully convert a unit to 100% natural gas by 2030, that unit is now taken out of the coal category, the 111D, and it's moved into existing steam and gas. So 100% run on, it has to be done by 2030, now can be run beyond 2039. It's no longer under the coal, it's under existing gas. And so you would have to then just comply with, your existing gas rules. So with that backdrop, we are, when I said earlier in my testimony, we're fortunate that we already have had the foresight to have some co-firing in our fleet. So we think, by and large, our retirement dates, with a couple of exceptions that I'll speak to in a minute, in Portfolio 3, Fall Base, those retirement dates that represent that orderly exit out of coal are compliant with the new rule. Now, a couple caveats, and we are going to have witness Ganta coming up later on 111 if there's some real detailed questions on this. But our current plan was not to convert Cliffside 6 to 100% gas until 2036. We would accelerate that full conversion to gas by 2030, such that we could move that out of the coal category. It's already capable of 100% gas, but it's dual fuel right now. So we have both the gas and the coal. We would have to cease coal burning at Cliffside 6 by 2030. And that would then also entail having a firm fuel source in the natural gas, because you've lost your dual fuel capability. So that would take up some of our firm gas in the state. And so that is the one acceleration. We do have Roxborough 2 and 3 that are retiring beyond the 32 date. I believe it's 34.
That's correct.
In our plan, that on the surface, you might say that's beyond what the rule says, but the rule, subject to when the state implementation plan comes out, in my understanding, it's going to take a little more than a year, that has a rule of provision, which is remaining useful life or other factors, where the state can allow a planned retirement to be delayed by a couple of years. If it's in your plan and you're committing to retiring that resource, you have that flexibility. Another flexibility afforded in the rule is statewide averaging. So to the extent your other DFO units run more on gas than the 40%, that average carbon reduction can be applied to those that don't have DFO or don't use their DFO as much. So the reduction can be effectuated through statewide averaging. So we think between the rule of provision and the statewide averaging, subject to not prejudging what the state implementation plan will be, a year or year and a half from now, that our existing coal retirements make sense and are continue to comply with the rule. You will see we ran a number of sensitivities that said, what if we were to firm up the other units that don't currently have 100%? Now, I will remind that, don't think I'm telling this commission anything. Cliffside 6 is our newest. It's the most efficient coal plant in the country, or top 2. 12 years old, can run both right now very efficiently. That made sense. When you start to look at taking 60-year-old plants that are going to be 70 years old, doing an engineering conversion, taking away the coal operation, and then incurring the cost of a firm pipeline reservation that you would need, because again, you would lose dual fuel. You would be 100% subject to gas availability at those units. We ran through each one of those sequentially and deemed those to be uneconomic to move those out of out of coal and into the gas.
So
Only
you
put-
got a little bit ahead of me,
Sorry.
but that's where I want to go. So can your exhibit 2 to your testimony, you discuss the conversion of the units and sort of you all ran that sensitivity as well. And when I say conversion of the units, I mean converting those existing coal-fired facilities to run on gas.
That's correct.
Okay, so just kind of walk us through the entirety of that analysis, because I want to make sure I understand exactly what y'all looked at.
All right, I will do my best, and I'm going to ask Witness Beatty to chime in because he did a lot of excellent work on this as well. So first of all, there's a cost to convert, right? So you've got a cost to take the boiler and convert it from its capabilities today to be able to run on natural gas. So we include those costs in the analysis. We then also, as I just spoke about earlier, we include the fact that you wouldn't want to do this without firm gas supply because of the critical nature of these units. And right now they enjoy the dual fuel for fuel surety. You would lose that fuel surety. So we then ascribed the appropriate inter and intrastate cost adders to those conversions. And you'll see in the notes on page 4 of Exhibit 2, where we walk through, those conversions are sort of that bottom supplemental portfolio analysis where we do the conversions. We also then restricted the amount of gas that was available for the rest of the fleet. In other words, we didn't assume that there was an unlimited amount of inter and intrastate pipeline into the state, that there are limits at, given challenges there, we think you can get new pipeline, but it's not unlimited new pipeline. And so rather than just as a conservative measure, I would say, we said, well, what if we can't get the pipeline? Let's take that away from what we assumed is available for our normal portfolio, which then restricts how much is available for new gas assets. And when you do all of that in collective and run that analysis, it turned out to not even, it was not a cost effective. And, that's a modeling exercise. I would also say you could ask the operational panel how they might feel about having 70-year-old coal plants on newly converted boilers as a reliability asset 10 years from now when these units are 60 or 70 years old. So, this is just from a modeling. I do think there's probably things that are difficult to quantify in the model, but it didn't pass to them anyway because we show that is not an economic. So that was the analysis that was done on the bottom part of that table.
Okay, so I'm gonna ask you about that analysis just so I can make sure I've got the details right. So you looked at all of the coal-fired units, even those that you've already converted to fire some percentage of natural gas. And you looked at taking all of those units to 100% natural gas fired.
That is correct.
Okay. And then you assumed the cost, you had to factor in the cost, the capital investment you'd have to make to get those units ready to fire at 100%. And then you had to make some assumptions as well about gas supply that would be available to burn. And from what I'm hearing you say, those assumptions included getting gas to the converted coal-fired units and taking gas away from your existing gas fleet because there is not an infinite supply of gas.
It'd be the new gas fleet, not the existing gas fleet.
Okay.
Yeah. It would
Okay.
restrict,
Thank you for, okay. Thank you.
restrict how
Okay.
much new gas.
And then what did you assume about transportation of gas to the converted coal units?
That's where we came up with estimates from our fuels team on what the intrastate cost. I mean, a lot of them have pipeline there. On some of them, they already have pipeline. Others would need pipeline, like at Mayo. So there's a cost for intrastate, and then we assumed that you would want interstate firm because you don't have a fuel backup there. So we looked at the inter and intrastate cost of gas to these units and said, if we're going to make them gas, they would need to burden those costs. So that was part of the analysis.
Okay. And what, so you looked at, is it fair to say you looked at firm transportation to these units? Okay.
Yeah, absolutely. From a reliability point
Okay.
of view, when you don't have a backup fuel, there is, you would absolutely need firm.
Okay.
fuel.
And then just so I know, you talk about 100% natural gas fired units, 50% gas fired units. What does that mean exactly? Does that mean 50% of the rated capacity?
Yeah, that's the max, 50% of the max capacity. So if I have a 800 megawatt unit, at 50%, I can run 400 on natural gas.
Okay. And again, I know y'all are the modelers, but just help me understand. So when it's running at 50% natural gas, it also isn't running at 50% coal, is it?
It can.
Oh, it can.
It
Okay.
can blend.
Okay.
Yes,
All right. All of your units that are dual fuel can blend?
can blend.
Okay. Okay. Let's see. Okay, so you ran the sensitivity analysis and you conclude, and I'm sort of, you conclude that it's just uneconomic to undertake this conversion. And I'm looking at page 8 of your exhibit 2, where you kind of go through the narrative of the exercise that you went through in your conclusions. But then you actually have some, where is it in your, here it is, the PVRRs.
Are you looking at?
Page 14 now.
Yes.
So do these numbers support your conclusion that it's uneconomic?
Yes.
Okay. And just help me, I guess, walk me through the uneconomic conclusion. Why do these numbers support your conclusion that it's uneconomic?
Go ahead, Mr. Brady.
So if you look at the third line down, your CAA rule 36 base, we ran all these conversion cases off of a 36 base. So if you compare the PVRR there of $152.1 billion, and you'll see that in the far right column, you'll see that all the supplemental planning portfolios that convert them to 100% gas, they're all more expensive than that 152.1 billion.
Okay, thank you. And tell me again one more time why you have the 2036 base.
I'll maybe take that one. So we did, and it takes us back now to in the Clean Air Act sensitivity analysis in 111. You no longer can meet, we walk through the phases here, but because you now also, in addition to looking at the coal, you restrict, as you heard, your new gas to 40% capacity factor. And this is your new low carbon gas, right? So what we did is we started by saying, now with those restrictions on my new gas combined cycles, can I still meet the interim target? And we looked at it both from, if I re-optimize, if I don't re-optimize, and there was no path to 2035 anymore, because you're taking carbon that was going to be low carbon and you're displacing it by having to run either existing gas or existing coal, where you would have liked to have run those units higher. So 2035 is no longer attainable at our availability limits of resources that we have in P3 fall base. So then we looked at alternate compliance states under alternate scenarios, a 36, a 37, and even a 38. And that was alluded to in my earlier testimony exchange we had about testing a couple of different parameters within those sensitivities. And, we just looked at this and said 36 would probably give you the highest chance of being cost effective if it was to be converted. It was not. And as I said, I want to stress that this is just a model run, and you really would have to think long and hard, even if the model said it was a couple $100 million cheaper, is in reality at execution, are you comfortable running a 75-year-old unit, or 70-year-old unit only on natural gas during, a winter peak event? And I think that's a question for maybe the operations panel, but as I said, we didn't show any of them being economic. And so we did the 36. We recommend in this that 37 is a more measured pace under Clean Air 111. And it allows them, you wouldn't need every single resource availability at its max limits the way you do in 2036. And it gives you some flexibility and timing on some of your long lead time in the way that 36 doesn't. And so we showed some of those additional analysis. We also ran an additional single stress against, okay, now I have a 40% limit. What if I stress the capital cost of natural gas and move those up 25%? Does it still select them with the double restriction now on operations and a higher capital? And it still did select the gas units that are in our NTAP. So we just wanted to check and verify that does the new rule under different assumptions still justify both coal retirement dates as well as the resources that we're requesting for relief for in our near-term action plan. And what we accomplish through that is that we confirm that it does, and it shows some of the trade-offs of those compliance dates.
Okay. All right. Thank you, Mr. Snyder and Mr. Beatty. I don't have anything further.
So, Mr. Snyder, I want to clear up the record just to make sure it's completely clear about your answers, discussion with Mr. Neal. And can you confirm that after that discussion and your answers, that there is not a significant difference between the generic cost assumptions that Duke used and what is projected by NREL's 2024 ATB study? That's our understanding of what your testimony is, and we wanted to make sure that that is clear.
To be clear, they're conservative. I think Mr. Neal talked about they have a conservative, a moderate, and aggressive, and it brings us within the range of inside of their conservative assumptions, notwithstanding, and again, other differences that Witness Meeks spoke about, which NREL may have a different configuration, or there's other reasons why NREL, which traditionally is one of the lowest price forecasts out there, may be different than ours, but we were just clarifying NREL to ours without, and I'm not speaking to Witness Meeks's differences.
Okay, thank you. And then my last question is related to what I asked Ms. Bowman, and when you were on the panel as well. It's about the interim, the stipulation and the interim target date. And the stipulation states that it's no longer reasonable or executable to require future resource plan updates to consider pathways to achieve the interim target by 2030. And can you explain if it is burdensome or overly burdensome, and if so, why it would be overly burdensome to continue to model the 2030 interim target?
Yeah, I do think it is, as I said, I think there's a lot of requests for analysis in this proceeding that become additive. I have real concerns with now talking about developing some supply stack for a variety of demand side resources and planning, for example, our DEE DSM process that we have in place today. That in and of itself would greatly complicate our modeling. And, we get requests for scenarios and portfolios under different high fuel prices and high capital and different configurations. And at some point, there's just a limit to the amount of analysis that provides useful information to this commission. And, to continue to debate the executability of, X thousands of megawatts by 2030 of this resource versus this. And, it takes a lot of analysis. It takes a lot of testimony writing, takes a lot of discovery. It's not just the time in this hearing room. We answered over 5,000 individual questions in these binders behind me. And a lot of those questions are around inexecutable in plans that we spend a lot of time diverted from the true execution of this plan and more executable plans answering those questions and providing that analysis. And then writing testimony and rebuttal and then having it in front of this commission. So the cumulative impact of all of these additions is what continues to lead, I was naively thinking after that first carbon plan, we're going to shorten this to a week proceeding and maybe 1,000 data requests. And I was naively wrong. And so I just think we need to look for ways to make our analysis more useful to this commission in a way that is not overly burdensome for all parties involved.
Okay, thank you. That's all the questions I have. Commissioner Hughes.
Yes, thank you. I'm going to be referring to a couple of sections of your rebuttal testimony. I guess the first one would be on page 26, where it's a nice summary of the public staff's modeling versus Duke's modeling.
I'm there, Commissioner Hughes.
So, and were you, I don't think you were in the room, but did you have a chance to hear some of my conversations with Mr. Thomas about modeling, particularly behind the meter modeling?
Yes, I was watching that, Commissioner.
Is it as exciting on TV as it is in person?
I was afraid we were going to break the internet.
All right. No, so just to get some clarification, it seems like looking at this table and some of the discussions that was, whether it's a major impact is a different thing, but just from a modeling standpoint, the mechanics of modeling, that was probably the biggest difference, or one of the bigger differences of having this as a supply side selectable resource, and specifically behind the meter solar paired with storage. Is that understanding? I know there's a lot of difference in assumptions and things and scenarios, but
yeah, and I think people were getting close to being, but just to be clear, selectable. So there's a difference. Everything that's,
I meant to say selectable. I'm sorry.
Yeah, no, that's all
I know
right.
the difference.
But selectable versus can it be dispatched versus is it a load modifier, right? Those are the three. I just want to be clear on the record that we have load modifiers. Those are the energy efficiency type programs that change the load that we have to serve. Anything that the utility has control over, it's not a load modifier. So I just want to be clear. I thought there was some confusion as to, we forecast through our EE-DSM collaborative, and there's an entire separate docket that is trying to come up with what is the achievable levels of EE and DSM and customer sided programs that are appropriate for inclusion in an IRP. Once that's determined, those become like supply side resources in the model, because the model is controlling them and dispatching them at the production cost modeling phase. It's not picking the levels at system optimization, which is the selectable resource. So load modifier versus a supply side resource that gets modeled like DSM. And then there's this other term, selectable, which means I'm going to go pick the quantity and timing in my IRP model instead of this docket. That's the delineation that we have difference, and I have a strong difference of opinion with anyone wanting to change that historic precedent.
Well, I appreciate that clarity. That was my understanding, and I'm glad you saved me a question there. And I'll use the word selectable. I meant to so the difference is that they're behind the model solar was a selectable resource, and as opposed to modifying the load. I understand that.
Yes.
You brought up something I wanted to talk a little bit about, and I think if you go down into, I think page 48 and 49, I think you talk about, and maybe it's what you just referred to, some of your strong feelings about this issue there. And you mentioned there's a quote here about Duke's historic. It has been the company's long-standing position. This is on the top of page 49. It has been the company's long-standing position regarding modeling EE and demand response that these valuable grid edge resources should be modeled as a load modifier. So that's what we were just talking about. But then you also, you mentioned, and I think we can talk to Mr. Duff a little bit about this as well, but there's these different grid edge technologies or programs, whatever you want to say. You have everything from the MyHer EE behavioral program, which I think it's by far the largest EE program that Duke offers. I mean, I think it's on the residential side. I think it's 70% of the savings that are modeled are just from that one behavioral program. So you have that program, which you are making, and we've talked a lot about that, making assumptions, and that's in the load modifier. Then you have these DSM programs, which, and then you have pricing programs. You have all these different programs for modifying demand. And then we have this relatively new program of behind the meter solar plus storage, which I'm curious about your view, but from my view, it's somewhat of a hybrid of these. In some respects, it relies on customer uptake, but some have argued that Duke could play more of a role and would have a little bit more confidence in the outputs of those programs than, say, a pure behavioral program that you were relying on people to turn their thermostat down manually. But when you say it's been your longstanding view that these programs are load modifiers, that's the kind of a wide range of some different types of programs, everything from pure behavioral to more traditional DSM to this new potential promising, we don't know, group of behind the meter kind of storage, dispatchable, because I think under the pilot project, you use the word as that being a big, something that distinguishes these. Would you agree that certainly the behind the meter storage power saver is more dispatchable than the MyHer EE program?
Yeah, just reiterating on Mr. Duff's, I would agree with you, Commissioner Hughes, and recognizing there's two cohorts, as I understand it. There's the battery with a time of use rate where it's not dispatchable, and you are counting on the customer to economically respond to time of use rates. Yeah. And then there's the other cohort where the utility has control of that behind the meter battery, but certainly different, and as I said, in that respect, anything that would be dispatchable, I want to make clear, is not a load modifier as much as it is a resource that we estimate what's the maximum achievable potential that we can get with cost-effective incentives coming out of the EE-DSM collaborative and the docket. We have, a huge process in place that determines what is and isn't cost-effective, and that's the forum where that happens. Now, what's being suggested is let's somehow make the IRP the forum to determine what's economic, achievable, and cost effective. And then let's break that into some supply curve that is a pretty big academic exercise, and then let the model select within that supply curve. So now you either need to totally dismantle the EE-DSM docket and mechanism and reconfigure it under IRP, or you're going to live with a conflict, because who's picking what's the maximum achievable? So that's my issue with this too, is how do I determine?
Yeah. Well, and I appreciate that. And I do think that, back to my question, it seems we talked about, and certainly your DSM and EE team is involved with the power pair, but it's a hybrid. It doesn't fit. There's an element of it that I think is covered by our mechanism, because if the customer goes ahead and adopts the option to give Duke control of the dispatch, then I think there's a section that goes into the traditional EE program. But a lot of this program is new. It's outside of the traditional EE program. So I understand I just want to say you're lumping them all together, and I think some of the interveners have lumped them together. From my understanding, let's just talk about the behind the meter solar part, and that's both power pair, and then some of the some of the larger scale ones that are not part of power pair, but it could be a commercial, institutional, everything from a department store to others. Those types of dispatchable programs behind the meter there, that's the type of program that the public staff modeled as a selectable resource. From what I understand, they didn't model the MyHer program as a selectable resource. Is that your understanding?
Yeah, and it's my understanding it was the power pair was their attempted application, not to, that's how they approached it.
Yeah. Yeah. Well, I just want to make sure I understand the same thing, because I understand, I understand some of the arguments you've had about the behavioral programs, but this one, and particularly since I think in the early, if I understand, one of the witnesses said that it's early on, but the folks have been a lot more interested in giving you over dispatchability. I mean, I heard a really high percentage. I'm looking forward to hearing more about that, but I think someone said almost everybody's signing up for that program.
It's probably where the more lucrative incentives are.
Yeah, I think it's $450 a year. So part of my question, and I asked Mr. Thomas this, was where, if you were serious about modeling this moving forward, where that ongoing cost, where you would put that, because that is a cost to both Duke and other customers if you're paying these. So I was just that was a question that Mr. Thomas, I think, was going to look into. But with all of this said, I see the settlement discusses some intent of looking into this program, maybe accelerating the analysis of power pair. It didn't seem to come to a conclusion one way or another about, thou shalt model power pair as a selectable, or thou shalt not. And when I asked Mr. Thomas about this, he seemed to agree that that was not part of the stipulation. And he even suggested that if it was the interest of the commissioners to learn more about how these programs, could interact, that we could go ahead and ask for that kind of modeling moving forward. And that wouldn't necessarily, quote, break the spirit of the stipulation. Do you agree with that? That was not, I mean, I didn't see any language at all in the stipulation that dealt with any kind of modeling aspect of power pair.
How we, how we model power pair was not part of the stipulation. It would not break the stipulation. I contend it might break the model.
Well, and again, I understand all the variations, you could do, and I appreciate, I appreciate, kid and candy store. We want as many toys as you can give us. But realizing each toy takes a lot to build. So I understand that, but public staff was able to do it. And I understand your concerns about how they did it, but they were able to do it. And they said they had to make some limited assumptions. But I just wanted to first hear your interpretation of what the stipulation said about this, and also it seems like you're agreeing with me that power pair, if you're talking about just purely modeling power pair, some of the concerns that Duke has, not all of them, about modeling some of the pure behavioral programs might not be as strong, from modeling power pair, which could have a highly dispatchable nature. Is that?
Yeah, I just don't, well, it is dispatchable. So is many of our DSM programs, right? We have load control on heating and cooling devices and water heating, and we have commercial interruptible programs, and we don't attempt for any of these dispatchable resources to somehow let the IRP model pick how many customers are going to participate at what incentive level, and then let the model, we do that outside, and we say EE and DSM group, even though it's dispatchable and it's a supply side resource in our model, you tell us what's a reasonably achievable, because I really, what didn't come up in that is if we get those supply curves wrong and customers just don't participate or they drop, then we're short. I mean, we have 2,600 megawatts already of grid edge resources in our plan. That's 2 large power plants of growth in the plant. I am really counting on Mr. Duff's group to deliver those, or I'm 2 power plants short. And so letting the model say, then I'm going to pick more, you better be really confident in whatever academic demand curve you come up with, because this isn't a theoretic academic. These are reliability resources. And if they're not there, and we thought they were there, it takes 5 or 6 years to build the power plant to make up for them. So we don't know retention rates yet. What we saw in my experience in Florida back in the 90s was you had half your people drop off of certain programs when you used them day after day. Right.
And I appreciate all of that. Just to be clear, that 4,000 number, I was trying to find that in your testimony. Is that 2050?
The 2,600 number is in figure 2 of our rebuttal testimony.
Okay, that's 26, but where's the 4? And that's 2038. If we're talking about 2033, and from what I understand, I don't think we don't know what behind the meter batteries are going to look like in 2050. But if we're talking about 2023, it's I think what's in your model is a more modest amount, and it's largely things that have been verified with years of M&E. So I'd be worried about
I have 2,000 by 33 in that figure.
Yeah, and the 4,000 was a total number. It includes existing. And if you go up for 1 page on the testimony, that's where the 4,000 number is from.
This is just growth.
Okay, so of this, the power pair would fall under the net energy metering 46. Is that?
The net energy metering comes out of the load. We do not have, I think many interveners have asked, we don't have behind the meter batteries. I would contend as they grow, we could certainly add a forecast of those.
Okay.
It's just projecting it to select how many customers are going to install Tesla Powerwalls at this stage of that technology's development. Seems like a tall task for an IRP model to handle.
Well, I think that fair enough, but it seems like the public staff in the short term, in the 5 to 6 year range, was fairly modest in their selection. From what Mr. Thomas said, we're not talking about a power, we're not talking about a CT's worth of power pair installations. I think we're
Right.
talking 60 to 150, 200 maybe, if I got my numbers right.
Right. No, that's another good reason not to hit, because a 30 megawatt is really tough for a model to select. It's almost in the noise of a 35,000 megawatt system to pick a 30 megawatt resource. And I just think I support what they did in their modeling, public staff, from the standpoint of let's try and see how much growth in this program we can achieve. And certainly let's hold promise for it. My difference is we should do that in the forecasted in the DSM, and let the DSM team tell us, here's the amount of customers that we think are actually going to install and participate. And they go through a very disciplined process of going from technical potential to economic to achievable. And then they have an M&V process on the back end to ensure, that's measurement and verification process on the back end to ensure they get it. With all of that infrastructure in place, they then say, here's what goes into your IRP model. You don't start with the IRP model that says, I have a hypothetical supply stack that I've academically created that is going to assume at different price levels I can get 100,000, 200, 300, 400,000 customers on, and model, you tell me how many I should go get. That to me is you're getting into an area that is going to complicate this proceeding and not streamline it.
Thank you for the color, and I think that a lot of what you've said is well said in your rebuttal as well. But I do think that you've answered the question about it's not included in the stipulation, and that it's possible, and whether you should do it is another question. But public staff could do it, and if we asked you, could you do it?
I can't say that it wouldn't break our model because the way they did it was very simplified.
Could you
If-
do it in a simplified way like
If
they
we did it in a very simplified, could we do it? If they did, it, I'm sure we could work with them and take their learnings and do it in the same simplified. I'm sure we could. I don't
All
think it
right, I
would stay
appreciate it.
simplified.
I appreciate that. Thank you.
Okay, that comes to the end of commission questions. We have a slight change in schedule. We're going to take our lunch break at 12:50 rather than 1 o'clock. So we'll start with questions on commission questions for the next 10 minutes. Okay, Mr. Moore.
Yes, thank you. Tyrrell Moore with the Attorney General's office. You had a discussion with Chair Mitchell about your response to AGO Witness Burgess's statement that the companies did not increase the availability of CTs and batteries. Do you recall that?
Yes.
And I believe in your answer to Chair Mitchell, you were discussing the P1 fall base portfolio. Is that right?
Yes.
And I think Mr. Beatty, you disagreed with Mr. Burgess's statement that the companies did not increase the availability of CTs and batteries in that portfolio.
Yes, and P1 fall base, we did increase the availability compared to P3 fall base. That was my statement.
Okay, so I believe Witness Burgess was referring to the P1 portfolio, not the P1 fall portfolio. Would that change your answer?
You're talking about the initial filing?
Correct.
We did not change the battery assumption in the initial filing. I focus on the supplemental filing. That's what because it's the latest filing with the most updated load forecast and the most relevant information.
Okay. Do you have the supplemental planning analysis in front of you?
We do.
You turn to page 28, table SPA 211.
I'm there.
And this shows the initial plan assumptions and the supplemental planning analysis assumptions. Correct?
This is the base supplemental planning
Yep.
assumptions.
CT numbers are the same in both of those.
Yes.
Yes.
Standalone battery assumptions go from 4,400 megawatts in 2027 to 200 megawatts in 2027, correct?
Yes.
You would agree that's a lower number?
The question was about a comparison to P1 fall base versus P3 fall base.
All right. No further questions.
To be clear, those were P3. Those weren't P1.
Additional questions? Duke?
I think you gentlemen cleaned this up very well, but to the question that Mr. Moore was just asking in response to Chair Mitchell's questions, the technical appendix addresses the P1 fall base assumptions, correct?
Yes.
And subject to check, you'll allow me to get back there. You go to the bottom of page 8 onto page 9, it very clearly states how the resources were accelerated from all resources available to the model by 2035 for purposes of modeling P1 fall base. Does that sound right?
Yes.
All right. No further questions. Thank you.
Okay, so that takes us to the end of, Ms. Grudman, did you have a question? Okay. The end of commission questions. I'll take motions.
Thank you. We'd ask that the panel's exhibits pre-filed be entered in the record, which is exhibits 1, 2, and 3.
Seeing no objection, your motion is allowed. Mr. Neal?
Thank you. At this time, SACE et al. Would move into the record. SACE et al. Cross IRP, NTAP, rebuttal, confidential exhibit 1, and SACE et al. Cross IRP, NTAP, rebuttal, exhibit 2.
Okay. Seeing no objection, your motion is allowed. Ms. Grudman?
At this time, Walmart would move for admission of Walmart Cross IRP and NTAP panel rebuttal exhibit 1.
Okay. Seeing no objection, your motion is allowed. Duke, does Mr. Snyder or Mr. Beatty have any additional testimony? Are they on any additional panels?
Not in this case.
Okay.
They may be back they will be back next week.
So thank you for your testimony, and you may step down and be excused. We are close enough to our lunch break, so we'll go ahead and take it now. We'll come back at 1:30, and Duke can call its next panel at that time. On the record, and before we get started, we have another minor change in the schedule that I think will be people will be happy about. We're going to end at 5 o'clock today rather than 5:30. So slight change. With that, Mr. Drack, you may call your witnesses, or Ms. Finley.
Thank you. Duke Energy calls the Resource Adequacy Study Panel back to the stand.
Okay. And I'll remind you that you have already been sworn in and you remain under oath.
Mr. Wintermantle, are you the same Resource Adequacy and Study Panel that appeared earlier in this proceeding as part of the company's direct case?
Yes.
And Mr. Wintermantle, did the panel cause to be pre-filed in this docket rebuttal testimony consisting of 30 pages and 4 rebuttal exhibits?
Yes.
Do you have any changes or corrections to your rebuttal testimony at this time?
No, I do not.
If I were to ask you the same questions today that appear in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
And your rebuttal testimony or exhibits do not contain any confidential information, correct?
That's correct.
And did you also prepare and cause to be pre-filed a summary of the panel's rebuttal testimony?
Yes.
Okay. Presiding Commissioner Kimwright, I would ask that this panel's rebuttal testimony and rebuttal testimony summary be entered into the record as if given orally from the stand.
Seeing no objection, the panel's, seeing no objection, the panel's testimony and summary of its testimony will be entered into the record as if given orally from the stand.
And I also ask that this panel's 4 rebuttal exhibits be pre-marked for identification to be entered into the record at the appropriate time. Okay.
And seeing no objection, the 4 exhibits attached to the rebuttal testimony shall be marked as identified.
The Resource Adequacy Study Panel is now available for questions from the parties and the commission on their rebuttal testimony.
By my notes, it looks like Ms. Kress, SIGFR is first.
SIGFR has no questions for this panel. Thank you.
Mr. Smith with EDF.
Thank you. I think I just have one question. It's something we talked about during the direct testimony for this panel, and I just want to make sure I have it nailed down, because you do speak about it a little bit on page 27, your rebuttal testimony, beginning of line 1, if you want to turn to it.
Okay, I'm there.
Okay. I'm going to try to ask this as precisely as possible. Within the preferred portfolio, is there a non-emitting generation resource currently commercially available with higher marginal winter wind ELCC value than offshore wind?
Yeah, I'm just not sure. I think that was probably a better question for the modeling panel. We created the LCCs, but as far as understanding every resource that was analyzed in that plan, I'm just not sure I can answer that. I can answer what the ELCC of an offshore wind offshore wind resource is.
Sure. Can you give the the marginal winter wind ELCC value?
Yes. So just based on my rebuttal testimony, page 27, the onshore marginal wind ELCCs ranged in 20 to 45%. The offshore ranged in the 60 to 75%.
And offhand, and I know it wasn't referenced right there, but do you know if offshore wind is higher or lower than utility scale solar on that note?
Yeah, I mean, definitely relative to the solar, offshore wind has a higher ELCC.
No further questions.
Mr. Neal, SACE is next.
Thank you. David Neal, for SACE et al. Good afternoon.
Good afternoon.
In your rebuttal testimony, you addressed some but not all of the issues raised by SACE et al. And NCEMC witness Jim Wilson with regard to his review of the Astrape 2023 Resource Adequacy Study, correct?
I mean, I believe we addressed most of what we saw in his direct testimony. I can't say for certain that we addressed every point.
And do you have a copy of his report in front of you?
I do not.
May I approach?
Yes, you may.
So I've handed you a copy of his report, and at the bottom of page 41, in paragraph 55, there's, I think it's at the second sentence, you see where he wrote, relating to the Astrapi 2023 resource adequacy study. The approach entails estimating through regression the amount by which incremental cold apparently increases load. The results of the regressions, expressed in megawatts per degree, are then used to extrapolate load levels to the very low, and then turning the page to temperatures found in the 43-year history. The extreme loads resulting from these regressions account for nearly all of the load loss in the simulations and drive the reserve margins higher than they would be otherwise. Do you remember that part of his report?
I'm recollecting now. I see it.
And would you agree that under Astrapi's methodology, the lowest winter temperatures from that 43-year history are associated with a significant amount of the load loss in your simulations?
I would agree, as part of any LOLE study, if you're looking at 40 weather years, the LOLE is going to be seen in the extreme winter events for the companies. So yeah, it would not be in all 40 weather years, because lots of weather years in that analysis are mild. Certainly the extreme winter periods are what we're trying to analyze to understand the risk. And so, yeah, probably in the top 5 to 10 weather years of extreme cold weather is where we'll see the LOLE.
And in your rebuttal testimony, starting at page 11, line 8, you were asked the following question. Are you there? Did the resource adequacy study overstate the likely frequency of extreme cold temperatures by using historical temperature data back to 1980 weighted equally? Do you see that question?
I do.
Now, do you understand that Mr. Wilson's criticism had nothing to do with the frequency of extreme cold, but the magnitude of extreme particular cold weather events in the early to mid 1980s that have not been experienced in the Carolinas since?
Yeah, my understanding is that he does not believe that we should include some of those cold weather events in the 1980s.
But you understand that the question asked about the frequency of events. So that would indicate like how often we have extreme cold events. And you understand that the magnitude of that extreme cold is a different issue than the frequency by which extreme cold is experienced.
I understand the magnitude is a different issue, but if I were to remove the 1985 weather year as if it did not occur, that also changes the frequency of my whole analysis, because now I'm removing the worst weather year we've seen in 43 years out of my analysis. And so it's going to affect the frequency of events that we're modeling in our simulations. So it's twofold. I agree.
And in response to that same question at lines 11 to 12, you testified, Astrapi does not believe it is prudent to remove extreme weather years, as you just stated, when modeling the potential risk that the companies might face in the future. Now, at any point in his report, did Witness Wilson recommend removing extreme weather years?
I would need to go confirm again, Mr. Benson. I'm not sure if you've got at the place where we believe that, but I did feel like I heard yesterday in his testimony, and I could be incorrect, that he had a problem with us modeling the early 1980s. But if he doesn't, then that's okay. That's great.
Well, you heard his response to commission questions yesterday?
I was listening. I wasn't in the room, so I heard some of that exchange.
Well, the testimony will speak for itself, but do you recall that he said there were two different approaches? One is to remove those years, and the other is to adjust them based on trends we've seen in climate?
Yes, I did hear
that. Do you recall that his approach is to adjust them based on climate, not to remove them?
Okay, I missed that, but if that is the case, then I work more in line with that we shouldn't remove the early 1980s. As far as the trending goes, if we went back to the 2020 study, we actually did exactly that. And so if we go look at NOAA data over the last, well, they actually report it, and I think the most recent data says temperatures over the last 40 years have moved up by about 0.3 degrees per decade. So if I want to rescale 1980 temperature to today, I can take that 0.3 degrees per decade, multiply times 4 decades. It's roughly a 1.2 degrees, 1.3 degrees that we would move that up. And we tested for that in the 2020 study. The ultimate reserve margin results moved by 0.25%. So it was essentially, because we're moving those temperatures so slightly up, just really did not have a material impact. So we didn't do that again for this study, because also we're assuming that that trend is going to continue. And we also know, as kind of stated in my rebuttal, EPRI has kind of come out clearly that the frequency of these events are actually occurring more often. So we're very hesitant to start playing with the data. We like to use the historical data as it has come, with the idea that, hey, 1985, there's nothing we can say here and sit here today that 1985 won't occur again. If we look at the Texas event in 2021, they had not seen those temperatures in 2021 since 1988. So this is kind of the whole reason we like to keep all the weather in, try to capture the frequency as it's occurred, understand the trends in temperatures, but we did look at that last time. It just didn't have a material impact.
And you recall that Witness Wilson noted that that trend per decade, he had a higher figure than 0.3 degrees per decade. I think he said that there have been observed trends. It's more like a degree per decade.
Yeah, I was puzzled by what he said, and Mr. Benson may have more here, but I feel like he was saying, well, Mr. Benson.
Yeah, I believe he said yesterday that it was 1 degree every 5 to 6 to 7 years, but in his testimony, he said 1 degree per decade. So we're unclear which one it was.
Assuming his pre-filed report is what he intended to say, you at least acknowledge that he had a different perspective on the amount that adjustment would be. Whether you agree with it or not.
Yeah, definitely the case. For the record, we're looking at the NOAA reported surface temperatures when we quote the 0.3 degree per decade.
And I'd also add that he only included the trend for the Charlotte airport, and we modeled other weather stations in the company's territory.
Yes, and do you recall that he used that as an example because that was a heavily weighted region in your study?
Yes.
All right. So later in that same response on page 11 of your rebuttal at lines 14 through 15, and you've alluded to this already, the weather pattern seen in 1985 can happen again, and Astrape assigned it a 1 in 43 probability of occurrence. Do you see that?
Yes.
And again, as climate change continues over the coming years with a general warming pattern, you at least understand the concerns with how equally weighting each year discounts that trend. Again, putting aside frequency, but in the most extreme cold temperatures that are actually observed in more recent years.
Yeah, I'm not a climatologist. We've looked at the trending recommendations by lots of parties. We do this all over the country, and so we see that. We've seen that be a small impact in increasing the temperature for the lower years. And so, yeah, while we recognize that, I'm not a climatologist. I think we've always moved forward with, let's just look at it based on the historical data. We do know reports, as I've already stated, testified to, EPRI has come out and said these events are happening more frequent. So that's part of also the climate change. So it's not just temperatures rising, it's also more frequent events. So it's a difficult thing to get your hands around. But I think we have thought about it a lot, looked at it a lot, and are firmly standing on what we did in this study.
So this time I'd like to mark one exhibit. Turning your attention, my colleague will be handing you a binder, or maybe you can go ahead and get to exhibit 71. So this is SACE et al. Potential cross exhibit 71. We would ask to be marked SACE et al. Cross resource adequacy rebuttal exhibit 1.
It will be so marked.
So turning your attention to the exhibit of annual minimum of daily minimum temperatures for the region shown, This is information from ClimeDex, a database of global observed climate extremes derived from daily temperature data compiled by the University of New South Wales in Sydney. Did you see that according to this data set, the extreme cold from 1985 has not been observed in this region at any other time over the past 120 years?
That's what this chart suggests. Just kind of looking at it. So this is, I can ask a question. The chart on the top, the figure on the top is based on the marked off area at the bottom of the page. Is that?
Yeah, it was just an available online database of climate data that allowed you to select by region. So it's that Southeast region.
Yeah, I mean, 1985 looks like it was the coldest date and temperature. I mean, coldest temperature in the last 100 years.
Or 120 years.
Fair, 120 years, but that does not in any way convince me that it can't happen again. We've also looked at kind of the distribution that we've done over the last 40 years. We didn't do it as part of this study, but we've worked with this company for many years, and we've been thinking about this 40-year issue. We've looked at the distribution of the Carolina weather over 100 years. Because some say, hey, we should go further back, right? We need to have more and more data. And that's usually where we stand. We want more and more data. But the hourly temperatures in NOAA actually kind of clean up from a data processing standpoint from 1984. So that's kind of where we are. But as part of that discussion, we looked at, if we basically take the distribution over the 120 year here on this chart, and we compare it to what the last 40 years looks like, it actually resembles it pretty well, which gave us even more comfort that our 40-year window was okay. Understood point about slight increases in temperature over time.
But it was your testimony that you view the 1985 extreme cold as a 1 in 43 occurrence, correct?
That's correct. And as I said, the overall distribution is what matters. And if I'm comparing some of these weather stations in the Carolinas versus 100 years, the last 100 years versus the last 40 years, those distributions actually look pretty close. I know you're pinpointing on this most extreme temperature. I can't get around that. That's the most extreme temperature, but there's no reason for me to pull that out of the study. And 1 in 43 is still very small. I still think it's reasonable.
No further questions.
Thank you, Presiding Commissioner Kimmerite. Following up very briefly on the questions that Mr. Neal asked, just going back to the exhibit that he marked, I just guess I want to make sure that I understand. When you talk about the distribution over 43 years versus the distribution over 120 years, you're talking about taking each weather year and plotting it out and then kind of figuring out, do they look about the same when you look at a 43-year versus a 120-year period? Is that right?
Yeah, and I'm trying to recall the analysis. I think it was close to 100 years. But yeah, we're looking at the distribution of kind of temperature thresholds. How many times did we get below 15 degrees Fahrenheit, 10 degrees Fahrenheit, et cetera? And that those distributions were not incredibly different enough to give us heartburn about the 40-year period we're modeling.
But you do agree that an extreme weather outlier like 1985 would be weighted more heavily in a 1 in 43 equal probability as opposed to a 1 in 100 probability.
The math works out to, yeah, that 1 in 43 would be weighted slightly higher than 1 in 100.
Were you listening? I want to say it's yesterday, but I think it was another day this week. But were you listening when Public Staff Witness Thomas was testifying?
I heard some of his testimony. I did not hear it all.
It was in the record will obviously reflect more accurately, but I'll do my best to summarize what I believe that I heard.
Okay.
But it was in the context of the 2.5 percentage point increase in the reserve margin related to outages. And my recollection is that Public Staff Witness Thomas indicated that outages are going to occur no matter what. Do you recall that testimony?
Vaguely, but yeah, I mean, I agree with him that outages throughout the year on a electric system will occur. Yes.
And I agree with you as well.
Yeah.
But if we just look at the 17% reserve margin that's currently in effect, based on the study that you all performed for the prior CPIRP, would you agree that embedded in the calculation of that number is also generator outage information and generator outage performance?
Yes.
Turning to, so following up on that point. So even if the commission were to, for example, assume that generator outage performance would improve with all of the changes made after Winter Storm Elliott, and say only increase the reserve margin to about 20%, embedded in that number would still be some assumptions that there would be outages. You agree with that, correct?
Well, just to clarify, I think what you're saying is if we went from 22 to 20%, in that 20% analysis, there would still be forced outages on the system.
Correct.
Yeah, that's correct.
Bear with me 1 second while I find my place. And I think you mentioned also in your testimony, specifically pages, I think it's 6 and 7, you note that public staff, witness Thomas, reflected that even if there were some improvement to the generator outage issue, there still would be the increase in the reserve margin to 20%, right above 20%, correct?
I note that he says that. I don't know what the numbers would be. That's not my testimony.
And did you also, I think you noted on page 5, the question that begins on line 16 going into page 6, line 6, you note the spread of reserve margins that are maintained by different entities throughout the Southeast.
Yes.
And you agree with me that Dominion Energy South Carolina is targeting a 20.1% reserve margin?
Yes.
Thank you. Those are all the questions that I have.
Ms. Finley, redirect from Duke.
Yes, Mr. Wintermantle, I believe you said that you don't agree that the weather event that happened in 1985 could not occur again.
That's correct. I cannot sit here and say that that 1985 temperature will never occur again.
And you also testified that data before 1980 is less reliable, which is why that's kind of the cutoff point. Is that right?
Yeah, I mean, it gets into a modeling issue, but yeah, hourly 8760 data, which is required in the resource adequacy study. We want to study all hours. You start to see holes in the data. Yeah.
And as we move along, so at the next resource adequacy study, we may have 3 or 4 more years of data to rely on, which would make the weight of that 1985 year continue to drop.
Yes, if planning, and I think we would just recommend to maintain as long of the data set as we could. Yeah, the probability, it would change slightly.
And would it be reasonable for planning purposes to ignore or discount historical data showing actual extreme weather temperatures that this region has experienced?
Yeah, I do not think so. Absolutely not. That is really what we're looking for in a resource adequacy study. We want to understand the extreme periods. So to ignore a point just seems to put reliability at risk for customers.
All right, no further questions.
Thank you, Ms. Finley. Now we'll move on to commission questions. Chair Mitchell. Commissioner Duffley.
So I'd like to turn your attention to page 4 and lines 7 through, we'll go through 9. You state, as noted in the resource adequacy study, the increase in reserve margin from 17% to 22% was driven by a reduction in neighbor assistance. Are you aware of the PJM capacity auction the results came out this week?
I am.
How do those auction results play into this statement that I just read?
Yeah, I mean, it was kind of a validation of what we're seeing in our study. Obviously, the capacity prices rose considerably from the last auction. Just shows that there's not this excess glut capacity in the PJM region. And I think that bodes really for all the regions around Duke Energy. I mean, Southern Company is currently looking for several gigawatts in all sorts of, or in some capacity RFP. They're targeting a 26% reserve margin. I think also as part of that PJM, there's a lot of changing dynamics going on in PJM, especially in the modeling world. The main piece of that is they are now seeing the winter LOLE. I think their last study, which really was December of 23, trying to give a little bit of time to that this week and looking at it. I think the winter LOLE might have been 30%, but then I saw some updated analysis this summer that was pushing it all the way to 60 or 70% of their LOLE being in the winter. So they're seeing it. Our study really did kind of project that. So I think the neighbor assistance coming down is justified with exactly what you're seeing, Commissioner Duffley.
Okay, and were you aware that 2 zones cleared just short of their reserve requirement in that auction?
I can't remember exactly which ones, but I believe, yeah, Dominion South hit the cap for capacity pricing.
And are you aware that PJM put out a statement that the significantly higher prices in this auction confirm our concerns that the supply-demand balance is tightening across the RTO?
Yes, I saw that. As part of that, I think it's also coal retirements causing some of that as well.
Yep, and that was going to be the next question. So you anticipated my question. Those are all my questions. Thank you.
Thank you for your testimony. Now we will move to questions on commission questions.
Very briefly.
Okay.
You're aware, following up on Commissioner Duffy's questions about the recent PJM capacity auction, that those results were for the 25-26 delivery year?
Yes.
And the date of your study is 2027, correct?
Date of our study, yes, is based on the 2027 study year.
And the APCO zone did not have any issues with clearing resources despite the higher price?
Subject to check. I do know Dominion South was the one that had the high capacity price that hit the cap. I would have to look.
And you agree, though, that with those prices being signaled for 2 to 3 years in the future, it will send signals to power generators in the PJM region and price signals to them as to what to do with respect to generation moving forward?
It will send signals, but there's certainly a delay in getting new capacity online. I mean, generally 4 to 6 years is to build. I mean, I think solar and battery maybe come in a little bit earlier than that, but yeah, there's definitely a signal now that hopefully they can get ahead. 27 is only 3 years away. That would be kind of the best case, I think, for generation that was being thought of today to go get approved, get contracted, or whatever a developer needs to get done, permitting and get it built. So, I can't sit here and say there's not a concern in 2027.
But it doesn't only send signals to new generators, right? It also sends signals to existing generators who may have planned to retire.
Sure. Yeah, there's flexibility there if they could delay retirement.
Thank you. That's all the questions I have.
Any additional questions?
No questions.
Okay. So I'll take motions.
Should I go first?
You may go.
At this time, Presiding Commissioner Kemmerite, SACE et al. Would move for admission of SACE et al. Cross Resource Adequacy Panel Rebuttal Exhibit 1.
Okay. Seeing no objection, your motion is allowed. Okay. Ms. Bentley.
And thank you. I ask that this panel's 4 rebuttal exhibits be entered into the record.
Okay. Seeing no objection, your motion is allowed. And gentlemen, I don't think you're on any additional panels, so you may step down and be excused.
Thank you.
Thank you. And Mr. Direct, which panel are you going to be calling next?
So I think might have been a slight, we're ready with the grid edge panel. I'm seeing now in the spreadsheet that we had, I think it was on us, had resiliency, reliability, operational first. Would it be okay to move forward with the grid edge panel right now?
Seeing no objection, it is fine to
Just-
switch
just-
the order and have grid edge go
Okay.
first.
Thank you very much. If you'll just give us one moment to get situated, we'll get started.
So gentlemen, you've been sworn in previously, so you remain under oath.
Thank you very much. Mr. Duff, on behalf of the panel, is this the same panel that presented testimony in the company's direct case?
Yes, it is.
And did this panel cause to be pre-filed in this docket rebuttal testimony consisting of 37 pages and one exhibit?
Yes, it did.
Do you have any changes or corrections to your rebuttal testimony or exhibit at this time?
No, not to my knowledge.
If I were to ask you the same questions today that appear in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
And your rebuttal testimony does not contain any confidential information, correct?
No, it does not.
Did you also prepare and cause to be pre-filed a summary of the panel's rebuttal testimony?
Yes.
Presiding Commissioner Kimmerite, I would ask that the panel's rebuttal testimony summary be entered into the record as if given orally from the stand.
Seeing no objection, the panel's rebuttal testimony and summary of the rebuttal testimony shall be entered into the record as if given orally from the stand.
Thank you. I would also ask that this panel's one rebuttal exhibit be pre-marked for identification to be entered into the record at the appropriate time.
Seeing no objection, the one exhibit attached to the rebuttal testimony shall be marked as identified.
Thank you. The Grid Edge and Customer Programs panel is now available for questions from the parties and the commission on their rebuttal.
And let me check, I think we've had some changes with cross-examination. I see that CPIRP and Walmart have cross-examination questions, but it appears to me that NCEMC has waived its cross-examination. Is that correct?
Yes, Justin Smolowski on behalf of NCSEA. That is correct, Commissioner Kimmerich.
Commissioner Kimmerite, Walmart has also waived its cross.
So Ms. Kress with CPIRP, you're up.
Thank you. Good afternoon, gentlemen. You testified on pages 24 and 25 rather, of your rebuttal testimony in response to some testimony offered by CPIRP witness Collins. And I'll give you a second to get there before I continue.
There.
Specifically, you reference witness Collins' testimony regarding recommendations pertaining to the emergency demand response program offered by Southern California Edison. And specifically on page 25, lines 5 through 8, you state the commission order was based, excuse me, on a settlement between DEC and CPIRP. And the work was completed during and after the comprehensive rate design study in advance of DEC's rate case filed in docket number E7 sub 1276. Is that correct?
That's right.
Okay. Would you agree, subject to check, that the comprehensive rate design study included a non-residential working group that had exactly one meeting on demand response programs, and that meeting occurred on September 8th, 2021?
I recall a number of meetings of the non-residential working group as well as breakout sessions. And I recalled more than one conversation I thought about these types of programs.
Mr. Byrd, you were involved in preparing the roadmap that was the work product coming out of the comprehensive rate design study. Is that correct?
I was involved, yes.
And subject to check, would you agree that in that comprehensive rate design study roadmap that you played a part in filing with the commission, it indicates that demand response programs were discussed in the non-residential working group on September 8th, 2021?
Subject to check, yes.
And are you aware that House Bill 951 was enacted into law in October of 2021?
I don't have that date logged in my memory.
Would you agree, subject to check, that House Bill 951 was enacted into law in October 2021?
Subject to check, I'll take your word for that.
And do you have a copy of House Bill 951 in front of you?
I do not.
If I could ask my colleague to put that in front of you. And for the record, Presiding Commissioner Kimmerer, I don't believe anyone has asked yet for the commission to take judicial notice of Session Law 2021-165. So if I could request.
The commission will take judicial notice, and you're correct, it has not been requested yet.
Thank you. It is SIGFER potential exhibit number 43. $43. Gentlemen, do you see in Part 1, subsection 1 of House Bill 951, it instructs the commission, and I'm not going to read all of that, but it instructs the commission to develop a plan no later than December 31st, 2022, with the electric public utilities for the utilities to achieve the authorized reduction goals, which may at a minimum consider, and then it provides a whole bunch of different things for the commission to consider, including demand side management. Is that correct?
You read some of the words on the page. I'm not an attorney, so and I haven't spent a lot of time with HB 951.
So as the customer programs panel, is it your testimony that you don't know whether or not House Bill 951 directs the commission to consider demand side management in the implementation of the carbon plan?
Presiding Commissioner, I'd object to the line of questions. He's not an attorney. He's here to answer any questions on what they've done, the activities they've conducted to date. Obviously, council's asking a lot of questions about what happened in a different proceeding, the comprehensive rate design study, which is questionably relevant to what we're doing here. But I've not objected to that, see if it may lead to something admissible. But I think asking him to provide legal advice or legislative interpretation and characterizing the question the way she did, I would object to the form of the question.
Respectfully,
Ms.
if I
Cressy, you
may.
may respond.
Thank you. First of all, this isn't a statutory interpretation question. Literally, the words on the page read demand side management. And this is the customer programs panel who has put rebuttal testimony into this record indicating that a SIGFER recommendation was already previously considered and case closed as of the comprehensive rate design study. And that analysis took place before the enactment of House Bill 951. So respectfully, it is absolutely relevant and material to exactly what we are here to discuss, which is the combination or mix of resources that Duke Energy will pursue to meet the carbon emissions reduction goals set forth in 951 in the least cost path.
So Ms. Kress, can you repeat your question so that I can rule upon whether to overrule or sustain the objection?
Yes. Mr. Byrd, do you agree with me that House Bill 951 directs the companies, among other things, to consider demand-side management as a potential resource in a mix of resources to meet the company's carbon emission reduction goals in the least cost manner?
Okay, so I'm going to overrule the objection. Mr. Byrd and Mr. Depp, I will give you time to look through the statute so that you can read it and see what the House Bill 951 states in that regard.
Ms. Kress, I see the words that you read, and it says which may, and then it provides a list, and included in that list is demand-side management.
And so in your rebuttal testimony, when you indicate that the program offered by Southern California Edison has already been considered and was considered as part of the comprehensive rate design study, which predated House Bill 951's enactment into law, don't you think it's fair to reassess in light of the subsequent law change whether or not this emergency load reduction program is potentially helpful to the companies as they continue down their carbon emission reduction path?
So I was the company's lead for the comprehensive rate design study. In our testimony, it says that we had discussions with stakeholders, including SIGFER, on this program and other demand response type designs during and after the comprehensive rate design study. And as I recall, the comprehensive rate design study was filed in March 2022.
And yes, you previously testified, subject to check, that that meeting discussing demand response programs as part of the non-residential working group took place in September 2021, which predated 951, correct?
The comprehensive rate design study work continued until it was filed with the commission.
And I don't think that responded exactly to my question. So just to be clear for the record, the non-residential working group had a meeting in September of 2021 regarding demand response programs, correct?
You asked me if a meeting occurred on that date, as I recall, and I said, yes. I believe you're reading from the report, which I don't have in front of me, but I remember the report laid out a number of meetings that we held, and we had a number of working groups and breakout sessions in addition to those meetings that were probably specifically listed. And again, I don't have a copy of that report in front of me.
And Mr. Duff, I believe you were asked a question by Commissioner Kimmerite regarding the amount of behind-the-meter capacity, specifically standby generation behind-the-meter capacity. Do you recall that question?
Yes, I do.
Are you prepared to answer it as you sit here today?
Yes. So looking at our programs today, we have approximately 31% of the participants in our non-residential DSM programs have backup generation, but that only consists of about 13% of the total capability. So that means that while a higher number of participants are participating, the capacity associated with that is not as large as those that don't have the backup generators.
So you testified in percentages. What about megawatts?
So with respect to megawatts, I have those specific megawatts for DEC, the DEC programs. I was not able to get the DEP program megawatt numbers.
What is it for DEC?
So it is with backup generators. It is, would you like summer or winter?
Let's do both.
It's 57.9 megawatts summer, 59.1 megawatts winter.
And just to be clear, this is megawatts of standby generation behind the meter currently enrolled in PowerShare?
That is generation that is currently enrolled. in the IS and the two power share options that currently exist. Obviously, voluntary isn't in place.
And what about more broadly than that, potential backup generation capacity that is not currently enrolled in a demand response program or an interruptible rate tariff, but which could be?
So I was not able to get Duke's service territory. It's not something that we necessarily track. But I was able to work with our team to find what's available in North Carolina that's registered with DEQ and permitted. And so based off of that permitting, there is approximately 2,100 megawatts of some level of permitted generators, whether they be emergency or non-emergency, based off of their permitting.
And that is for DEC and DEP in North Carolina?
That's total North Carolina. It's DEQ permits.
Understood, understood. Why were you not able to collect the data for DEP?
Because, as I said, we don't necessarily have a database of every customer that has a generator. And so this was based off of DEQ permits. And frankly, given the time, I wasn't able to go back and cross-reference every address with the DEQ permits because it's over 2,280 different customers.
And sorry, just to be clear, in terms of the numbers you were referencing at the outset of this line of questioning, you indicated that you had the DEC participating load data, but not the DEP participating load data. Is that correct?
Yes, we have much smaller participation in the SIG DRA program. As we've discussed before, given the 3-year opt-out, the participation in the DEP program is significantly less from a megawatts of capacity standpoint. So I don't have the generator numbers. I was able to get the percentages, but not the firm numbers.
Have the company studied whether participation would increase and uptake would increase if a program such as the Emergency Demand Response Program offered by Southern California Edison were offered in Duke Energy service territories?
Actually, Ms. Kress, we did have conversations with a number of SIGFIR members a number of different times. And the company, as I said the other day, is actually trying to put in a modification to its existing power share program that would enable an emergency generator program. A lot of the emergency generator that used to participate in the programs, because of the Rice-Nishap rules, weren't able to participate because they didn't have the number of hours. So our programs team have been working with DEQ to understand permitting and see if we could have a lower number of hour program for just basically significant emergencies that could be called. And so that's a modification that is part of the modification filing. And because that's in an open docket, I don't want to get into too many details.
And so what is the timing of the implementation of this modification?
Well, Ms. Kress, as you're aware, when we shared recently with the collaborative and I believe with all the attorneys, we're planning on filing the modifications on August 20th with the commission.
August the 20th of 2024.
That's correct.
And do those modifications include different time intervals and notice intervals and a value differential in the bill credit?
So it does not have different notification periods associated with it. As we've discussed in the past, there's differing opinions on the complexity associated with developing values associated with different notification periods. I know the California ISO program has continued to be brought up, but the California program operates in an ISO, which is fundamentally different from the Carolinas. And so we think that while we're not saying it can't be done, that there needs to be many more discussions regarding what different intervals provide different value that would justify different incentives for different notification periods.
And when do the companies expect to have studied that exact issue?
As I said the other day, we had to prioritize getting the modifications to existing programs that could be done in those program frameworks within 90 days of the order approving the EEDSM mechanism. We plan on working and convening with stakeholders to try to have more detailed discussions about it. There have been different notification periods thrown out as being desired, but we've also talked to our operators who don't necessarily believe that those intervals provide additional value like they do in the California ISO program. So I think it will take a number of different discussions with parties, but the company looks forward to undertaking those as soon as really it gets through with these massive modifications, which is covering the entire portfolio for both DEC and DEP.
Thank you. No further questions.
Mr. Depp, a follow-up to Ms. Kress's question about the backup generation. Oh, I'm sorry.
I think you anticipated my answer. No redirect.
So, Mr. Duff, the question that I was just about getting ready to ask is, you responded to Ms. Kress's question and said that there was about 2,100 megawatts of some level of generation for both DEC and DEP. And you obtained that information, I believe you said, from analysis of DEQ permits. Is that correct?
That's correct, but it's broader than just DEP and DEC. It's the entire state. So I wasn't able to get them to be able. We were trying to struggle to figure out how to get an answer for the question that was posed, and so somebody on our program team was very smart and said, "Well, we can go out and look at permits." Scrubbing that permit down to what's just in DEC and DEP was a challenge. The other caveat is there's also some, there's utility backup generators. I noticed there was a Piedmont generator in there. So I don't know if those should actually be qualified in there or not. The numbers have to be scrubbed, but the raw permitted capacity associated with generators is that 2,158 megawatt hours, or megawatts, sorry.
2,100 megawatts. Well, I appreciate the effort and the creativity to try to get an answer for the commission. So what I was going to ask, but this may be difficult based upon your answer, is the 2,100 megawatts of backup generation, would that be representative of backup generation for customers that have both opted in and then opted out of the DSMEE program or rider? And I don't know if you can answer that, but the best of your ability, if you have any guidance about how that 2,100 megawatts might translate to opt-in and opt-out non-residential customers.
So that being the total state, like I said, I was able to get the DEC numbers. And so when I look at the numbers there, as I said, DEC specifically, you're looking at approximately 25% of the participants have opted in that they have backup generators. So I would assume that the customers that aren't participating have opted out, but I don't have the ability to say that they haven't opted into another EE program. But from a DSM standpoint, it is 25.7% of the EE or the DSM programs do have backup generators. And as I said before, that's a lower percentage of the total capability. It's only about 11.9% of the winter capability. So they're smaller generators, higher number of customers. That's why your percentages aren't aligning.
Okay. Well, that's helpful information for us to be able to consider. And then moving on to some different questions. On page 2 of your rebuttal testimony, you've stated that you don't agree with the public staff's recommendation that the DSM program should be a selectable resource by Encompass because DSM programs are still 100% dependent upon customers' decisions to participate. Can you talk about Duke's experience in seeing continued participation in DSM programs so that the participation can be counted upon? And we've heard quite a bit of testimony about this, but really what I'm trying to get at is when will you have the experience so that you can have more assurance about customers being able to count that participation, being able to be counted on going forward?
So it's a great question. I think that it's not necessarily whether or not it can be counted on. It's being put in. It's when you make it a selectable resource, that can be called on multiple times. And that's one of the things I heard Witness Thomas for the public staff talk about markets in Indiana and reference that we bundle and have it be a selectable resource in Indiana. That isn't exactly correct. Witness Thomas is a little bit off on that in that it's not a pure economic decision to say it's selectable. It's really based off of a max number of events versus a cost to achieve. And so it's not a selectable resource in the Compass model, which just looks at the economics of it. So when I talk about the fact that it really isn't selectable, the point that I'm making is you can say that a customer will pay you $30 and you're going to participate in our program. And in all of our programs, they have the ability to opt out of an event. So let's say we need that and we need to call it 3 straight days. And then we're going to call it the 4th day. And at that point, the customer just says, I'm sick of being uncomfortable. I'm going to opt out. It's that factor to opt out or to even decide I'm done with participating in this program that gives us concern that the DSM should be treated the same way. When we're providing the forecast to Mr. Snyder, we're looking at a lot of the inputs that have been talked about. We're looking at, well, if we give a customer an incentive, what do we think they can participate? And there are certain customers that will never participate. I heard a customer on the SIGFR panel say, well, my operation, I think it was Charlotte Pipe representative, say, my operations are 24/7. I can't shed load. So there's a customer that even if the model says that it's economic for them to take the incentive and we could give them an incentive, they're not going to participate. So if the model selects it and says economically they can participate, we've now factored in a resource that would not participate despite the economics. So it's really that fact that it's not something that you have firm control over in the long run that gives us pause about making it a selectable resource. We want to continue to include it, and it really does get priority because my understanding from the modelers are that when we provide the DSM forecast, it's considered off the top. So it's selected. It's not like it says, oh, no, you know what, there are other less expensive resources. It's selected and put in, but it's put in based off the parameters of the program.
So what I think I've heard you say, just to really summarize it, is that the real issue from your perspective is not lack of experience, but it's lack of having firm control. Is that the essence of what you're saying?
Yes.
Okay. And then you talk about there was some questions about vehicle to grid and vehicle to everything technologies. And I think there was a few pages in which you talked about how to respond to requests to consider vehicle to grid and vehicle to everything technologies. And you said that Duke would be interested in considering, especially the vehicle to everything technologies, when the technology is more widely available. And can you talk about where Duke is, where the country is in regard to that vehicle to everything technology?
So as the commission knows, we have filed a demand response program that was vehicle to grid.
Mm-hmm.
We did that based off of lengthy conversations with OEMs about the availability of that technology, and the technology to support that program still is not in the market. We had to pause implementation.
Mm-hmm.
We are in the process of running a managed charging pilot that launched in November of last year, and even that we've had significant issues using vehicle telematics versus kind of the charger. And so I think that what we've seen is we continue to hear from vehicle manufacturers that it's coming, it's coming. We're aware of a number of small tests, and we've done some technology tests, but when you start talking about the costs, it gets much more burdensome than some of the estimates that we were originally told in terms of having home integration systems and give you the ability to actually fully leverage that battery. So we think it's an exciting technology. There's a lot to like about the fact that it's really kind of a mobile source. It's something that can actually put excess generation onto the grid beyond just what a home's consuming. But all of those things have not been proven out. And so to assume that they are available and assume a date that they'll be available in a resource plan, based off of my understanding, would not be a wise decision. And so as we continue to see the OEMs tell us that that technology is coming and that it will be available in the market at a cost that would be affordable for customers to adopt, even after our incentives, that's, I think, when it makes sense to start understanding what the magnitude of those programs can be from a capacity standpoint, as well as what the costs and how quickly the adoption will occur.
And then I think the vehicle to grid is a little bit farther ahead than the vehicle to everything technology. And the pilot program was the Ford 150 Lightning, is that correct?
Yes.
And I know that had been paused. Do you have an update about when that might be able to be moving forward?
So the last update that I received, the technology, the software, which is required, still is not there. The company is frustrated because a lot of the underlying assumptions that were included in that program that was filed over 2 years ago and approved by the commission, they're dated. So we're in the process of evaluating whether or not it makes sense to just kind of maybe start from scratch to really factor in what we've learned since that pilot was filed. But as of right now, the implementation is still paused. I think we're excited to try and move forward with something, but need to make sure that it is a positive experience for not only customers participating, but something that can provide system benefits.
Okay, thank you for the update. And then just a couple more questions. You talk about data centers that we've had a lot of discussion about on page 18. And you talk about how the recently approved power share mandatory plus curtailment option might be able to be utilized by data centers to increase their participation in DSM programs. Can you provide some more information, some more detail about that statement?
Sure. So the Power Share Mandatory Plus program is really designed to basically create higher incentives for customers for giving additional firm hours of utilization. So we're saying we're going to use it for 100 hours. Doesn't matter if it's not emergency, we're going to try and use it for economic reasons or other reasons. And so what it does is it stacks an additional incentive on top of the mandatory program. Because one of the things we didn't want to do was have a customer sign up for the kind of economic option, but then opt out of the mandatory, which is what really is the important capacity that we use in our resource planning. So it's really designed to be kind of, as it says, Power Share Mandatory Plus, because for those additional hours, it's a way for somebody like a data center who can shift usage maybe a little bit easier than somebody with a manufacturing facility to participate and get a higher overall incentive. We're getting more mandatory capacity as well as now some economic capacity that can be utilized for more events, because it's 100 firm event hours that's included in Mandatory Plus.
And have you seen any interest from the data centers about this?
So we haven't yet. The program is going to launch in January, and a lot of the reason for that is because of the opt-out. We want to make sure that we're telling customers about it before they're making that opt-in, opt-out decision. So as you're probably aware, customers can opt out for the next year's vintage in the fall. And then there's a 1-week opt-in window in March. Unfortunately, that program didn't get approved and into the market for that opt-in window. So we plan on making it part of the communication that our large account managers will have as they do every year in DEC, to let them know that that program is available. And with DEP, it's a little bit different. There's not the opt-in windows. They're in for 3 years after they elect to participate. And so the Power Share Mandatory Plus program didn't really bolt on the DEP program. It's one of the things that we think we're going to need a new program in the DEP region that will allow us to offer a similar type program. But we should be able to start giving the commission an update later this year, early next year, when we start to communicate to customers of the availability of this option. And additionally, that program, although recently approved in May, will also benefit from some modifications to increase incentive levels to be consistent with the new system benefit recognition.
Okay, thank you. And you mostly answered my question, but I think I was curious about whether you had your account managers or the people who are speaking with the data centers that are coming. Are these the types of conversations that you're having to gauge interest in the programs that you are going to be potentially offering to the data centers?
Yeah, yes. Both our economic development and our large account management team who deal with them, we're making sure they're well-versed in these program offers as well as the modifications that are coming.
Okay. And I think just 2 more questions. On pages 28 and 29, you talk about, we've had a lot of discussion about this topic as well, but I just wanted to get some more detail from you. The steps that Duke is taking to make sure that the large load customers will pay their cost of investments in the event that their load doesn't actually materialize. Can you just provide some more information about what you are doing to ensure that ratepayers are not subject to, that these large load customers will in fact be the ones that are responsible for these investments to the greatest extent possible?
Yes, excuse me. Yes, Presiding Commissioner, I'll be happy to describe a little bit about what we've done. So first of all, what's in the tariff today has historically worked really well for smaller loads and the uncertainty associated with those loads, right? So we have minimum bills that are tied to contract demand. We also have termination charges that are limited by something we call loss due to early retirement. So it's really the on-site equipment used for service. And so those terms have worked really well for smaller loads that might have uncertainty or might have seasonal outages or something like that.
Mm-hmm.
So what we found was with these very large, unique, concentrated loads, we needed to strengthen some of those terms. So we came to the commission and we received approval back in January to apply some complementary or additional performance provisions as well as credit provisions for those performance terms in contracts with customers above 100 megawatts. So essentially what we did was take those historic structures and tie them out a little bit differently to, instead of the current contract demand, to the load ramp over time. So if a customer says, I need 500 megawatts over this very extended period of time, and I'm going to ramp up to that, we would tie a minimum billing demand to that load ramp. And then we would have a termination provision that's associated with that minimum billing demand kind of structure and put that into the service agreement. So it's reflecting the uniqueness and concentration of that large load in the service agreement that layers on top of. It doesn't replace, but it supplements what was historically working well in the tariff for smaller customers.
Okay, thank you. And then my last question, reading around pages 24 and then later in the testimony, it appears that CPIRP has been working closely with Duke to try to come up, providing ideas or suggestions for DSM programs that might actually work for the large load non-residential customers. And I think that you provided some examples of some good suggestions and ideas that CPIRP has put forward in your testimony. I won't go through that because I think you've described those programs. But I did ask yesterday, Witness Collins a question. He talked about, and this is on page 24 and 25 of your testimony, about emergency response programs. Oh, excuse me, I'm looking at the wrong page. Page 22. Witness Collins had made a recommendation that Duke needed to be flexible and creative to offer programs that would be attractive to the non-residential large customers. And his suggestion is that there needed to be a new way of thinking about it, and that the program should be offered regardless of whether those customers are participating in the DSM-EE rider. And in your testimony, it appears that that is something that the company is not receptive to. And I asked Witness Collins about it. I'd like to hear your response about participation in that rider.
So I think the company believes that its DSM programs are designed to provide consideration to shift or reduce load.
Mm-hmm.
And those then fall under the commission rule R868, which is the EEDSM programs that we judge cost effectiveness for, and that we basically allow customers non-residential customers who are opt-out eligible to opt out of participating in if they're kind of undertaking it on their own, or they don't want to participate because it would subsidize other customers. However, the company feels strongly that if in fact they want to participate in a DSM program, then they should pay into the EEDSM rider for such a program, because other customers that aren't opt-out eligible are paying for EEDSM programs that they can participate in. So from a symmetry and equality standpoint, it is logical to the company that if it is truly a DSM program, that a customer should participate in the DSM rider so they can take advantage of that program's benefits.
So are you essentially saying if you are participating in the program, but you are not required to be part of the rider, you'd be shifting costs to the customers that are required to be part of the rider? Is that correct?
If it's an approved EEDSM program that all customers in the rider pay for, if a customer is participating in it, the company believes that the statutes and the rules support customers participating, as well as the EEDSM mechanism, which outlines opt-out. And as I said, there's a pretty prescriptive process of, if you don't want to participate and pay the rider, you can tell the company and not have to pay for it, and then you don't participate. If you do want to participate, you pay the rider.
Mm-hmm. And then last question, I think this is stated in your testimony, but just for clarification, Duke is continuing to work with the large non-residential customers to try to find ways to have programs that will be attractive to them, cost-effective programs so that they can participate in DSM. Is that correct?
Yes, we think it's critical for us to be able to achieve the amount of EE and DSM that's been modeled in the CPIRP. And, we believe that a lot of the mechanism updates will help to do that. But obviously, we continue to need to have conversations through our advisory forum, which is the EEDSM collaborative, with large non-residential customers to inform us of what could make an attractive program.
Okay.
If I might add, it's not just conversations about ideas, it's implementing actual ideas. And we had the comprehensive rate design study. We made a lot of changes as a result of that work in the rate cases. So those have been effective, resulting in significant changes to like hourly pricing rates that reflected customer interests. And I'm very hopeful that will provide a lot of benefits going forward. So those become real. They're not just conversations. So.
Okay. Thank you. That's all the questions I have. Commissioner Hughes.
Just a really quick follow-up on one of the last responses about the issue of fairness for DSM program participation. I understand, how you laid it out. I'm concerned, what if there is a program that has a clear benefit, not even cost benefit, just a financial benefit, where you can buy peak capacity for much cheaper from a large non-residential customer during an emergency than you can produce it yourself? I mean, so what if there was something that if it was a selectable resource, the model just loved it and picked it? So it would have a clear financial benefit, but moving that program mixed in with a lot of other smaller DSM programs that are part of the rider, just make it so it's from a all in or all out perspective. These large companies just, they've told us over and over again, all they care about is the bottom line. So I'm just concerned, isn't there a possibility of losing some of these really good for the system DSM programs? If we lump them together with some of these other smaller DSM programs that might not have as much of a benefit. I mean, that's what I heard your response to be. If they don't agree to do the DSM rider, we're not going to necessarily focus on them for, maybe I'm putting words in your mouth, but.
So I think from a DSM program standpoint, that is what we believe, that if it's a DSM program that's approved and being paid for by non-residential customer class, that it should be paid for by somebody who's participating in one of those programs. If I think your example, Commissioner Hughes, was purchasing power from a generator out in the system, that may not necessarily be DSM as opposed to a reduction in a customer's consumption. I think that there's a lot of details would have to be worked out on a program like that. But what I would say is we have tried to address kind of, as I said, some of the emergency generators with a new option in the program, and believe that the DSM programs are being designed to be cost effective, and hence if it's a real concern if you're offering customers the ability to not pay, that you're then the rider amount for those customers that are participating will go up and make it less attractive for them to participate. So I think we've tried to do things like breaking out EE and DSM so that you really can isolate the programs that the customers that are participating and paying the rider are associated with. But I think if it's a commission-approved DSM program, that the customers participating in that program should pay the rider.
Might I also add that in the embedded cost rates that we design in rate cases, we have new time of use rates, hourly pricing programs, and those are designed to allow those customers with flexible usage or consumption profiles. They can shift it around based on price signals. They can see those demand charges or energy charges or the hourly pricing rate, and they can respond accordingly. So those are embedded cost structures that are allowed to, that are set up to allow customers with flexible loads to move around in response to prices. So that's in the core tariffs.
Well, I appreciate that as an alternative option. I just, yeah, and I didn't mean to necessarily say that you would buy from a generator, but if the generator turned on and then suddenly the person used less power, that was the example I meant to give, Mr. Duff. So, they'd be using less power. You would grab that peak capacity right there. And we've just seen the prices this week in this industry right now, peak capacity is at a premium. So if we can figure out a way to grab that peak capacity and it's just, I'm just thinking out loud, but thank you for your answer.
I have one other thing for you, Commissioner Hughes, because it's been brought up a number of times. Mr. Thomas misquoted the percentage that I threw out earlier. It's 93% of power pair customers.
I probably misquoted it, but I appreciate it. But
Mr. Thomas threw out 97, and then it's kind of snowballed from there. So I just thought I would clear the record up on that one because I've heard it said a couple of different times.
Okay, well, that's a great number still. Yes. Thank you for that.
Okay, questions on commission questions. Ms. Kress.
Mr. Duff, just following up on the conversation you just had with Presiding Commissioner Kimmerite as well as Commissioner Hughes, it sounded from your testimony like you're familiar with Rule R868. Is that correct?
That's correct.
And to your knowledge, has Rule R868 been updated or amended since the enactment of House Bill 951 in October 2021?
I'm not aware if it has or not.
And to the extent you know, can the commission at any time change their rules?
I think that's their prerogative, yes.
Thank you.
Questions from Duke?
No further questions. Thank you.
Okay. So I will receive.
Presiding Commissioner Camright, I have
oh,
one question, if that's okay.
Go ahead, Ms. Malore.
Nadia Lure with the public staff. Mr. Duff, are you or is Duke aware of an electric vehicle to home program in any other jurisdiction, like Baltimore Gas and Electric?
I'm not specifically aware of that program. I know there are a number of pilots that have been publicized, similar to ours that we thought was going to launch. I don't know if it's launched or not. I was also aware that I think Pacific Gas and Electric announced one, but again, I don't know if those pilot programs have launched.
Okay, thank you.
Any additional questions?
No additional questions. Thank you.
Okay, so I'll receive motions.
At this time, I'd move that the panel's 1 rebuttal exhibit be accepted into the record this time.
Okay. Seeing no objection, your motion is allowed. Ms. Kress.
I don't
Actually,
believe
you
I-
did not have, I apologize, you did not have an exhibit.
Okay, thank you.
So with that, we've come to the conclusion of this panel's testimony, and thank you for your testimony. You may step down and be excused.
Thank you.
Thank you, Commissioner Camright. At this time, the Duke Energy calls to the stand the Reliability and Operational Resilience Panel.
Good afternoon, Mr. Holman and Mr. O'Connor.
And before you get started, I'll remind the witnesses that they had previously been sworn in and you remain sworn in.
Mr. Holman, are you and Mr. O'Connor the same reliability and operational resilience panel that appeared earlier in this proceeding as part of the company's direct case?
Yes, we are.
And did the panel cause to be pre-filed in this docket rebuttal testimony consisting of 38 pages and 1 rebuttal exhibit?
Yes, that is correct.
Do you have any changes or corrections to your rebuttal testimony at this time?
No, we do not.
And if I were to ask you the same questions today that appear in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
And neither your rebuttal testimony or your exhibit contains confidential information, is that correct?
That is correct.
And did you also prepare and cause to be pre-filed a summary of the panel's rebuttal testimony?
Yes, we did.
Presiding Commissioner Camright, I would ask that this panel's rebuttal testimony and rebuttal testimony summary be entered into the record as if given orally from the stand.
Okay. Seeing no objection, your motion is allowed, and the panel's rebuttal testimony and summary of the rebuttal testimony shall be entered into the record as if given orally from the stand.
And I would also ask that this panel's 1 exhibit that be pre-marked for identification to be entered into the record at the appropriate time.
Okay. Seeing no objection, the 1 exhibit shall be marked as identified.
And the panel is now available for questions.
And I believe that we have cross-examination only from Walmart. Is that correct?
Walmart certainly has cross. I think I'm the only one I see on the spreadsheet.
Okay, you may proceed.
Thank you. Good afternoon, gentlemen. I'll be very brief. Were you all in the room or listening to the hearing when I spoke to the resource adequacy panel about the 2.5 percentage point increase in the reserve margin study associated with generator outage data?
We were not in the room, but we were listening.
Can I ask you to look at that yellow notebook that's right there and turn to what has been pre-marked as Walmart potential cross-examination Exhibit 8? And Your Honor, may I mark this for the record as Walmart cross reliability and operational resilience reliability and operational resilience panel.
Rebuttal Exhibit 1. It will be so marked.
Thank you. Mr. O'Connor, did you provide this response?
I did.
And just in looking at this, the question asks you how much of the winter capacity risk built in to the assumptions leading to the 2.5% increase is avoidable. And am I understanding correctly that you all are assessing this, but you haven't quantified those effects at this time?
I think it's more accurate to say that, and Mr. Holman can speak to, basically the line of questioning from our direct on, the actions taken after Winter Storm Elliott. But, from a modeling standpoint, from a planning standpoint, there is always some level of fundamental risk. And all of the actions that are being taken to improve reliability are there and they are real. But I think from a modeling standpoint, we want to see them be proven out. We want to make sure that as we go through our data-driven approach to setting the reserve margin and assessing reliability, that we have confirmed performance before we build that into our assumptions.
So when you say in your answer here, the companies have not quantified the potential effects of these actions on future winter capacity risk, is that answer accurate in light of the answer you just gave me?
We have not explicitly quantified the impacts of reducing the winter capacity risk, correct?
Okay. Thank you. Those are all the questions that I have.
Well, I will be almost as quick as Ms. Grundman here. I have 2 questions. I believe this one is for you, Mr. Holloman. On page 34, you respond to public staff witness Metz's concerns. He talks about what he calls an alarming situation. And we've talked a little bit about this before and he testified to it, but I want to, for the record, get your testimony about it. But he says that there's an potentially alarming situation on the grid due to the amounts of intermittent resources such as solar that's going to be coming onto the grid and the need to ramp up dispatchable resources very quickly to meet changing load conditions, changing conditions on the grid based upon the variable nature of solar. Can you talk about Duke's experience already and with the solar that's been added to the grid? I think that you've testified that Duke has integrated over 5,000 megawatts of solar to date on the system, and how you're going to be prepared to handle the amount of solar that we already have and that will be coming.
Sure, and I can speak from it from an operational perspective, and Witness O'Connor can speak to it from more of a planning perspective. But I appreciate Witness Metz bringing up this concern. It shows a grounding in operational experience. This is not anything new. We are challenged, and I think he's talking mainly about low load periods or lower load periods. We've been challenged for as long as I can remember in certain low periods with, okay, it's kind of the opposite of what we've talked about mostly in this hearing, and that is your customer demand has dropped to a point where you now got to make considerations. Okay, what units do we keep online so that we can meet the bottom end of that? As operators, we're obligated to meet load generation reserve balance when it's really cold or really hot. We're also required to do that same discipline when load's down. It's a 24/7 by 365, 8760. You've heard all those phrases so far this week. And so as we look at this, and I think Witness Roberts has spoken about this before, we have a process called the lowest reliability operating limit. And it's information we provide our operators. It basically tells them, okay, don't just look at what's happening right in front of you. Don't make a short-sighted decision that'll hurt you 2 days from now. They may not even be working 2 days from now. And so we give them an indication. It's a plan over a short window of time that says, okay, given what we project and forecast to happen 2 days from now, you need to keep these resources online because their performance indicates that if you bring this particular asset down, it won't be back in time to be able to help you in 2 days. So we manage that. It's called the lowest reliability operating limit. And that was kind of a unique process that we put in place a couple of years ago in the industry. And it's kind of picked up pace because you do have the phenomena that happens, especially with solar integration, that if it's bright and sunny, you're going to have a lot of output. And that's part of the benefits of solar. But if your load's not quite there, you have to have the flexibility and the dispatchability to manage down to that load. And through the oversight and guidance and direction from the commission, we've been able to construct things like Bad Creek pump storage, like Joe Cassie pump storage. And then in the plan, you talk about later Bad Creek 2, but they provide the opportunity in pumping mode to create load. That's all part of managing your lowest reliability operating limit. So I don't know that I would agree with Witness Metz that it's an alarming situation or something we haven't dealt with in the past. It's part of our job. It's our job 8760. It's our job to comply with NERC standards for balancing and to deliver for our customers on what they have as their load demand and carrying reserves over the top of that. And in particular, we talk a lot about, and Winter Storm Elliott was kind of this way. We didn't have enough assets to meet the load, so we had to go into controlled load shed. And I think we talked about the way that happens is with the balancing authority ACE limit, you're managing to make sure you're not hurting the interconnection. Overfrequency can be a problem as well. And so you don't want to be that balancing authority who's over generating. So our operators are well trained in this. They've been well trained and they implement the lowest reliability operating limit process, and we will deal with that as the system grows out. But I do think it's important to look at P3 fall base, the discussion and the creation of dispatchable, flexible resources. That's how you deal with it. No asset is perfect, but if you've got dispatchability, and when we talk dispatchability from an operator's perspective, it's their ability as an operator to issue an operating instruction of which they are the only credentialed people in Duke Energy to take an action, either to change status of a piece of equipment or leave the status like it is. But the instruction here would be, I need you to drop generation. I need you to go down to your emergency load limits so that we can ensure that we have not only balance in the current state, but we can maintain balance in the future state. So that's a long answer to a short question, but it's part of what we do.
Okay, thank you. And that leads me to my second and I think last question. But Public Staff Witness Metz has recommended that Duke perform a solar integration study. And from your testimony, you state that you don't think it's necessary. Can you explain your understanding of what the public staff wanted with that solar integration study and why you think it's not necessary?
I am not exactly certain as to what they were wanting explicitly, but I think our interconnection process as it exists today, and as it is improving over time through commissioning and through permission to operate formality, we blend that into the training that our operators get. We handle it today. And so what is we build out towards future years, I think that's the beauty of P3 fall base. We are enacting or developing a plan or a strategy to make sure that we're replacing capabilities, such as being able to ramp down, load following down, that's an essential reliability service, in situations like this. And it forces coordination around the addition of new facilities, assets, solar, demand or customer-sided resources in the longer term, offshore wind, onshore wind. It allows us to coordinate that with retirement of over 8,400 megawatts of coal with the addition of natural gas resources. So I think we're doing it. I think we're doing it by process. And so I don't know that there's necessarily a need for a specific integration study.
And you have performed actual solar integration studies in the past, is that right?
I don't know that I can speak definitively to it. I'd say subject to check. I think we have.
Okay. Thank you. That's all the questions I have. Chair Mitchell.
Good afternoon, gentlemen. Just a few questions, mostly based on things that I've heard during the hearing over the past couple of days. So, Mr. Holman, can you talk some about the company's experience with batteries? I mean, and let me tell you why I asked the question. I've heard your testimony related to other resources that the company doesn't have extensive experience with at this time, but will gain experience as time goes on. The plan obviously involves the integration and the development and integration of a significant number of batteries, standalone storage. Can you just talk some about y'all's experience to date
So
from the operation side?
From operation side, from a system operator, ECC Energy Control Center perspective. So the way I kind of look at it, it's storage. And so we have extensive, I'd say, industry leading experience in pump storage with Bag Creek and Jocasta. We understand its operating parameters. We understand what we have to do to maintain our optionality over time. I think the value of that played out. It plays out every day, but it played out especially on days like the 24th of December, 2022, gave us tremendous flexibility. So we have, I would say, industry leading experience in pump storage. When it comes to battery storage, that's a little newer. We've got a facility in Hot Springs as part of a microgrid. I think we were asked that question in Discovery coming out of Winter Storm Elliott. It's a very small capacity battery. And so we have limited experience, operating experience, functional operating experience with battery storage.
Okay, and with respect to battery storage, who makes the call as to how it's operated? Would that be the ECC or is it the renewables dispatch? Who's controlling that storage?
So that's a great question, and I think that's part of the learnings we will develop over time, because that will be critical as we train. We talked a lot about training. When's it too early? When's it just right? When's it too late? I suppose that will be definitely a key part of our training to our operators. This is the asset. This is how it can perform. These are the essential reliability services it can provide. These are its limits. That's very common to any kind of asset we have. But you, ECC system operators, as the control authority, there is only one set of control authorities within the NERC framework in the Carolinas at Duke Energy, and that is the system operators at our Garner Energy Control Center for DEP and in our Charlotte Energy Control Center for DEC. They are the ultimate highest authority decision makers as credentialed and empowered by NERC. And so nothing that affects the balance of the two balancing authorities, DEP and DEC, can happen with intentionality that doesn't go through the system operators first. Now, in areas like distribution located assets, our relationship with our distribution control center, Delta Charlie Charlie, we've got one of those in the Raleigh area and one of those in the Charlotte area, has become more critical and more real time than it's ever been. We work very closely with Rick Grant and his team in the distribution control center side. But the ultimate authority, the ultimate control authority, are the system operators in the ECC. So, Chair Mitchell, that's part of the learning we will get into and train our operators on how it works. Because a lot of these assets, especially these new ones, especially these ones that are owned by our customers that we will need to partner with, there's multi-value opportunities for them, both for the grid and for the customer. And we don't want a system operator who's working the shift on the BA desk, balancing authority desk, to think I've got the ability to discharge this battery between 2 p.m. and 4 p.m. and the local owner operator has used it for something else. That will be a problem. And to a certain degree, some of these batteries are smaller than operators are typically used to using, but as you combine them into capability, they become material. They become significant. And so we need to frame that up for our operators to understand this is the tool, this is how you execute it. And it may be that we call the DCC and say, we're instructing you to bring on X megawatts of batteries. And they'll know the details of how that's going to happen. System operators don't necessarily need to know that. We just need to know the framework on how that works. So that's how you get around this challenge of chasing megawatt and gigawatt challenges with kilowatts. Big problems being chased with small granular assets. If you look at graphic, the graphic we talked about in direct testimony that showed the amount of rate of change that's going to happen in the backside of summer peaks, those are thousands of megawatts. And if I have to call on individual kilowatts of battery storage to help chase that, that's a problem. But if all I have to do is call the DCC and say, I need 500 megawatts of battery discharge to help me deal with this ramp, that's manageable. But that discipline, that framework has to be established, has to be signed off by both the Distribution Control Center, Delta Charlie Charlie, and the Energy Control Center, the Echo Charlie Charlie, so that there's no misunderstandings on how that'll work. That's actually how some of Winter Storm Elliott happened. We were working very closely with our teammates in the Distribution Control Center on managing the whole controlled load shed situation. Our relationship with them has just gotten tighter and more operational since then. I hope that helps.
It does. And so, and I think I understand the points you're making about distribution tied batteries and batteries that are owned by your customers. But for those battery assets that the company plans to develop and own and operate, I'm hearing you say that you all have to develop and gain operational experience with those assets as well, those transmission tied assets.
That's correct. But
Okay.
I think the answer to your direct question, who's the control authority? It's the Energy Control Center. It's
Okay.
the system operators.
Okay. All right. A few more questions for you. Who makes the call to switch to backup fuel for those units that you have that can run on dual fuel?
So that's a coordinated effort between the generation asset owner, that would be the folks that own and operate. And when I say own and operate, it's all within the framework of Duke Energy, but registered entity-wise in NERC space, the owner operators are the folks that work in the generation group, just to keep it at a conceptual level, because they're running the assets. It's also working with our fuels team that's looking at the economics and the availability of fuels. And from an ECC perspective, because we've had such success with doing this, it's not without risk, but it's something we have done. We've trained on it. We understand how it works. We're at that table, but we're just wanting to make sure, when's it going to take place so that we can know what's going to happen to the generation. Do you need to adjust it to a certain level to make the switch, and so you can come back up? We just need to know the operational ramifications so that we can coordinate with what we're doing.
Okay.
So we're at the table. We're not necessarily the decision maker.
Understood. Okay. Thank you for that. Next question, who makes the call to exercise the company's rights under the JDA?
So the joint dispatch agreement is very automated. I mean, it's a tool that, and I know you're thinking he's not answering my question. I'll get to it, but I want to paint the picture a little bit. So it's an algorithm that looks at the incremental costs in one BA and the incremental cost in the other and attempts to drive it to the same incremental cost. And the effect of that is whoever has a lower incremental cost, you're going to pick up generation in that balancing authority. Whoever has the lower incremental cost, or the higher incremental cost, you're going to drive down. And this assumes kind of flat load, but you're attempting to dispatch to a common, we call it lambda, but it's really the incremental cost of the grid, the cost of the next megawatt. So that question is a very interesting question because it is non-firm energy. It's kind of economically available. We're not committing to it, but it's economically available at the time. Witness Veterami's team and the trading floor is very involved in the economics of it and the algorithmic management of it. It's performed very well since we put it into service. I think it's been very value producing for our customers. But at the end of the day, from an operator perspective, and this goes to some of the discussion around energy only service. It is energy only. It is non-firm. It is non-firm 6, which is one of the lowest priority non-firm products that the open access transmission tariff provides. That's the pro forma tariff from FERC. So that being the case, system operators have to maintain capacity to backstand that energy. That just doesn't apply to the JDA. It applies to any situation like that. When we buy non-firm from another system, we've got to have capacity-backed resources in our operating reserves to backstand the potential loss of that non-firm import and the JDA flow. So that also applies to the discussion we had with some of the provisional or energy-only products with some of these new technologies like wind. From an operator's perspective, if you tell me that, okay, this is energy only, I can deal with that. I deal with that by carrying capacity in my operating reserves that backstands the loss of that resource. And it really doesn't matter the probability of losing that resource. The discipline that NERC expects from us is that if you've got non-firm imports or non-firm production of generation or non-firm exchange of energy with your neighbor who happens to be in the same company, you have to backstand that with capacity-backed assets in your operating reserves.
Mr. Holman, I understand what you're saying, and here's my next question. So, in a situation like we had during Winter Storm Elliott, where we were growing short on capacity, and you all were looking outside of the BAs to import energy in. So, as the BA has to declare emergencies, does that obligation relax, or because at some point you're going outside because you don't have any available capacity and no energy from that capacity?
So in the continuum of managing your load generation balance and carrying your operating reserves, and that's a great example. So as we and I believe, subject to check, we were at some points buying non-firm energy because we were looking for any energy we could get. When you do that and you don't have any capacity to back it up, you have declared my operating reserve is now my customer load. And that story kind of played itself out that day. In order to get our ACE back into a place that was supporting interconnection frequency, in order for us to get back to a place where we weren't dragging the interconnection, we had to use our customers as our operating reserve.
Meaning you had to, yeah.
That's
Okay.
our old load shed.
Okay, got it. Okay. All right. I want to talk to you some about Bad Creek 2. Obviously, the company has some proposals before the commission in this proceeding related to Bad Creek 2. And we've focused a lot of discussion in this hearing and in the evidence that's coming in before the commission on storage and energy storage. Obviously, Bad Creek 2 is a component of the company's energy storage assets. Can you talk about why Bad Creek and Bad Creek 2 and Jocassee are important to you, the system operator, and to your team of system operators, and maybe go into the sort of is this an asset that why should we continue to pursue this Bad Creek 2 project? What is it about the Bad Creek 2 project that provides value to the companies and its customers?
So I'll address that from a system operator's perspective. I'll turn to my co-panelist, Witness O'Connor, from more of the planning perspective. And hit me if I talk too much of it.
Well, I'm really interested in the operations, because as we look to change, the changes that are going to occur in the resource mix as this coal comes offline, I want to know how you and your team of system operators are going to respond to the changing dynamics, and specifically how these pump storage hydro assets are going to work in.
So Chair Mitchell, I'd encourage you to turn to page 3 of Exhibit 1.
Exhibit 1 to your rebuttal?
Yes, and that will take you to the larger pictures. I kind of need that help with the larger pictures. But I'll say one anecdotal thing, and then I'll get to the heart of your question. So I don't know of a single balancing authority system operator whose balancing authority has pump storage who won't tell you pump storage is a system operator's best friend. It provides almost all of the essential reliability services that are listed in the NERC document on concepts around essential reliability services. It's the fastest ramping resource we have by orders of magnitude. We've had years, and I think 50 with Jocassee, of operating experience with this resource. It's tremendously flexible, and operators depend on it a lot. And so if you extrapolate out over the course of our journey through now to 2050, we are, through the retirement of coal, you've got to replace not only the megawatts and the megawatt hours, and that's not insignificant. You've got to replace the ability of those assets to load follow, the ability of those assets to go on regulation, the ability of those assets to ramp, the ability of those assets in today's world. And a lot of these coal units when they first came online, when I first started my career, they were pretty much base loaded units. Now they're cycling off and cycling on. All of those capabilities go away when you retire it. And so the challenge, and I think P3 Fall Base addresses this explicitly, you've got to replace those capabilities. You know, you've heard me say before, you got to replace the capability before you retire the capability. That's kind of fuel agnostic, even though that's not practical. There's always fuel aspects to things. And so as we move forward with more solar, I think we're incrementally adding 6,000 megawatts of solar between now and 2031, subject to check. We got about 3,800, 4,000 now. That puts us over 10,000. That's a lot of intermittency and variability. Intra-day, minute to minute, hour to hour, and intra-week, day to day, depending on the irradiance. And so and you're introducing more variability with some of the customer-sided tools as well. I heard the prior panel talking about the ability of a customer that we partner with to say, you know, I'm going to opt out this time and I'll pay the penalty. Or this isn't really working for me, so next time I get a chance to pull completely out, I'm going to pull completely out. That's just the nature of those tools. And we depend on our grid edge teammates to do that. But as I look out at what we're going to be facing over the next 5 years, 10 years, 15 years, walking our way out to 2050, we're going to need those capabilities that Bad Creek 2 would provide us. Because you look at some of those graphics that we've looked at in the direct testimony, the more solar you add, the deeper that trough gets in that load curve. You've got to have something that can ramp down and ramp back up. Now, pump storage can't do it by itself. It's not a generator. It pumps and it creates the ability to generate through pumping, but it is extremely flexible. And as we look ahead to the changes we're making with additional solar, with additional load through the economic development discussion, I know we've had that today as well. I see that resource being used. Given the change in load and change in the generation mix, I see Bad Creek 2 being utilized just like we utilize Bad Creek 1 in Jocassee today. We use it day to day, hour to hour, to meet the ramping needs, the essential reliability services needs that we're required to deliver.
Can you, Mr. Holm, this is my last question for you, and I know Commissioner Kimwright has told me we need to take a break, but can you? I mean, you're talking to people who have very little experience, actually, you know, in the ECC or in the DCC, you know, where you've spent your career, or even sort of understanding the dynamics of how all your plants are operated so that they function together as we need them to. But give us an example of a day in which you and your team of system operators really value the Bad Creek asset and use it. And maybe not so much Winter Storm Elliott. I mean, we know, we understand y'all had to ride it in Winter Storm Elliott, but what, another day?
So you're selling yourself short. You all know more. I am always impressed with the questions, the targeted, the informed questions you ask, at least me. I can only speak for myself. You all care, you're passionate. You represent the using and consuming public citizens in North Carolina very well. We call them our customers, but I told, I think, Mr. Jurack the other day, I'm inspired, encouraged every time I have an opportunity to engage with you all. I'll move on to your question. So here's a good example, because we've talked about this a lot, because we're going to move to more granular resources in the future. Smaller resources that we need to somehow turn kilowatts into megawatts into gigawatts and turn that tool over to the operators. But here's the example that I think of the value to our customers that large capability resources like Bad Creek 1 and Bad Creek 2 really fit in. And this doesn't happen all the time, but it'll happen 3 or 4 times a month. It's the loss of a generator. And I think you all know we're in the Carolina's Reserve Sharing Group. And so we're not only responding to our own loss of units, but because of that arrangement, we're responding to the loss of our neighbors in Dominion, South Carolina, Santee Cooper, and DEP and DC. But so we lose a unit. And let's say it's a big one. Let's say, and I hope I'm not jinxing Daniel Fain in the ECC down in Charlotte. Let's say we lose a McGuire unit, roughly 1,100 megawatts of generation. And let's say it's an unforeseen loss of the unit. There was no indication that problems were arising. It was an immediate real-time contingency. And what happens there is whoever's the BA operator is looking up there and he's monitoring his ACE on his balancing authority ACE limit graphic. And suddenly that little dot, it's a red dot, we say follow the red dot, goes into a quadrant of that graphic that's hurting the interconnection. So the operator does a couple things. One, they verify it's a real event because it could be a telemetry error. So he or she may call down to McGuire and say, did you just lose a unit? Now they're up to their ears and stuff at that time. We may or may not get an answer. Usually they'll say, yep, can't talk to you. I'm sorry. Oh, yes, I'm sorry about that. I get pretty excited about this stuff. And so their job, once they verify it is a true loss of unit, they have 15 minutes to restore their area control area to pre-contingency levels or zero, or we are instantly non-compliant. And the reason it's instantly non-compliant is that we would be leaning on the interconnection. We talked about that in the direct testimony with unscheduled energy flows. And so what we're able to do with Bad Creek is instantly call down to the control center, to the operating center and say, I need you to start 3 Bad Creek units. And if they're available, and if they're not, that's part of the plan. They're already producing 420 times 3 megawatts. But we can get up to 420 times 4 Bad Creek units started. And this wouldn't be the case. It'd be very abnormal. Let's say we're in total pumping mode. We can swing it from total pumping to total generating and meet that 15-minute criteria. So that's something, that extreme situation doesn't happen all the time, but we regularly use Bad Creek to respond to these balancing authority ACE limit conditions. And that's BAL 2, it's balancing authority, balancing demand standard 2.
I would just add that on a short-term planning perspective, Bad Creek 2 gives us immense flexibility. And one of the problems we foresee, it's known, we can see it coming, is that the uncertainty in the day ahead and the week ahead is going to increase the more weather dependent our generation becomes. It's when you have an asset like Bad Creek 2 that can say, we have 22,000 megawatts of solar tomorrow, but if the timing of a storm front is different, or it's more cloudy, you're losing thousands of megawatts. You have dramatically increased the uncertainty. You have an asset that has a wide range of flexibility, so it can absorb energy you weren't expecting, and it can generate if you don't get what you thought you're going to, and it has flexibility from a 20-hour to a 10-hour pond, subject to check and discussion by the long lead time panel. But you can deploy that strategically to position yourself to reduce uncertainty on the system.
For the system operator, pump storage, Bad Creek, Jocassee, specifically Bad Creek 2 in the future is to keep it in simple terms, is a real problem solver.
And how, all right, well, that's all I'm going to ask you. And I appreciate all your testimony. So thank you.
So Chair Mitchell can ask any other questions she has when we come back from our break. So we'll go off the record and we'll come back at 3:40. And let me give everyone an updated schedule about what's going to happen for the rest of the afternoon. We have direct and rebuttal for dispatchable generation and fuel supply. And then we have the panel of natural gas firm, transportation, and fuel supply. And assuming we get through that panel, we will be ending for the day, and we will be taking up the additional Duke rebuttal panels on Monday, beginning at 11 o'clock. Okay, so Chair Mitchell, did you have any additional questions, or are you through? Okay, Commissioner Duffley.
Good afternoon, and I do like hearing your excitement, Mr. Holman. It's always very refreshing. So you were having a conversation with Chair Mitchell, and in your response, you talked about it's kind of like the energy only products, and you said you have to have that backup in case it doesn't show up. I've asked several witnesses during this hearing about this type of energy only product, and is there a limit to that? And I really just haven't heard an answer to that, and I just wanted to get from an operator's perspective, is there a limit to this kind of energy only product or resource?
So I would say that within our energy control centers, we have a framework around operating reserve. We have a target operating reserve. We have lower operating reserves that drive communications and decision-making. Coming out of Winter Storm Elliott, some of that decision-making communication is built into the grid risk assessment process that we've talked to the commission about before, and the grid threat process. So from the system operator's perspective, and those targets are roughly 1,600 megawatts in DEC and 1,300 megawatts in DEP, subject to check. So if a system operator has a target for operating reserves, and that's capacity-backed capability, and you're monitoring your energy only or non-firm purchases, both of them are kind of for an operator, same thing as energy only, and you get more of that product than, let's just say 1,600, you've intellectually said, okay, if I lose all of that in one fell swoop, my only option is turning to my customers. And that's not something, I don't think it's good utility practice nor prudent operator decision-making to get to that point. Now, it's not hard and fast, cut and dried, but if your operating reserve limit is 1,600 megawatts, that should serve as a guide to the operator on how much non-firm you could perhaps handle. Now, if it's not a high load day, you could bring on more units if you had that capability. There are options, but there's always that situation. There is nowhere else to turn. And that's a checkpoint, I think.
Okay, thank you for that. And then you were talking about you've really started working with your distribution control center. Can you just tell me a little bit more about the how that coordination will move forward?
And I can't speak to what's happening now since I've changed jobs, but I can kind of tell you what conceptually happens. So as a part of our facility build out, and we've got new ECCs in Garner and a new ECC in Charlotte, the distribution control center and the energy control center are in the same facility. And that was in my mind, operationally, that was a huge benefit. That really provides value to the operators and through them to the customer. So on a daily basis, they're communicating, what are we seeing with the amount of distributed energy resources that we see that are growing. That's creating the need and the opportunity to work daily on, okay, are there any loading issues? Are there any contingencies through our analysis that will cause us problems if a line trips or we lose a generator and things like that? As we get more generation resources on the distribution system, the whole contingency mindset shifts to the distribution area as well. It's the nature of the industry, I think, globally now, where you're getting more resources on the distribution side. The contingency analysis, which is a compliance-driven process where you're constantly looking at the system saying, if I lose a piece of equipment, and we're checking thousands of contingencies algorithmically, will any other piece of equipment overload? And is it overloading your emergency limit or limits you can manage? And so as we move forward with more generation on the distribution side, those kind of thought processes and disciplined procedures will move into the distribution space. And so we're working with them a lot. And just another example, over the summer, I mean, it's been a reasonably hot summer. We set an all-time summer peak in DEC, I believe, on July 9th, I believe it was. We're talking to them in the real-time space on how things going, how's the loading going, what are you seeing? Because the world, you know, the system is an integrated system. It doesn't really care how utilities are organized or how, you know, planning processes set things up. We've had the discussion around, you know, transmission has typically been in rate case space and generation has typically been in IRP space. The grid doesn't care about any of that. The grid's going to take generation that's produced at generation level. It's going to push it through the transmission, which is kind of like the interstate highway system. The end focus is the customer. It's all about the customer, getting them that critical infrastructure, that critical service that every single one of our 4.2 million customers in North Carolina depends on. I hope that helped.
That did. And then probably my last question, I've asked many witnesses about grid enhancing technologies and GETs, and just wanted to receive your views on this and these being placed onto the system.
I'm an all of the above person. If it can help us manage what we've got in front of us right now, and as we move out, I've referenced these graphics here. If you look at the 2038 graphics, those are pictures of exciting times for system operators. So if grid enhancing technology through transmission switching capability and even more granular limit calculations, if that helps us manage reliability and security for our customers, I'm all for it. It's just when you get to handing an operator a tool, whether it's a replacement for their energy management system, whether it's a new suite of customer-sided resources, or whether it's a new expectation NERC has of them in compliance space, you've got to train on detail. You've got to tell them this is how it's going to work. This is the setting in which it'll help you, and here are the things you got to be on guard against. So I know there's a lot of discussion around that. There's a lot on the transmission side of things. There's a lot of discussion around the technologies that help you reconfigure the system for more efficiency and more capability. There's a lot of discussions. In fact, there's a FERC activity 881, I believe, that we've got to have implemented by July 12th, 2025. And these are a lot of words, but it's ambient adjusted temperature based limits. And we're heads down trying to get that to work. You know, if it helps the operators, I'm all for it.
Great. And actually, I did have one more question. You praised the Bad Creek. You praised the pump storage. So there's a limit to that. So where do you go next?
So I think that's the logic of P3 fall base. You're building that capability up through the expansion of natural gas, and it's not the perfect resource. There is no perfect resource. They all have their risk, but you're building, and Witness O'Connor and I were talking about this earlier, you're building a diverse, flexible, dependable toolbox for our operators. You know, I was looking at something last night and I thought this was kind of interesting. It's called Pavlov's hammer. It's the law of instrument. And what it says is, if you look into your toolbox and all you have are hammers, you tend to look at the world and problems of the world as nails. And all your problems aren't nails. And so from a system operator's view, if they need ramping capability and they open their toolbox and all they've got is voltage support. Voltage support is an essential reliability service, but it's not going to help you with balancing. That toolbox has to be filled with proven, dependable capabilities. NERC Essential Reliability Services helps us with that. And it includes diversity of fuel. You're right. I mean, there's going to be a limit. I'm confident we're going to be successful under your guidance with Bad Creek 2, but there are limits to that. And so it's the combination of diversity, it's the combination of balance, it's the combination of proven, predictable capability that allows operators to deal with all the uncertainties and all the independent variables they face. And weather becomes an even more important independent variable with with resources depending on the weather. I hope I'm answering your question.
You are. Thank you.
Okay, so I'll move to questions on commission questions. Mr. Burns.
Thank you. I just have a couple of follow-ups. John Burns for CC, but I forgot my placard. I'm sorry. You were talking with the chair on the issue of Bad Creek. She asked you a couple of questions on that. Do you remember that conversation or that testimony?
I do.
And you mentioned that Bad Creek is your quickest, most flexible resource. You can turn it on, turn it off when you need it, right?
You've got to manage the forebay levels, but yes, assuming you've done that responsibly, yes, that's correct.
And would battery storage provide a similar resource to the system if it were on in a sufficient capacity?
So I've had a lot of conversations around that, and I'll ask Witness O'Connor to share his thoughts too. If a person of knowledge of the implementation and the build out and the capability of batteries came to me and said, batteries will have the same operational characteristics as pump storage, I'd be the biggest battery fan you'd ever see, because that is extremely operationally effective. I don't have enough information and operating experience in that space to know that. And I think over time, a stable foundational system that I believe is described in P3 fall base allows us to learn in a reliable and secure manner. It gives us the framework through which we can add batteries and learn from batteries and train our operators on how to use batteries and give them the ability to make mistakes, because there will be mistakes made, both in the construction and the execution of the plans and in the operation of the asset. Give them that framework built around the P3 fall base to allow them to effectively learn how to use those to the benefit of our customers.
Thank you for that answer. You referred to, I'll follow up to that same series of questions. You refer to P3 fall base, which has, I think, a little over 2,300 megawatts of storage.
27 by
2,700. Do you have any doubt that Duke's employees, engineers, the company itself will be able to operate storage in that way by the time frame of the P3 fall base plan?
So anytime you introduce something new, and I'm by no means a supply chain expert, but I've bought things before, there's always those challenges. But to directly answer your question, I have no doubt that the Duke team will be able to assimilate that kind of operating experience and capability and be very, very successful to operate any kind of storage that we deem through the guidance of the commission to deliver to our customers, whether it's pump storage or battery storage.
And I would just add that the deliberate pace of the P3 fall base portfolio allows us to learn and do that.
And one further follow-up to that line, there are other utilities in the United States that are bringing on significantly more megawatts of storage and have already. Is that right?
I can't say definitively.
But Duke can hire from others, can't it?
I think that could be a strategy.
Okay. One further follow-up. In response to Commissioner Duffley, you talked about the firm versus non-firm transmission and the energy-only resources. Do you recall those questions?
Yes, sir.
Just to clarify, is it your testimony that operating reserves needed for solar with firm transmission service are lower than operating reserves needed for solar with non-firm transmission service?
Now, our operating reserve criteria stands as our normal operating experience. What operators have to do is look at the assets they have available to them on any given day and do the calculus around, is it firm capacity? Is it a capacity purchase, or is it a non-firm purchase? Is it an energy only situation, or is this on the capacity sheet? And so I don't think that affects operating reserve, but it affects their calculus on, do I have enough operating reserve?
Thank you. No further questions.
Mr. Neal.
Thank you, David Neal with SACE et al. Good afternoon, Mr. Holman. I believe it was Presiding Commissioner Kemwright asked some questions teeing off some concerns that public staff witness met raised with regard to volumes of solar output, particularly on days of low load. Do you recall those?
Yes, sir.
And you've had a discussion in response to that about pumped hydro, correct?
It was in that same thought process, I think.
And I guess following on the questions from Mr. Burns for CCBA, a lot of the virtues of pumped hydro that you discussed there would apply to batteries, and you've had that discussion. And then you also, I believe it was in response to Chair Mitchell's question about your experience with batteries, you had a discussion about DCCs, or distribution control centers, and the challenge you're going to face of going from kilowatts to megawatts. Do you recall that?
Yes.
So kind of bringing those two together, are you familiar with the term virtual power plant?
Yes, I am.
And so you would agree that one possible way of going from kilowatts to megawatts would be aggregating smaller devices, behind the meter devices, up to megawatt scale. So maybe you had 10,000 water heaters and 4,000 EVs, and if they were on some kind of contractual obligation to allow the utility to control those devices, that would be a way to deal both with the situation, as you discussed with Presiding Commissioner Kimmerite, on a day with, let's say, a lot of solar and not a lot of load. You could shift some of that solar into heating the hot water or charging the vehicles, correct?
So you're talking about a hypothetical, and hypotheticals in an operating center get you into trouble. I am hopeful that those kind of designs and systems will come to fruition. But as I've said here many times, hope is not a plan. You don't put some kind of concept in front of an operator and say, operate the concept. That doesn't work. Now, I think Witness O'Connor can speak to how that's handled in the planning space. But I think the beauty of what we're presenting here as the company, the P3 Fall Base, is that we're planning to operate so that we can operate to the plan. That's vital. If the planning starts to diverge from how you're going to operate, you're setting yourself up for failure. You're telling your operators, you are consistently in an unplanned for state. Good luck. That's not disciplined operations, not just in a system operating center, but really in anything. And so from an operator's view, and I'll let Mr. O'Connor speak to this, when I look at this document and I look at what's required in House Bill 951, there's nothing more singular or foundational than planning to operate so that we can operate to the plan. There's continuity in it.
I think regardless of whether we call them virtual power plants or demand response or customer-sited resources, I think as the Grid Edge panel has testified, there are large components of that in the plan. It's part of the all of the above strategy. It's different components of load and different components of sort of controllable resources, but there are elements of that in the plan.
Yep.
And to be clear, I wasn't, Mr. Holman, I don't believe anything in my question suggested that the company would rely on that before it had proved it out or had experience with it. The question really is, I guess in response to another, I believe it was Commissioner Duffley's question, you said that you want all the tools in the toolbox. So just as, again, if Duke gets experience with that kind of active load management that goes beyond some of the existing demand response programs, wouldn't you like to have another tool in the toolbox that allowed you to shift when that solar that's on the system can be put to good use by the utility?
I'll attempt to answer. So I'd add a few adjectives to the tools. I want proven, I want predictable, I want effective tools. I want tools that I've trained in my operators on how to use them. And I am confident that those kind of capabilities are built into our plan. I think Mr. Duff talked about 2,900 megawatts. I was looking at more like 2,700 megawatts of additional customer sited capability. We use those tools now. We used it on the all-time peak or the all-time summer peak on the 9th. It's more standby generation. It's more interruptible services, partnering with our customers. But we have a long history of using these customer-sited products in peaking mode. I think what we're talking about moving forward is using it in more of a dispatchable mode, and that is responding to the direction of a system operator on what I need. I think that holds a lot of potential, but we've got to frame it so it's a real tool. How does the tool, when do you use the tool? You know, if I'm trying to paint something, I'm not going to pull out a hammer. If I'm trying to do delicate, fine work, you know, I'm not going to pull out a jackhammer. So you've got to build the capability around the essential reliability services. And I'm confident P3 fall base is going to do that over the window of time. So you asked me a hypothetical question, I'll give you a hypothetical answer. If it met that criteria and we were as solid on these tools as I'm confident we will be, yes, it will be an important tool in the system operator's toolbox moving forward.
Thank you. No further questions.
Mr. Dodge.
Thank you, Presiding Commissioner. Good afternoon, Mr. Holman. Chair Mitchell asked you some questions regarding who makes the determination on whether to dispatch batteries or other DER resources. Do you recall that discussion?
Yes, sir.
And I believe your response was that that call was made by system operators at the ECC or Echo Charlie Charlie. Is that correct?
Yes, sir.
Okay. And Mr. Holman, you also mentioned the importance of control and coordination of those resources to meet those NERC reliability requirements, particularly as we see these resources beginning to scale up on the system. Is that correct?
Yes, sir.
Thank you. Mr. Holman, I believe you were one of Duke's witnesses at the September 26, 2023 technical conference related to Winter Storm Elliott. Is that correct?
Yes, sir.
And at that time, you provided testimony, or not testimony, excuse me, you provided information regarding wholesale customers and the coordination of resources on their system in emergency or reliability events. Do you recall that?
Yes, sir.
All right. Would you agree that resources such as energy storage on the systems of wholesale customers that are effectively coordinated with Duke can and have provided reliability benefits to all of Duke's customers?
So when I speak on behalf from my experience as a system operator, I'm looking at the footprint as the balancing authority in which are our wholesale network customers. So we're providing services not only for Duke Energy customers, 4.2 million in Carolinas, but also our wholesale and retail customers. So we coordinate with our wholesale and retail customers on what capabilities they may bring to the table, because we're the control authority that affects them dramatically at times. And so, yes, the answer from my perspective, from operator's perspective, I'd say yes. Now, Mr. O'Connor, I don't know if you have a view of that from a planning perspective.
No different view.
Okay.
Thank you.
Any additional questions?
None from Duke.
Okay, seeing none, I'll take motions.
I would move that the reliability panel's one rebuttal exhibit be accepted into the record.
Okay. Seeing no objection, your motion is allowed.
Walmart would move for the admission of Walmart Cross Reliability and Operational Resilience Panel Rebuttal Exhibit 1 into the record.
Seeing no objection, your motion is allowed.
Thank you.
And with that, thank you for your testimony. You may step down and be excused.
Presiding Commissioner Kimmerer, Duke Energy calls the dispatchable generation and fuel supply panel to the stand.
Okay, thank you. And for clarification, this panel is up on the stand for direct testimony only at this point.
Yes, that's correct.
Okay, great. I'll go ahead and get you sworn in. If you can place your left hand on the Bible and raise your right hand. And do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
Beginning with Mr. Verderame, would you please state your name and business address for the record?
Good afternoon, Commissioners. My name is John Verderame. My business address is 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Corporation as a Vice President of Fuels and Systems Optimization.
Can you please briefly describe your role and responsibilities at Duke Energy?
Sure. I oversee the strategic direction and commercial management of the fuel strategy and procurement of fossil fuels for the regulated fleet. I also oversee teams that are responsible for system optimization, power trading, energy supply analytics, and short-term load forecasting.
Thank you. Turning to you, Mr. Donashad, would you please state your name, your full name and business address for the record?
My name is Daniel Donashad. Business address is 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
Employed by Duke Energy Carolinas. I'm the general manager of Generation Execution and Technologies.
Can you please briefly describe your role and responsibilities at Duke Energy?
Sure. I prepared the generation fleet strategy to ensure comprehensive and orderly energy transition. I proposed strategic decisions like gas co-firing, coal retirements, and significant new gas builds. And generally, my group informs and helps execute the IRPs.
Thank you. Turning to you, Mr. Hoffledge, would you please state your full name and business address for the record?
Yeah, Peter Hoffledge of 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Carolinas as a principal engineer.
Can you please briefly describe your role and responsibilities with Duke Energy?
Yes, my role is to look at new generation that provides low carbon, zero carbon potential. And the focus of most of my work is hydrogen and carbon capture and sequestration.
Turning back to you, Mr. Verderame, excuse me, did the panel cause to be pre-filed in this docket direct testimony consisting of 28 pages?
We did.
Do you have any changes to the panel's direct testimony at this time?
No.
If I were to ask you the same questions today that appear in the panel's pre-filed direct testimony, would your answers be the same?
We would. They would. Sorry.
This panel's direct testimony did not include any confidential information, correct?
Correct.
And did this panel also pre-file a summary of its direct testimony for the commission?
Yes.
Presiding Commissioner Kimmeride, I would ask that the dispatchable generation and fuel supply panel's direct testimony be entered into the record as if given orally from the stand, as well as the summary of its direct testimony.
And before I rule upon this, can you double check the number of pages? I have 38 pages, and I think you said 28 pages, so my notes could be wrong, but let's make sure that.
I think the rebuttal is 38.
Yeah, I will double check, Commissioner. I do believe it's 28,
Okay.
but we'll double check. Yeah.
I apologize. I was looking at rebuttal pages.
Okay, no problem.
Your motion is allowed. The direct testimony will be entered into the record as if given orally from the stand, along with a summary. And the exhibits you stated?
No exhibits.
No exhibits. Okay. So thank you.
Thank you. The panel is now available for questions from the parties and commission on direct testimony.
Okay, so my understanding is that there is no cross-examination from any of the parties. Is that correct? And I believe, let me check with my fellow commissioners, but I don't believe that there's any questions from the commissioners. But let me make sure. They're going to be back on. So there are no commission questions. So we do not need to go any further with direct testimony. Mr. And I apologize, I may pronounce your name wrong, Mr. Verderame, is that correct?
That's very good.
Okay.
Thank you.
You may step down. You're going to be on a later panel, is that correct?
That's correct.
Okay, so you may step down and you're not excused. And I think that we have another panel member that is going to be coming up for rebuttal testimony.
That's correct.
Okay.
Duke Energy calls Duke Energy witness Venu Ganta to the stand.
Good afternoon. Since this is your first time testifying, I'll go ahead and get you sworn in. If you can place your left hand on the Bible and raise your right hand, and do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
Mr. Verderame, are you the same? Excuse me. Thank you. Mr. Donashad, thank you. Are you the same dispatchable generation panel that filed direct testimony in this case?
Yes, however, the dispatchable generation panel now includes witness Venu Ganta and no longer includes witness John Verderame. Witness Ganta did not file direct testimony in this proceeding. Witness Verderame is now separately testifying as part of the natural gas firm transportation and fuel supply panel.
Mr. Ganta, would you please state your name and business address for the record?
Sure. My name is Venu Ganta. My business address is 410 South Wilmington Street, Raleigh, North Carolina, 27601.
And by whom are you employed and in what capacity?
I am employed as Vice President, Regulatory Affairs and Policy, North Carolina for Duke Energy.
Can you please briefly describe your role and responsibilities at Duke Energy?
I'm responsible for managing North Carolina regulatory matters and directing North Carolina energy policy for the companies.
Turning back to you, Mr. Donashad, did the panel cause to be pre-filed in this docket rebuttal testimony consisting of 38 pages?
Yes.
Do you have any changes to the panel's rebuttal testimony at this time?
We do not.
If I were to ask you the same questions today that appear in the panel's pre-filed rebuttal testimony, would your answers be the same?
They would.
This panel's rebuttal testimony did not include any confidential information, correct?
That's correct.
And did this panel also pre-file a summary of its rebuttal testimony for the commission?
We did.
Presiding Commissioner Kimmerite, I would ask that the dispatchable generation rebuttal direct testimony be entered into the record as if given orally from the stand, as well as the summary of its rebuttal testimony.
Okay. Seeing no objection, your motion is allowed, and the rebuttal testimony and the summary of the testimony will be entered into the record as if given orally from the stand.
The panel is now available for questions from the parties and commission on rebuttal testimony.
And I apologize, was there one exhibit attached to the testimony, the rebuttal testimony?
I don't believe so, Commissioner. We'll double check.
Okay. I've looked back through my notes and you're correct. There is not an exhibit.
Thank you.
So we do have cross-examination from EDF and also from SACE. So Mr. Smith with EDF.
I've actually waived my EDS cross in this for this panel. Thank you.
SACE, you may proceed.
Thank you. Nick Jimenez for SACE et al. So this is to the whole panel. But you cited EPA's Final Clean Air Act, Section 111B and D rule in your testimony, right?
That is correct.
And you're familiar with that? If we call it the Clean Air Act rule, you're familiar with that?
Yes.
Okay. You testified about compliance strategies that for Duke with regard to the final rule?
Yes, that is correct.
In your testimony, you do not claim that any facilities in Duke's coal fleet are fundamentally different from the information EPA considered in determining the emissions limitations in the Clean Air Act rule, correct?
I wouldn't characterize it quite in that manner.
You did claim that.
I think it'd be more accurate to say that EPA's promulgation of standards under Section 111D of the Clean Air Act.
Can you speak a little louder and into the microphone? Thank you.
Happy to. Apologies. Are presumptive standards that then need to be incorporated into a state plan by North Dakota, in this case, by North Carolina Department of Environmental Quality. And so at this point, there's not a standard with which to comply.
You don't have any specific reason to believe that Duke's coal facilities are fundamentally different from the EPA, the information EPA considered in coming up with its presumptive standards, do you?
I think it's premature to make that determination.
You didn't state in your rebuttal testimony that the costs to bring Duke's coal facilities into compliance would be outliers considered nationally, did you?
We did not make that assertion.
And you don't have any specific reason to believe that they would be, right?
I think it's premature to make a statement like that. Again, there is a process that the companies have with North Carolina Department of Environmental Quality to make that evaluation on a unit by unit basis. And again, that is the province of the state to make that determination, incorporate that into a state plan.
Nor did you claim that those costs would fall in the 95th percentile or greater relative to the costs to bring other facilities into compliance around the country, correct?
We did not make that statement.
Nor did you claim that the costs would be multiples of the cost threshold that EPA deems reasonable, correct?
You'd have to elaborate upon that statement, the cost threshold that EPA deems reasonable.
Multiples of the, well, multiples of, scratch that. Okay, moving on. In your testimony, actually, I'll just go to the question. You'd agree that if Duke is not able to maintain the 40% capacity factor limit on new gas CCs for any reason, then it wouldn't be complying with the final rule, correct?
So I believe the question is with regard to the 111 new gas standard that allows for new gas sources to operate in baseload, intermediate load, or low load. The question is whether we would be operating in baseload or intermediate load. Is that my understanding of your question?
It's close. So in your testimony, you addressed statements from public staff witnesses Nader and Thomas that the Clean Air Act rule could cause unanticipated environmental compliance costs related to carbon capture and sequestration of hydrogen if it's not possible to maintain the 40% capacity factor limit on new CCs.
Excuse me, Commissioner, could council point the witness to the specific page and line in testimony that he's referring to?
Sure thing. That's page 11, line 10 to page 12, line 11. And that citation's a little broader. It includes your response, which was, well, I won't read it to you. You've got it right there.
Yeah, I have it in front of me. So can you repeat the question? I'm not clear on what the question is.
So the question is, you'd agree that if Duke is not able to maintain the 40% capacity factor limit on a new CC, then it would not be complying with the rule.
So the statement we've made here is if we intend to operate the units in baseload from 2032 forward, we would need to incorporate 90% carbon capture and storage by 2032, which we don't think it's possible. As summarized by witness Snyder and also summarized by the public staff panel, our intention is to operate the combined cycles, the new combined cycles, consistent with the rule in intermediate load, which require capacity factors at 40% or lower.
Right, and the question is, if you had to go over that 40%, you wouldn't be complying with the rule, right?
If any owner operator were in violation of the rule, we're above 40%, that would be in violation of the rule currently. However, EPA does allow for additional time for reliability reasons. So an additional year for infrastructure challenges, and then case by case basis, there would be a reliability determination. So I think you're asking a very generalized question, but could be a specific matter where that statement that you made would not be true.
And in that case, if Duke weren't able to avail itself of the exceptions you just identified, there would be additional compliance costs, such as for adding CCS or hydrogen, right?
If the companies determined that it was appropriate to operate those CCs in baseload, then yes, they would need to incorporate CCS. or some other, potentially hydrogen or some other clean fuel that would be consistent with what EPA allows in the rule for baseload operation.
All right, moving on. Were you here for witness Snyder's testimony concerning Cliffside 6 and its potential conversion to gas this morning?
Yes, I heard it.
And you agree with this testimony that to qualify as an existing gas plant under the Clean Air Act rule and continue running past January 1st, 2039, it would need to convert entirely to gas by January 1st, 2030?
Let me add something there. So witness Snyder said existing gas, but he meant to say existing gas steam. All right, so it's a gas steam unit by 2030. And that would allow you to continue to run past 39 or as long as you wanted to.
So to add to witness Donishad's point, that's absolutely correct. I think existing gas steam units, because there is no existing gas combustion turbine standard. So existing gas steam is regulated under section 111D of that rule. It requires that the way the rule is written, it requires that you cease combustion of coal at that facility by January 1st, 2030. So it's really a question of category definition.
Okay, well, hopefully maybe you can help clear up some confusion, because in your testimony, didn't you say that it's Duke's plan to convert that plant to gas in 2035 and continue running it to the end of 2048?
And I'm sorry, if you could just point the witness to the specific page in line that you are referencing.
Okay. If you'll look at page 16, lines 2 to 8.
Yes, I see it. So again, let me try to clarify this point. EPA has promulgated presumptive standards. It's because this is existing source. We're not talking about existing source. So EPA's obligation is to promulgate presumptive standards, which the state then evaluates on a case-by-case basis and determines whether they're appropriate. The state has the ability to change the timeline for compliance or change the standard on a unit-specific basis. So what we've said here was that the plans for the companies were to operate or to continue operating this Cliffside 6 facility and to convert it to 100% gas by 2035. It may say in here, it should. Well, I'll say by for the purposes of this conversation, and then we will continue to evaluate that based on our conversations with Department of Environmental Quality.
I think no further questions.
Redirect from Duke.
Yeah, just a couple questions. Thank you. So my question is actually for Mr. Donishad. Mr. Donishad, does EPA Clean Air Act Section 111 change the company's conclusion that the new CCs and CTs that are proposed in the CPIRP are needed?
It does not. The modeling group did the model with and without 111, and in both cases, it wanted 5 combined cycles.
And does Duke Energy have a plan to operate the CCs and CT units if EPA Rule 111 or Clean Air Act 111 is upheld?
Yes, assuming that the 111 Act stays in force, we have a plan for compliance.
And can you just briefly walk us through what that?
Yeah, I mean, basically, these combined cycles are going to be the most efficient ones available to be built, right? And so we'd want to operate them, 80, 90%, capacity factor type of thing. If 111 stands and the rule is not vacated, it's not stayed, the dates aren't pushed out, then we would run it as the system wants between that, once they go online, and January 2032, we'd have to reduce the capacity factor to 40%. That would be our compliance method. That's not a great thing, but it's the lever that we have to be able to pull. And so the units are still used and useful. It's going to put more pressure on other units to have to pick up the energy to meet the system load.
Thank you. No further questions.
Okay, commission questions. Commissioner McKissick.
Sure, just 1 or 2 questions here, and it's related to the stipulation. And if you would, turn to paragraph 22.
That's page 12.
That is correct.
Hydrogen.
And of course, what it says here is that there's going to be this hydrogen pilot project study, and the companies agreed to engage with the public staff to scope a hydrogen pilot project study to assess, number one, PEM technology, number two, co-located carbon-free generation to produce hydrogen, number three, maximization of federal tax credits on behalf of consumers, number four, analysis of PEM's generation's abilities to mitigate system reliability events with ramp constraints and or mitigate lowest reliable operating limits. Number five, analysis of the impacts of not cycling baseload nuclear power generation. Number six, estimated pilot project cost. So it has some degree of specificity here. I guess the question is, will this engagement also include discussions that more fully develop the underlying hydrogen fuel assumptions and modeling inputs used by Duke's in its capacity expansion modeling?
Yeah, I'd like to answer that. Yeah, I think it will. I'd say it won't answer all of them, right? Because it's a pilot that will be, this pilot's defined as sort of like an inside the fence production of hydrogen, right? So to the extent that those questions are answered. So when we think about it, we think about what's the impact to the units to maybe convert to hydrogen? What's the cost to produce hydrogen? You know, critical question here, you know, we talk about this PIM electrolyzer. The PIM electrolyzer and electrolyzer space is like a racehorse, right? The reason that it's being selected by a lot of these demonstrations is that it can ramp quickly both up and down and react to, you know, the volatile nature of, you know, renewables, you know, and so it would answer a lot of those, right? And it would really enhance our understanding what's needed to create hydrogen and utilize hydrogen.
So you would envision that even though that's not explicitly stated, it is implicit to you that that is going to be a part of what that pilot would consist of.
Correct. And I would add that, you know, some of the work we're doing at DeBerry now in our Florida jurisdiction also helps, right? Because we're working through the details, you know, I think it's easy to say, hey, you know, you can convert a unit, you can put these systems in place, but when you actually go through the engineering and execute the work, you learn a lot, right? And so these pilots are critical to those learnings.
And what do you envision as the timeline that would be required to develop all of the details relating to the pilot so that it could be successfully undertaken? And not only will it be commenced, but how long would you anticipate it might function or operate to really provide meaningful data that can be used successfully in modeling, say, moving forward with the next rendition of the carbon plan?
Yeah, that's a really good question, right? So you have a development phase where you're going to define, working with public staff to define that pilot and kind of scope it out, right? Then typically you move into, you know, some level of engineering and estimate to make sure you get the cost right. In DeBerry, which is somewhat of a similar pilot, but I can't say that because I'm not sure what this pilot would look like yet. You're looking at maybe a 2-year execution and implementation, maybe 2.5-year implementation phase, right? 2.5, 3 years maybe. And then operational, you'll learn a lot through that engineering work, as I mentioned earlier, and then you'll have some short-term learnings, right? And then the longer you can operate that system, then you'll start to see some of those longer impacts. For example, what's the impact on maintenance, right? And what are the components, life, you know, and what's the scheduled maintenance? So I can't really define that length of time. You want to have a long enough period of time so you can capture that, right? You know, the other important aspects of the work is you start to understand operational procedures, maintenance procedures, safety, you know, training operators. So there's a lot to that. Those short-term learnings typically would happen maybe in a year, but that longer duration learning would take a while. And I really don't have unfortunately a timeline on that. You have to kind of let it play out maybe, right? So
I understand. And I mean, I think it's imperative that it play out and that it be fully developed so that it can provide that meaningful data. So it sounds like while there might be information being reported back to us, that the next carbon plan rendition all that information really won't be available yet. It may be the one after that.
Correct.
Thank you. No further questions at this time.
Chair Mitchell.
All right, good afternoon, gentlemen. Just a few questions for you. Did you all have a chance to hear Mr. Snyder's testimony earlier today where he went through the sensitivity, the Clean Air Act rule sensitivity analysis? Okay, I
Yes.
see you shaking your head. All right, so, okay, so he gave us the company's results of the sensitivity work they did, and specifically in the context of the existing coal-fired generation. And as I understood his testimony, since there are Cliffside 6 is implicated, and Cliffside 6 would have to be taken to 100%. Well, the plan would be to take Cliffside 6 to 100% natural gas fired burn by 2030. And then he indicated that for Roxborough units 2 and 3, which the company had planned to operate until 2034, there would need to be some exception granted by the state or application of the, I think he called it the averaging, is that right? The averaging concept that's established by the rule. Do you all agree with at least my rehash of his testimony today?
Chair Mitchell, you've captured it almost perfectly, maybe perfectly. I'll try to give you a little bit more detail there. So we had this consistent with the exchange we had earlier, just to kind of put the existing source kind of aspect, just step back a little bit. So Section 111D of the Clean Air Act is worded a little bit more interestingly than some of the other sections, in that it says EPA's obligation is to establish a procedure that the states then implement. So for new sources directly regulated by EPA, enforced at the state level and also enforced at the federal level. So you go ahead and just put a standard in place. So that's new gas, for instance. When it comes to existing sources, and we're talking about two different kinds here, coal, existing coal, as you mentioned, and what's called gas steam. And that would essentially be gas fired in a boiler, right? Oil steam is also in the rule, but gas steam and coal are really the existing sources. For those, it's a procedure. And in EPA parlance, it's an emission guideline, or in this rule, they've said presumptive emission standard. And so that's an instruction to the states, go out and figure this out on a unit by unit basis. We think these are the presumptive standards, but it's really you as the state regulator who knows that, who know these units better and can work directly with the owners, operators to figure out if those standards are viable. So you mentioned, I think Witness Snyder mentioned two opportunities there. One is expressly in the statute, and it says that EPA has to allow states to consider remaining useful life when applying that standard. So they take that presumptive standard and then to put it into an actual emission standard. It's a 2-year process. It'll be due in July 2026. So in evaluating that and developing the standard, they have to think about remaining useful life. A lot of folks call it rule off, remaining useful life, and other factors. And EPA lays out some of the factors that should be considered, but one is just unavailability of infrastructure, some other challenges around infrastructure, and others cost. And so part of the evaluation the Department of Environmental Quality needs to do is to look at the couple of instances that you mentioned. Cliffside 6, where we had currently planned to make that conversion in 2035, EPA would have us make that conversion earlier in 2030 to 100% gas. The other is Roxborough 2 and 3, units that have an enforceable retirement date before 2032. So by December 31st, 2031 are not in the rule at all, not covered by the 111 rule at all. So the question is for Roxborough 2 and 3, they currently in our coal retirement analysis have retirement dates after 2031. So they would either need to, based on the rule, move their dates or co-fire. And that is subject to an analysis by Department of Environmental Quality, taking all those factors into account we mentioned. Witness Snyder mentioned another option, which is an averaging plan that allows you to average over all of the sources. That still would be also something that we'd have to discuss with Department of Environmental Quality. All of that, again, will go out in draft form from DEQ with some oversight from the Environmental Management Commission, and then will be finalized before submission to EPA in July 2026.
Okay, so it's got to go to the EPA in July of 26?
That's right. And then
Okay.
they have a year to approve it, disapprove, give feedback, and then technically then after all that's done, then the standards would go into force.
Okay. When has the state started its process yet?
They have.
Okay.
They've issued an information request already.
Okay. And I assume that the companies, what role will the companies play in developing the state implementation plan?
So the first piece is identifying the units that are covered. So again, this is just existing. So what do you consider an existing coal unit subject to the standard? And it gets into this trickiness of what is Cliffside 6. Currently, it's an existing coal unit, but it'll be switching to an existing gas steam unit. So it's a question there about how you classify. So that's the first step. And then you have to give the baseline emission rate. And then that's the kind of information that DEQ is looking for currently. And then they move forward with their evaluation.
Okay. All right. Thank you, Mr. Gonta. Will you, and just in terms, you've laid out timing associated with the state process. And it sounds like y'all are at the beginning of that process, identifying generating resources that'll be subject to the rule. When do you anticipate that there'll be some sort of meeting of the minds as to which units the rule applies to?
So that's ongoing. And I believe in North Carolina, DEQ has to actually issue, before they can put together a plan, they have to issue a draft rule.
Okay.
And then put that out for notice and comment, then finalize the rule itself that codifies the standards. And then they put that into the state plan to submit to EPA.
Okay. So DEQ has not initiated the rulemaking yet?
Not yet.
Okay. That's what I need to know. Thank you. All right. Mr. Snyder discussed sort of his views and his understanding of the rules implications from a modeling standpoint. And he said, talk to somebody else about the operational aspects. And so, are the operational implications of the rule. And so are you all the panel that can answer questions related to the operation of these facilities, or should I raise that with another panel?
I'll give it a try.
Okay, so we talked about the sensitivity analysis he ran related to the conversion of his team ran related to the conversion of the existing coal-fired facilities to fire natural gas. I guess he took them to 100%. And I understand the results of the conclusions that the company has drawn regarding that modeling work. But what would be the practical implications of converting those units to run on natural gas from your perspective?
Well, I think one thing that's really important to know is that Duke was out in front, this co-firing thing, we're out in front of the whole country. We've had all types of utilities come and visit us because, we've been doing this since like 2016, right? With Cliffside 5 and 6 being the first ones. So,
and just for the benefit of everybody here, can you indicate which facilities in the Duke fleet, which coal facilities are co-fired?
right. So all of the DEC facilities except for Allen. So Marshall 1, 2, 3, 4, Cliffside 5 and 6, and Blues Creek 1 and 2. They're all outfitted, right? So Cliffside 6 is the only one that can do 100%. So when we talk about converting Cliffside 6, there's not much to convert. It's already got the ability to do it. We've done it already, right? We have to firm up the gas if you get rid of the coal. So that's Cliffside 6. And then the other, the way the rule says is that they want you to do 40% co-firing. That's that BSER, best system of emission reduction, that EPA set is 40% co-firing, which is basically a 16% CO2 reduction off the unit's baseline, right? They basically say every 10% co-firing is 4% CO2 reduction. So we just multiply that by 4, we got 16%. So, Cliffside 5 can do 40%. Cliffside 6 can do 100. Marshall 1 and 2 can do 40%. Marshall 3 and 4 can do 50%. Blues Creek 1 and 2 can do 50%. There is no need to really do any more work, right? Because I can run all of those units till 2039, and that's all beyond what my current retirement dates are, with the exception of Cliffside 6. So I think we're in really good shape from the coal units. On the DEC side, on the DEP side, Mayo would retire in 31, so that's before the rule, and then that just leaves you with ROCs 2 and 3, and we've already talked about that.
Okay, and remind me, what is the date by which, under the rule, the date by which the coal units would have to convert to co-fire?
That's January 2030.
Okay, 20.
So we would need to start next year. They're about a 4-year project, 4.5-year project to do DFOs based on our experience. So we'd have to start next year if we're trying to do something by January 2030.
Okay. Okay. And then, and what about, so with respect to converting these old coal units or the existing coal units to run on natural gas, talk about that from a reliability standpoint.
So if you're going to convert it and run it 100%, so say like a Roxborough, is that what you're
Yes.
talking about? Like a Roxborough?
Really,
53?
any of them?
Yeah, yeah. So, I mean,
Other than Cliffside 6?
Yeah, yeah. So Cliffside 6 was built in 2012, so it's much younger than all the other ones. You know, the one thing with the gas is there is a little bit of a higher moisture content than coal, so you do get a little bit of a efficiency hit with that. There is some equipment that you can probably get rid of. Like if you wanted to build a bypass duct, you can go around the scrubber and not have to treat that flue gas with the scrubber because there's no SO2 anymore, right? Because you've gotten rid of the coal. So those, you know, and then coal handling is something that could be, you know, you wouldn't need coal handling anymore because it's coming in a pipe. But you know, I think, but a lot of the equipment is still going to be there. Now you're not going to run the pulverizers, right? You're not going to grind the coal, so you don't need those. But there still is a lot of infrastructure that's needed, and so you have to take that into account. You know, your steam turbine is still of whatever age it is, the boiler tubes, et cetera. So there's a lot of evaluations that have to go and have to be done. And the first thing we would do is get an engineering firm to do a very detailed study on looking at the boiler and what it would take to retrofit. And you've got to look at different vacuums and pressures and structural abilities as well. So it's not, you know, it's not just check a box. We can do it. We have to study it.
Okay. All right. Let's see. All right, I think that's all I have. Thank you all.
So I have just a couple of questions. You testified earlier about if you're going to be running the gas units at the 40% capacity factor, you said that that would put pressure on other generating units. And then you specifically talked about that on page 13 of your rebuttal testimony and said that the final rule has the effect of placing significant operational constraints on newly constructed, highly efficient advanced class CCs and thus forcing redispatch to less efficient units. So implementation of the final rule would result in increased costs, potential adverse impacts to reliability, and delays to the achievement of the final interim target. What I'm really interested in is which less efficient generating units would be dispatched, and what are the potential adverse impacts to reliability for doing so?
Well, I mean, what you're going to be doing is you're going to be relying on existing generation. So it's going to be your existing combined cycles, your existing combustion turbines, your existing coal units, right? And so those are not going to be as new as these brand new assets. They're not as efficient as these brand new assets. And so, you know, reliability is number one, right? So we've got to have a reliable system. Our supplies have to meet our demand. And so we're going to do that, right? And so, you know, the group that does all the dispatch, like Sam Holman was talking about, I mean, they're going to go and dispatch the system as needed, but just by the inherent nature of not being able to use the very efficient units, the most practical that you could, you're going to be burning something or using something that's less efficient. That's what we're trying to say.
And how does that relate to reliability then? Because I understand less efficiency, but in relation to using less efficient units, how does that impact the reliability?
I mean, I think you're going to be depending on units that are older. So if you're relying on the coal units to pick up the slack because I backed down my combined cycles, your reliability is not going to be the same.
Okay. And then one last question. You discuss it in pretty good detail in your testimony, but starting on page 18, this has been a big issue in the proceeding, but it's about related to stranded assets. And can you provide Duke's position about, with the final rule, what your response is to stranded assets?
Right. So I think, we talk about these assets being 35-year assets. I know the commission in your carbon plan order ruled on that 35-year assets that's reasonable. And I think, as we look at moving down the road, I mean, the 111 compliance we talked about, it could be a 40% capacity factor, right? And then if you do that under the current rule, there is nothing else that you would need to do, right? We get to 2050 though, we've talked about hydrogen, right? CCS, carbon capture sequestration, is an option. CO2 offsets is an option. And then you also have that run for reliability. So you're talking a quarter of a century down the road, all right, how we're gonna meet that. So I think, those are the options. So I'd say the assets are used and useful. You may use them a little differently in 2050 than you will in 2029 when they go in service. But I'd say they're used and useful and will not be stranded assets.
And I think that some of the interveners have put kind of a nuanced argument to the stranded asset they're concerned about by saying that you would be limiting the capacity factor to 40% as opposed to having a 90% capacity factor for the new natural gas facilities. I think that their argument is that might entail stranded assets. So can you respond to that argument?
I mean, if we have to run it at less, that doesn't make it not useful. It's still useful, right? It's good. And we would operate that thing at 39.99% capacity factor. It'd be right there, right? Because we want it. But I'd say it's still used and useful. So I would not agree with that argument.
Okay. Thank you for your response. Chair Mitchell.
Mr. Gonta, just confirm for me, the final rule does not apply to the company's existing gas-fired facilities, right?
That's right. To put a finer point on that, EPA proposed an existing gas standard, and just to get the dates right. So it's based on a proposal publication date. So it's May 23rd, 2023. Anything that commences construction after that date is considered new. So then EPA tends to put an existing source standard, which would be everything before that date. So EPA proposed a standard, but then decided not to finalize it and said they would rework it and potentially issue one later this year or maybe next year.
Okay. So we don't have one at present, but one could be coming.
That's right. And I think what's important to note there is that when there is a new source rule, there's an obligation to determine whether to issue an existing source rule as well, but they're going to have to use a similar record. So this is really critical when it comes to the litigation on the 111B, the new source standard for gas. How does the litigation progress if it ends up getting stayed or there's some other challenge to the rule? That's going to make it challenging then for the record for the existing source standard, if that makes any sense.
Okay, it does. Thank you. I appreciate it.
Okay, Commissioner McKissick.
And this is just a follow-up on Commissioner Camerite's question, and dealing with the capacity factor being, 40% or less. I mean, and I raised the same question with the public staff when they were up providing testimony. Where did you originally model? How did you model the capacity factors originally for these units that now will only be able to be used at 40% or less because of Section 111, because, that is a substantial limitation. So, I mean, one might think that, if you were originally thinking that the capacity factor would be substantially higher and that the investment would be, recaptured at over certainly 35 years is the useful life, but you'd be able to get much greater utilization out of it. So can you address that and help me understand how, in terms of this decreased capacity factor and utilization, impacts the economics of it all, and as well as the modeling that you originally anticipated?
I mean, certainly Witness Snyder is the right one on the modeling. I would just say that, when they're modeling, they're going to let the model choose how much the unit would run, right? So they're not going to dial in 75% or 80%. They're going to let the model choose. It's going to solve for a system and a set of resources. And so it's going to have the combined cycles running at a very high capacity factor as they have in the past. Will in the future. So, I mean, I think 111 is substantial in that respect, that it's putting that cap on it. Now, will it stay? That remains to be seen. See what the Supreme Court does. But it is a pretty dramatic cap to put on the units.
So, I mean, originally it might have been 80%.
Right. That's right.
And now we're down to 40 or less.
I'd say 40 at 40 would be the limit at 2032
Right.
if the rule stays as
As it is
currently.
today.
Yes.
But this is something that you all, well, even in stipulation, can continue to monitor this and report back and see what the implications are.
Absolutely.
Thank you.
Okay, that comes to the end of commission questions. We have a hard end time at 5 o'clock. However, we will endeavor to see if we can get through commission questions if possible. If not, the panel will have to come back on Monday morning, but we will see what we can do about completing the panel and being able to excuse you. Questions on commission questions? Mr. Smith.
I just have a couple. Commissioner or Presiding Commissioner Camerite had a question about stranded assets. Do you recall that?
Yes.
And there was another question about concerns about, well, it was the same question about sort of 40% being sort of not optimized output from the factors, but required by law, you have to go through it anyway. You recall that interaction?
Yes.
So what I want to ask you is, do you all consider it to be a risk that when 2050 rolls around and you have to consider hydrogen variable markets or potential carbon capture infrastructure costs, that those aren't currently being captured in the modeling despite the initial tread being put down right now?
Well, I'd say that the modeling team does have hydrogen costs in the model, so they do have it built in.
Okay, so I guess they have 2050 fuel costs for hydrogen built in the model?
They have conversion costs, and there is, I think also, Peter, help me out with this one, but I think is also at 2050, any units that aren't hydrogen will be
We
converted.
have hydrogen fuel costs from 2022 out to 2050.
Okay, and then how about carbon capture and sequestration?
Carbon capture and sequestration, we have costs for carbon capture sequestration and carbon capture, that's independent of where you are. Sequestration costs, like for example, for the Carolinas include transportation costs to, some location, X hundreds of miles of transportation. So that's like a generic unit cost that the model can select. And so obviously these inputs are in there and it's going to pick the optimum, configuration around hydrogen, carbon capture, sequestration. I don't think for the Carolinas it's selected carbon capture and sequestration. Part of that I think is due to that, transportation cost, but that also can change. It's an evolving kind of developing area of sequestration is.
All right, no further questions.
Any additional questions on commission questions?
Just a few. Thank you, Presiding Commissioner Camerite. Mr. Donishad, so would you agree with me that the need to run the CCs and CTs that are proposed in the CPIRP at a 40% capacity factor only applies if they continue to be fired by natural gas and EPA Rule 111 is upheld?
Madam
Yes.
Presiding Chair, if I can interject, what question is this about?
There were several questions about the running the units on 40% capacity factor from several commissioners.
I'll overrule the objection. There were questions in that regard.
Do you need me to restate the
Yeah,
question?
please.
Is it true that the CCs and CTs only would be required to run at a 40% capacity factor if EPA Rule 111 is upheld and those units are fired by natural gas?
Yes.
And you agree that all the CCs and CTs that are being proposed in the CPIRP are 100% hydrogen capable, is that correct? Or being proposed to be constructed as 100% hydrogen capable?
The new assets that we're putting in will be between 30 to 50% hydrogen capable. These new ones, all the OEMs have said by 2030 that their offerings will be 100% hydrogen capable. So eventually, yes, 100% hydrogen capable.
And would you agree that the IRP and NTAP panel in this proceeding ran a sensitivity analysis which modeled those units running at a 40% capacity factor?
Yes.
And did that model still select those units as the least cost pathway?
It did, yes.
Okay, thank you.
Okay, so there are no additional questions on commission questions. So we have finished this panel before 5 o'clock. There's no motions that need to be made, or is there?
No motions, just a correction. I believe I incorrectly stated that the rebuttal panel's testimony consisted of 38 pages. It's actually 34 pages. So I just wanted to correct that for the record.
That is correct, 34 pages. Thank you. The record will so reflect.
Thank you.
Thank you for your testimony. You may step down and you may be excused. And we will reconvene on Monday at 11 o'clock, again, after staff conference. So please remember to not come into the hearing room until staff conference has been completed. So thank you. Have a good weekend, and we'll go off the record.